Blood say
No mention.
extreme urgency, my lord.
Even then,
Say encashment.
I
of
cannot
bank
accommodate any one single matter
Yes,
for
my
that.
lord.
Sorry. Yes, Colin.
The only thing is, my lord,
Yes,
his
Mr.
connection is day after tomorrow.
Nothing doing, sir. Colin.
My lord, notice for encashment of bank guarantee issued, my lord.
I cannot accommodate one single matter in my list. Further matter. Yes, Colin.
Listed matter, item number 1, court application Kejriwal Mining Private Limited versus Indian Bank.
For the
Yes, Mr.
petitioner,
Mukherjee.
but this application is possibly by my senior friend's application for addition of party. But my lord, I have instructions to withdraw the writ petition, my lord.
Instructions to?
Withdraw the writ petition, my lord.
Very
With liberty to file afresh, my lord, on the self-same cause of action.
After the application was filed, you're.
Yes.
No, no.
Yes. Because
But there are negotiations going on with
Even
the
then,
bank,
Mr.
my lord.
Chaudhary, if they withdraw the.
if he withdraws, I can't stand in the way. But my lord, the question of-
Consequentially, your petition will become infructuous.
Yes.
I'll record that.
the liberty part is what is intriguing. My lord. Otherwise, I have no right
Definitely, yes. Liberty to do what?
But,
to file afresh on the same cause of action. That's what.
but
he's
the
looking
reason
for.
being, my lord, there are.
You are
advan-
asking for a liberty.
Yes, my
Yes,
lord.
that's
There are
Then
why I-
withdrawing then.
My lord, because there are advanced stages of negotiation with the bank, my lord. This is only for rectification of my name with the
There is
records
a
of
question
civil-
of further refiling.
My lord, if the
I'll keep
representation
it pending, keep it next week, take it up.
no, my lord, if the representation fails, my lord, then I don't want to, my lord, trouble your lordship unnecessarily.
So then no liberty to sue further on the self-same cause of action.
Then my lord will then simplicity, my lord will kindly let me withdraw the writ petition.
I can't
I'll come.
object to that.
Learned counsel for the writ petitioner submits that the writ petitioner no longer wants to continue with the matter. Full stop. Accordingly, WPO 2851 of 2022 is dismissed as withdrawn. Full stop. Consequentially, IA number GA1 of 2023 stands disposed of as well.
My
No
lord,
rest to court.
instruction may be kept on record.
What is the instruction? Let me see that.
Though it says, my lord, to withdraw with liberty to file, I leave it to your lordship.
Keep it with you. Yes.
Item number 2, Hindustan Petroleum Corporation Limited and West Bengal versus West Bengal State Mines.
Yes.
But I appear for the petitioner,
Right.
but I am to reply today.
Yes, Mr. Dott.
But
Oh, you were
I-
arguing on the last option, right? You were
I-
arguing on the last option.
Yes.
Yes.
My lord, my learned friends have finished their
Yes.
submissions. I am to reply.
Right.
My lord, primarily, my lord, the argument was when the MSME Council,
Oh, works contract. Yes.
Yes.
Remember. Yes.
when the MSME Council has come to the conclusion that this is a works contract, whether thereafter they can exercise powers. They have sought to exercise powers by applying the dominant nature test.
Yes.
That is the bone of my contention, and I have said that in various judgments, one of which is Kone Elevators, where Supreme Court has said that the dominant nature test cannot be applied in case of a works contract. Now, that was my principal submission. And the second submission followed by that was that various high courts have held that in a case of works contract, the MSME Act does not apply. Therefore, I've cited 4 or 5 judgments,
Yes.
which your lordship has been pleased to note down, Miller.
Right.
My second argument was that when various high courts have taken this view upon interpretation of a central legislation, therefore, the other high court should ordinarily follow, except in a case where the high court feels that no, there are striking reasons not to follow that. The high court may not follow that, but upon recording its own observation on that. These were, Miller, my principal submissions, to which, Miller, with respect, Miller, I think, Miller, none of my submissions have been dealt with. This is number one.
Yes.
Then my second argument is to reply to what my learned friends have argued. Miller, first, Miller, in sequence, Mr. Pal had made his submissions, where, Miller, he sought to
Yes.
draw an analogy, Miller, from the contract itself that it is not a works contract. To that, Miller, I have got 2 answers. First answer is that when the MSME Council has found it to be a works contract, you cannot say that it is not a works contract, having not challenged that finding. I mean that conclusion.
Yes.
And number 2, on facts, the contract itself says that it is a works contract. Your lordship may kindly have a look to page 64 once.
Yes, 64.
at the top. Page 64. Sure. So where the contract itself also describe itself to be a works contract.
Right.
Well, two judgments have been cited, my lord, for your lordship's consideration. One is 2022 volume 1 Supreme Court cases, page 75,
Yes.
and an unreported decision in AP 835 of 2018.
Is this a marine craft judgment?
Yes, Marine Craft Judge.
Yes.
In both these two judgments, my lord, the contention was, or the question was, whether a writ court can adjudicate whether the particular contract is a works contract or not. This has not fallen for consideration before this honorable court. I have not come here for an adjudication from the writ court on the issue whether it is a works contract or not. MSME Council has said it is a works contract. Therefore, my lord, in my very humble submission, my lord, these two judgments would not apply.
Marine craft is a point of arbitration. The Arbitration Act overrides the MSME Act.
But in the Marine Craft judgment, my lord, there was another question, which is whether the Arbitration Act applies or the arbitration clause supersedes
MSME.
MSME Act. This is the second point involved over there. On that point also, so the other judgment which has been cited by my learned friend Mr. Pal is 2022 SCC Online AP 2013. We have paragraphs 14, 17 and 14, 16 and 17. Same point, whether the arbitration clause bars an exercise of power under section 18 of the MSME Act.
14, 16 and 17 are not cited by him.
But my lord, if your lordship
Point
goes
you are-
through these paragraphs, your lordship would find, my lord, this is.
Right.
So my lord, that is also not a question
No.
which has fallen for consideration before my lord, whether an contractual arbitration clause would override MSME Act or the arbitration under the MSME Act or not. But this is also not a point, my lord, which falls for consideration before this honorable court in this matter. Therefore, my lord, in my very humble submission, my lord, the contentions and the judgments which have been cited on behalf of the private respondent in my very respectful submission is inapplicable insofar as the points which have been raised by me in this writ petition. But this, my lord, is my respectful, my lord, answer to what Mr. Pal has submitted. Now, my lord, so far as Mr. Mukherjee has submitted, my lord, Mr. Mukherjee has mainly laid a stress on the object of the act.
Yes.
Now, my lord, the object of the act is, my lord, very clear in its wording. The object of the act is to facilitate or benefit the small, micro and whatever
Small scale.
or the industries, so that they can face a competition for the big players in their respective fields. Therefore, my lord, to give some benefit, it's basically a beneficial piece of legislation. There's no
No doubt.
doubt about that. Nobody can doubt it. No? That is the purpose. And number two is to minimize competitiveness between the bigger players and the smaller players.
Yes.
But that is the object. Now, my lord, we are not here, my lord, at the procurement stage. My lord, if your lordship goes through, my lord, the MSME Act, my lord, it has got two stages, in fact. One is the procurement stage where, my lord, some protections are given. And the second is post-award stage, or, my lord, after the contract is discharged or any dispute within the execution of the contract. My lord, we are, my lord, not at the procurement stage. We are at a stage where, my lord, the contract has been executed. There has been some claims of a micro small industry, to which, my lord, the question of the jurisdiction of the MSME Council qua the nature of the contract is in dispute. Therefore, my lord, in my very respectful submission, we are not dealing with the object and applicability of the act in its true sense qua the object. We are dealing with a case where, my lord, whether the works contract is contemplated within the act. But our submission is that the works contract is not contemplated within the act. The council wants to assume jurisdiction by trying to find out what is the dominant nature test, which, my lord, has been made clear, my lord. I don't think it's again required. That is in Kone Elevators case, my lord. But in fact, my lord, before the council also, we had placed all the judgments, my lord. It's unfortunate that none has been referred.
Dominant purpose was one of the tests, the major tests in the council's judgment.
Yes.
No doubt about that.
Yes. And my lord, all these judgments were cited. My lord, if your lordship may only take me at the index page of my written notes of argument before the council at page 387. Your lordship need not be bothered with the written notes of argument.
No, but yes. Right.
Index is at page 387. Your lordship would find, my lord, the judgments, my lord, we have cited.
All these were.
And the discussions of on the judgments in the written note, not in the, unfortunately, not in the MSME council's order, which your lordship would find, my lord, from page 400, para 25. And I must be, my lord, candid to the court. Dominant nature test was neither placed by me, obviously I will not place it, nor by the private respondent over there. Therefore, my lord, my note before the council, your lordship will
Nothing
not
about
find
that.
the any submissions on my part on the dominant nature
Very good.
test.
Yes.
But these are my respectful submissions. No.
I'll close arguments. No reply to reply. No. No further judgment has been cited.
No further judgment.
Did not clarify anything.
My lord,
Reply to
Mr.
reply.
Dotto, my lord, said that, my lord, the MSME council has findings that this instant contact is the works contact.
No,
But,
Mr.
my
I'm
lord,
sorry, no reply to reply. After order record করুন. Heard learned counsel for the parties. Hearing is concluded and judgment is reserved.
I'm grateful.
MSME তে সঙ্গে যাবে, হ্যাঁ?
Item number 3, Ashu Dhar versus the Assistant General Manager, UCO Bank and another.
Yes.
Lordship, may I please your lordship, I'm for the writ petition.
Yes, right.
Lordship, petitioner participated in the e-auction.
Proper service on the other side.
Yes, my learned friend is here.
Yes. Very good. Please proceed.
Lordship, petitioner participated in the e-auction of the respondent bank on March 23, 2020. And he was subsequently declared as the highest bidder. Lordship, upon tendering the highest bid amount to the tune of rupees 17 lakh, sales certificate was issued on April 6, 2020, which would appear at page number 11 of your lordship's brief. Lordship, series of representations were given. Writ petitioner was given neither the physical possession of the mortgage of the property, nor the amount which he had put in before the bank.
Sales certificate was complete.
But petitioner was not handed over the possession of the property.
So did you ask for refund?
Yes. Lordship, kindly
What
come to
is
page
that?
number 15. Kindly come to page number 15.
This is the entire writ petition.
Yes.
It's a welcome relief, actually. I mean, you have been very precise.
I'm
Thank
sorry.
you. This is what it should be, the pleading.
Yes, Lordship.
Anyway, so page 15, yes, you asked for a refund.
Yes.
Did they reply to this?
No, Lordship.
Yes, what do you say? Nothing to say, actually.
Lordship, your lordship has absolutely correctly. I don't have much to say.
What should I say then? Tell me what I should say. Do you intend to give back the possession or refund?
Lordship, as far as I have understood, it has been a long time. We have not been able to give the possession.
I think
So-
refund will be a better option.
Better option.
So refund, what is your claim?
Lordship, claim is, if your lordship kindly
Let me
come,
see page 15 once.
Only thing
kindly
is
come
that
to page number 15, penultimate paragraph.
Right. 17 lakh was the
Yes.
principal sum. Along with interest 14%, that can
Yes,
be
yes, yes.
considered. I mean.
That is the only thing.
What
that
is
I-
your rate of interest, which
Uh,
you take from the people?
House building loan, it is somewhere around 8%, 8.1.
I'll put it at 8.
Lordship, kindly make it 10, subject to Lordship's.
Why 14? You cannot make
Lordship,
it a money-making.
Lordship, kindly appreciate the agony of the
Your money
petitioner.
also.
Kindly
Your
appreciate-
agony versus public agony. To pay you 14% or 10%, even why 10%? I mean, why this magic figure? I'm taking their highest amount.
Lordship, let
It
them
is
produce that they are taking maximum 8% interest from the public.
No,
Let
I'm
them
saying-
put on affidavit.
no,
I shall accept that.
I am saying that
No, he's not saying
8%.
maximum.
8% is
Standard.
more standard for the house building loan. Since this is a property
What is your maximum?
maximum that I have to consider, your lordship.
Lordship, there is an SBAR.
So
Advanced.
10 is then reasonable.
I'm-
10.
Lordship.
Learned counsel for the petitioner contends that despite the petitioner having purchased a property from the respondent bank by way of e-purchase and the sales certificate having been issued as long back as on April 6, 2020, the physical possession of the property was never handed over to the petitioner. Subsequently, when the petitioner asked for refund along with interest, the bank is also sitting tight over the matter. Next para, learned counsel appearing for the bank submits on instruction that due to reasons beyond the control of the bank, the possession could not be handed over to the petitioner. However, upon hearing learned counsel for the parties, it is seen that there is no justified reason as to why the bank ought not to compensate the petitioner by refunding the principal amount taken by the bank, in view of the long delay of more than 4 years in handing over possession of the purchased property, along with interest. Next para. Learned counsel for the petitioner presses the petitioner's prayer for 14% interest. Next para. Learned counsel for the bank, on query of court, submits that the prevailing standard interest on house building loan is approximately 8%. However, there are certain other ventures in which the bank charges more interest. Keeping a balance between the claim of the petitioner and the stand of the bank, 10% interest per annum would be a reasonable rate for such interest. Next para. Accordingly, WPO 577 of 2023 is allowed, thereby directing the respondents to refund the amount, the principal amount of consideration paid by the petitioner to the tune of rupees 17 lakh, along with interest on the same, calculated from April 6, 2020
Grateful, Lordship.
till the date of such refund, at the rate of 10% per annum. Such amount along with interest shall positively be refunded by the shall be paid by the bank within what will be a reasonable limited
2 weeks, your lordship.
2 weeks. Fair enough. Thank you. Within today we are on 13th. Within June 30, 2023.
Lordship.
No rest to cause certain certificate.
I'm grateful, Lordship.
Thank you. Thank you for being fair. Yes. Next matter.
Item number 4, Uma Mitro versus the Directorate
Yes,
of
sir.
I'm
What is
appearing
the
on
matter?
behalf of petitioner.
Right.
But I will be praying for an accommodation till Monday because I'm being late by my senior who is ill. He'll
Very
be
good.
appearing on Monday.
Shall keep
I
it on-
apologize for my
On the
conduct.
prayer of the petitioner, the matter is adjourned till
19th.
June 19th, 2020.
Grateful, so grateful.
Yes.
Item number 5, Pranab Bose versus Union of
Yes.
India and others.
Well, I appear for the petitioner in
Right,
this
right,
matter.
right. Yes.
We are representing respondents airports authorities, 2 to 5.
Very well. One you have served.
Well, we've
I
served
am-
all of them. They
I
have
am
appeared.
appearing for one.
One. Very well. Yes. What is the matter?
Well, I am a regular
Please take your seat, sir and ma'am. Please take your seat. Yes.
My lord,
Okay.
I am a regular contractor for the Airports Authority.
Right.
I am aggrieved by an order of blacklisting dated 14th March 2023. I have not been given any hearing opportunity and I have been blacklisted. My lord, the contract relates to an electric turnkey project
Hmm.
for an airport in Guwahati.
If no hearing, then it should be set aside. Why not? Should be given a hearing. I'm asking you.
My lord, I am ready for hearing, and I have taken a jurisdiction point.
What is the jurisdiction point? Take that first. Then
My lord,
you'll deal with that.
Not
Take
only,
your seat, yes.
not only original site, even
Right.
the appellate site has got no
Jurisdiction.
jurisdictions.
Why?
My lord, may I come to the prayer portions first?
Please.
Main prayer.
Blacklisting order to be
Page
set.
13, my lord.
Page 13, very well, yes.
A read and or nature of the prohibition prohibiting the respondents, particularly the respondents number 7, from issuing work order with respect to the so and so tender.
Right.
Respondent 7 is outside of this state, that is in Assam.
I'll
They
not
are
grant that
agreed
prayer.
with
I'll not grant that prayer. I'll set aside the blacklisting itself. I'll
My
not
lord.
grant their prayer.
my lord,
fee.
second,
Yes.
most important, that second prayer, nature of directing respondents to forthwith transmit the entire records of the case,
Certiorari, yes.
particularly the order dated 4th March 23 passed by the respondent number 6. All records are lying in the state of
I'll refuse
Assam, my
that
lord.
also. I'll refuse
My
that
lord,
also.
as per
I'll
rule
refuse those.
of original site, when any record is outside of the jurisdiction of this court, certiorari may not be issued. My lord, second thing, I may be permitted to rely
Take your seat. You need not jump.
Supreme Court judgment about jurisdictional point. I think one judgment is very clear, Supreme Court judgment. May I be
Yes.
permitted? Judgment.
Union of India has nothing to say as such. Well, yes.
My lord,
It is Supreme Court.
my lord,
Take your time, find the judgment.
apex court decisions.
Citation. What is the citation, please?
Citation is yes, 1.90.007. My lord.
This is Alchemist Limited versus State Bank of Sikkim.
Yes, my lord. My lord, facts
Let me reply.
exactly similar in this
See
case.
first, then I'll give you.
No, may I
only about-
reply to the
No, reply, composite reply. I'll take it up lock, stock, barrel. Yes. Let
My
me
lord-
finish the stock and barrel first. Then I'll take the lock also. Yes.
I'm taking,
No, absolutely. Please. Yes.
my lord, I am relying on para
Yes.
4, 6, 23, 24.
Para 4, 6, 23, 24.
Let us come to 4.
4. Yes, absolutely.
Exactly similar case, my lord.
Mhm.
The appellant company submitted its formal proposal for the strategic business partnership by its offer dated February 3, 2004. Several proposals were received from various country and entities, and the board of directors in 143 meeting shortlisted 2 entities. That is appellant company and another company based in Calcutta. Negotiations took place between the appellant company and the first respondent bank. The chairman and managing director of the first respondent bank visited Chandigarh for further negotiations. The first respondent bank asked the appellant to deposit a sum of rupees 4.50 crores with the State Bank of India fixed deposit to show that to the appellant deposited the said amount with the State Bank of India, Chandigarh, on March 16, 2005, and the outcomings of the receipt were handed over to the executive of the first respondent bank at Chandigarh through a letter dated February 20, 2004. The first respondent bank informed the appellant company that government of Sikkim on February 23, 2006, the appellant company received communication at Chandigarh by which the first respondent bank informed the appellant company that the government of Sikkim had not approved the proposal submitted by the appellant company. My lord, for this cause of action, case was filed in Chandigarh High Court. Supreme Court says whatever communication received at the place does not confer or create any jurisdiction on the court situated there.
Why did it say that? Give me the ratio of the Supreme Court judgment.
No, my lord, this is my submission. The spirit of the judgment says, in later part it will come, my lord.
No, place that portion, the later part, where the Supreme Court has observed. This is the fact of the case I've seen.
Yes.
Show me that ratio of the Supreme Court judgment, the principle. Where the Supreme Court has laid it down. Show me that. I'm not attacking you. I'm requesting you. Show me that portion.
Yes, that portion I will come, my lord. Then para 6, page number. Para 6, page number.
Page 2.
Para 6, the appellant company contended that part of cause of action had arisen within the territorial jurisdiction of the High Court of Punjab and Haryana. The appellant company for such submission cited the following facts. Appellant company has a registered and corporate office at Chandigarh. My lord, this is the plea taken in their writ petition that they have received communication in Calcutta within the jurisdiction of this honorable court. The appellant company carries business at Chandigarh. The offer of the appellant company was accepted on February 20, 2004, and the acceptance was communicated to that Chandigarh. My lord, my humble submission, facts exactly similar. Their submission, their plea before this honorable court that they have received the letter of termination at Calcutta at their office. Only that plea, no other thing. Now, my lord, I am coming. This is a we will come to para 24. That is sufficient to meet our case. My lord, para 24.
24, yes.
The judgment of High Court was sought to the supported inter alia.
Probably para 23 also.
23 also.
Yes. Place 23 also.
Yes.
23 as well as 24.
Yes. The question territorial jurisdiction came up for consideration. A filed petition under Article 226 of the Constitution in the High Court of Gujarat claiming benefit of the passport scheme under so-and-so policy. Passport was issued by the Chennai office. Entries in the passport were made by the authorities at Chennai. None of the respondents was stationed. None of the respondents were stationed within the state of Gujarat. It was therefore contended that Gujarat High Court had no territorial jurisdiction to entertain the petition. The contention, however, was negative and the petition was allowed. The respondent approached the Supreme Court. The judgment of the High Court was sought to be supported inter alia on the grounds that one A was carrying on business at Ahmedabad. Orders were placed from and executed at Ahmedabad. Documents were sent and payment was made at Ahmedabad. Credit of duty was claimed for export handled from Ahmedabad. Denial of benefit adversely affected the petitioner at Ahmedabad. A had furnished bank guarantee and executed a bond of Ahmedabad at Ahmedabad, etc. My lord, following the appeal and setting aside the order of High Court, the Supreme Court held that none of the facts pleaded by A constituted a cause of action. Facts which had no bearing with this or dispute involved in the case do not give rise to a cause of action so as to confer territorial jurisdiction. My lord, my humble submission, anywhere in the pleading, they have not pleaded that whether action on the part of the respondent has arisen within the jurisdiction of this area. All records are available in Assam. It is very difficult to the establishment of Airports Authority of India to contest this case before this court, my lord. So, spirit of law principles decided in this case is applicable to us, and hence I humbly submit that my jurisdiction point may kindly be considered.
Anything else regarding merits? You have nothing because you are taking the jurisdiction.
No
If I turn down the jurisdiction point, then what is your point on merits? What is your argument?
Merit, I can argue.
What is the argument on merit? Make a composite argument so
lord,
that they can also reply.
My lord,
Regarding blacklisting, what is your?
was allotted.
I am only putting you one question. One,
Hmm.
whether the blacklisting was divorced the law without giving him a hearing, an opportunity.
Yes. Show cause was given, my lord.
You say show cause was given.
Show cause was given, and we are not satisfied with the show cause.
Achha.
My lord, one thing, job allotted to him is very, very important.
True,
If job flow is there may be an air accident.
No doubt
Lighting
about that.
job in the
Hmm.
airways, they have defaulted.
Hmm.
And for that, their contract was terminated as per termination clause. 1 year debarment has been made as per procedure laid down in the manual.
Let me hear. Yes, on the jurisdiction point primarily, and also on
Not show cause issued, no hearing, blacklisting. Covered by erosion and the subsequent judgments.
yes. About
Now,
jurisdiction.
On jurisdiction is the argument.
Yes.
But Article 226(2), I'm not placing it.
Hmm.
Secondly, my lord, in a blacklisting matter,
Hmm.
if I receive the notice of blacklisting at my registered office or at my place of business within jurisdiction, and it takes effect there, I am prejudiced within jurisdiction.
Hmm.
In a similar matter, my lord,
Hmm.
which is, in fact, this is a better matter because it's a blacklisting order, which, my lord, has graver consequences, which I feel at my office. There was a RDSO delisting matter. Because of an RDSO listing, I was getting contracts. RDSO delisted me. We filed a writ petition in this honorable court, and the learned single judge, my lord, was pleased to reject the writ petition on the ground of jurisdiction. We succeeded before the division bench. That is a judgment, my lord, which I want to place before your lord.
Give a copy to him so
Yes,
that I'll hear you on this limited point also.
Of course, I.
Yes.
My lord, please, my lord, have a look at page 3, last paragraph. The appellant number 1 and Thales sent a letter that dated such and such, agreement dated such and such, and technical transfer and collaboration agreement. But the respondent number 4, vide his letter dated 17th August 2021, temporarily delisted the respondent number 1. This was the challenge. Now, my lord, page 5. After the order of dismissal, my lord, the division bench notes the honorable single bench has been further pleased to observe that the mere fact that the writ petitioner number 1 has its registered corporate office at Kolkata, or it has obtained finance from banks in Kolkata, and by impleading other authorities such and such, will not ipso facto confer jurisdiction when the integral principal cause of action was outside, because RDSO is in Lucknow. Now, my lord, judgments are cited. My lord, submissions are recorded. Page 9, my lord.
Page 17, second last paragraph is probably the most convincing. Probably the most convincing. Because I was thinking in those lines also, not because I was thinking it's most convincing, but otherwise also, I mean, logically.
That is the conclusion. But may I, my lord,
Something else apart from this?
everything leads
judgment.
to that.
in
Everything
this
leads to that, my lord.
Very.
My lord, my favorite judgment. My lord, please permit me to cite, though not necessary after a division bench judgment. Anoni. I'm sorry.
Thank God. Yes. Thank you.
Lalit, I wanted to cite Lalit Kala Academy, my lord, which also considers 226, distinguishes the four Supreme Court judgments which blemished our institution for a long time. My lord,
Justice Banerjee's judgment.
no, this is Justice Dotto's judgment.
Achha.
Lalit Kala Academy, which takes
Lalit
into
Kala Academy.
yes, which takes into account ONGC. Lord,
That would be more on sentiment, Mr. Chaudhary.
yes,
This is more on logic.
this is
So let us not go on sentiment. Let us be on
no,
logic.
that's also applicable. But
That
now
binding.
with the
nothing.
division bench judgment, it's not necessary
Correct.
to cite that.
Correct.
And Lord, no hearing given. The other point is, I don't want to take it now. I'll take it before the authority. The tender subject to correction does not have, my lord, the relevant blacklisting clause, which, my lord, I'll take before the authority once I go back, if I succeed before your lordship.
Very well. You are Mr. I'm sorry. No. Mr. Poddar. Yeah, Mr. Poddar, please just satisfy me on the cited judgment. Please come to page 17 of that.
17.
Cited judgment. Mr. Chaudhary cited.
Page 17.
Ask your learned junior friend to help you. He appears to be very competent also.
Yes.
Yes. Find out the penalty. The second last paragraph of page 17. That please defy that logic. That convinces me most. I am against you on jurisdiction for this. So satisfy me against it. But in the present case.
Yes, my lord. Undoubtedly.
So this is blacklisting. The judgment you cited is on the termination of the contract, or rather the contract did not materialize.
We have met only department for a period of 1 year.
Even for a single day. Blacklisting is different from refusing a particular contract.
Yes.
Mr. Poddar, undoubtedly you would be on a much better footing, at least in my court, if they had challenged merely the contract refusal. Probably you would have a very good case on this judgment also, but then it would be a very arguable case probably.
Yes, my lord.
But in this case, it's clinching against you since they have challenged the blacklisting without giving them an effective hearing. Only this. So the best order I can grant them is setting aside the blacklisting and directing you to give them a hearing, and then not blacklist them, but to do whatever. Decide it in accordance with law.
My lord, problem is.
That is the only thing I can do, and I'll not direct affidavits because it's on only that point.
My lord, only one thing.
Please
would
open
like
your.
to draw your lordship's kind attention.
Right.
What is the nature of the job? Airport authority is
Job is
maintaining
very
writing in this. Now,
Mr. Poddar, only one aspect of the matter. If you blacklist me, suppose if I did the job very badly, you blacklist me, which is absolutely all right. But before blacklisting, I have to be given an opportunity of hearing. Because otherwise, if you proceed on that premise without opportunities, then Mr. Poddar, there was no use of hearing you at all in this matter. Suppose I bring that analogy in. I heard Mr. Chaudhary or his learned junior, only them. And I did not give you opportunity. I give you a show cause before you come, I say, hear it out. And I allow their application. Then the jurisdiction point could not have been taken by you at all. So applying similar analogy, in your position, kindly put the authorities. They did not have an opportunity of hearing their version. In an adversarial system, in a society, Mr. Poddar, giving a hearing is very important because we never know what comes up from their hearing. That is the difficulty. I am only on this violation of natural justice patently because they were not given an effective hearing. They could have said many things which might have convinced the authorities. We don't know, we never know. So that is the only reason. That's why I'll set aside I'll
My
reject your
lord,
jurisdiction point.
I fully agree with your lordship.
Then let me pass my order.
That natural justice demands
Yes,
the
definitely.
hearing should be given.
Yes,
But
Mr.
most probably your lordship is well aware that in public sector working, in so-called notice for this type, there is no system of hearing. That is why it was not given. But if it is directed,
I'll introduce that system, Mr. Poddar, subject to what the appellate court says. I'll introduce that system from now on. Yes, I'll pass my order. Yes. Ash. The petitioner's challenge is limited. Full stop. By virtue of the impugned communication dated March 14, 2023, the respondent authorities virtually blacklisted the petitioner by debarring, DEBARRING, the petitioner from participating in future tenders for any work in Airport Authority of India, CAPSE, Airport Authority of India within bracket AAI, bracket close.
For a period of 1 year only.
I'm reading. Please take your seat, Mr. In any name and style for a period of 1 year with effect from the date of the issue of the said order. Full stop. Next para. It is noteworthy that the petitioner has its office in Kolkata, which is within the territorial jurisdiction of this court. Full stop. Next para. It is contended on behalf of the petitioner that no hearing worth the name was given to the petitioner prior to the said impugned decision being taken, which is the very antithesis of the principle of natural justice, odi alteram partem. Full stop. Next para. Learned counsel appearing for the petitioner also cites an unreported division bench judgment of this court rendered in Eldine Electrosystems, একটু দেখে করে দেবেন, হ্যাঁ, এখানে Eldine Electrosystems এই নামটা, versus Union of India and others, wherein in a similar matter, the division bench was pleased, inter alia, to observe that the petitioner had alleged that the impugned order of temporary delisting, 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 affecting its legal right and having adverse effect on its business was served to it at its registered office in Kolkata, and as such a part of cause of action had arisen within the limits of this court, where the order of delisting had taken effect. Full stop. Next para. The learned division bench had gone on to consider several judgments and ultimately come to the conclusion that this court, accordingly, had jurisdiction to take up the matter. Full stop. Next para. Learned counsel further contends that within the contemplation of Article 226 within bracket 2 of the Constitution of India, the law rendered by with regard to territorial jurisdiction, every high court in the country has jurisdiction to look into and correct any irregularity or illegality committed within any part of India, even if the same is beyond the territorial jurisdiction of that particular high court. Full stop. Next para. Learned counsel appearing for the respondent authorities takes a preliminary objection as to maintainability and cites a judgment of the Supreme Court reported at Manu, MANU, Block A, /SC, /1290, /2007, within bracket, Alchemist Limited and others versus State Bank of Sikkim and others. Full stop. Next para. In the said judgment, comma, the Supreme Court had inter alia gone on to hold that facts which had no bearing with the LIS or dispute involved in the case, comma, do not give rise to a cause of action so as to confer territorial jurisdiction on the court concerned. Full stop. In the said case, comma, none of the respondents was stationed within the state of Gujarat, comma, for which it was held that the said High Court did not have territorial jurisdiction. Full stop. Next para. It is further submitted that a show cause notice was issued to the petitioners. Full stop. Next para. A bare perusal of the impugned communication dated March 14, 2023 indicates that the same does not reflect any consideration whatsoever regarding any objection that the petitioner might have to the decision to blacklist the petitioner for 1 year. Full stop. Be it for a single year or even for a day, comma, an order of blacklisting not only casts a stigma but also affects the goodwill of the particular concern. Full stop. Next para. It is relevant to mention that Alchemist Limited Supra was also considered by the division bench cited by the petitioner in some of its paragraphs. Full stop. Next para. Hence, comma, this court is bound by the judgment of the division bench of the same court, comma, which also took into consideration and interpreted the judgment of the Supreme Court cited by the respondents. Full stop. Next para. That apart, comma, even logically, comma, Alchemist was considering a case where the challenge was primarily against the disapproval of a proposal submitted by the appellant company therein, comma, which tantamounted to refusal to enter into a contract, stroke rescinding, rescinding, rescinding a contract. Full stop. The premise of such a challenge is much limited when compared to the present one, comma, the latter being on a wider footing of blacklisting the petitioner from participating for 1 whole year for any work in the AAI. Full stop. Next para. Moreover, comma, as rightly observed by the division bench, comma, with utmost respect, comma, the other logic which sanctifies the territorial jurisdiction of this court is that the effect of the impugned blacklisting would directly be that the petitioner would not be able to function in any activity of the AAI from its registered office situated in Kolkata, comma, which is the territorial jurisdiction, which is within the territorial jurisdiction of this High Court. Full stop. The same, comma, thus, comma, operates on a wider scale than a mere refusal or rescission, RESCISSION, of a contract. Full stop. Next para. Thus, comma, the objection as to territorial jurisdiction taken by the respondents is turned down. Full stop. The other aspect sought to be highlighted by the respondents is that the nature of the job demands the highest standards, comma, since the same affects the safety and security of millions of people, comma, who travel by air and also delivery of goods. Full stop. Next para. Even without denying such proposition, comma, the same cannot be a stimulus, comma, per se, comma, to blacklist a particular concern without giving it an effective hearing and considering its objection. Stroke show cause. Full stop. Next para. In the present case, comma, No objection or cause shown by the petitioner was even considered at any point of time by the petitioner, by the respondent authorities, and the blacklisting was patently unilateral. Full stop. Next para. Apart from the above discussions, the petitioner is also justified in arguing that, within the broad campus of Article 226 within bracket 2 of the Constitution of India, an injustice which affects a resident of the country, of a citizen of a country, perpetrated wherever within the territorial jurisdiction of within the territory of India, justifies interference by any or all of the high courts of the country, which exercise concurrent jurisdiction to such extent. Full stop. Next para. In view of the above findings, the impugned impugned communication of blacklisting of the petitioner was palpably dehodes the law and without authority. Full stop. Next para. Accordingly, WPO 742 of 2023 is allowed on contest, thereby setting aside the impugned blacklisting of the petitioner dated March 14, 2023. Full stop. However, nothing in this order shall prevent the respondent authorities from giving a due opportunity of hearing to the petitioner upon a cause being shown specifically to the petitioner as to the reason of the proposed blacklisting. Full stop. Only upon such opportunity of hearing being adequately given to the petitioner, the respondent authorities shall be at liberty to proceed with its decision to blacklist the petitioner or otherwise in accordance with law. Full stop. No address to cause certain certificate. Thank you.
Grateful to you.
Sorry, Mr. Podar, you argued very well, but I could not accept it. Yes, thank you. And your junior is very competent. Apart from his junior, also I know them, but I did not know him. He's very competent. Thank you. Call on them.
Item number 6.
6, who is appearing for the petitioner?
I
Yes.
appear for the petition.
Yes.
For the respondent, some of the
This is
Yes, what
with
is that?
respect to the refund of the GST amount with for a contract. Lordship, what has happened, my lord?
Explain the principle and
The
the
principle, my lord.
and logic
Lordship.
behind GST to me. I mean,
Lordship,
start from the beginning.
Lordship,
We have to start from there.
we need not go into much
Very
details. Only thing is, we were granted, Lordship, the petitioner used to run a refreshment center in Howrah station. The railways had given the license to the petitioner. Lordship, just before the COVID-19, Lordship, this license was introduced, was given to us, and we had paid the license fee along with GST component to the railways. After giving this, after the COVID-19 started, Lordship, in June 2020, Lordship, we had asked for an honorable discharge. Lordship, we gave several reminders.
It's an honorable discharge in a contract.
Honorable discharge means the honorable exit would mean that no damages or
Doing too many
nothing.
criminal matters, Mr.
No liquid. No.
Anyway,
No,
then you sought
not-
for that.
not really.
What happened after that?
Lordship, after repeated reminders, Lordship, only in October, 1st October 2020, Lordship, it was communicated to us that it has been decided that
When was your first communication regarding this? Seeking the exit?
in
or
June,
discharge?
my lord,
June 20?
2020.
Right.
Sorry, my lord, 8 July 2020.
Right.
And on 14th October 2020, we were communicated that from 1st October 2020,
I'm sorry, 20th?
14th October 2020, we were communicated that we would be given an honorable exit from 1st October 2020 till the end of the license period.
Right.
In terms of this honorable exit, Lordship, we were given the proportionate license fee, which was refunded to us. But the GST component was not refunded to us. Lordship, we had wrote
So,
to
Ali,
them-
as far as I know, my knowledge is very limited on GST.
Lordship.
But just satisfy me on that. GST is payable one time at the inception.
Lordship,
So is there any scope because they have already paid or whoever has paid?
I have paid.
You have paid, that has been, that has gone
I have paid
wherever it
license
was.
fee plus GST. And Lordship, there is a provision in the GST Act, Lordship, for refund
Oh,
of
okay.
GST.
No,
So
what is the
railways-
provision? Have you
The
got it?
railways, Lordship, I have set out the circular, my lord, in my petition.
That will do.
Lordship, the railways could have applied to the authorities for
Acha.
refund of the GST, and at that point of time, my lord, due to the COVID-19 period also, Lordship, they could have asked the authorities to refund. My lord, what happened, my lord? This is the second round of writ petition. They did not give any refund. Ultimately, they said that we cannot refund you the GST component. Lordship, we challenged that in the writ petition. Lordship, there was an order that since it is unreasoned, there is no reason given, you should consider and whether the GST component, how you can refund and etc.
Yes.
Thereafter, Lordship, no hearing was given, but nevertheless, no, I'm so sorry, my lord. In this matter, a hearing was given. The previous matter, hearing was not given. Hearing was given, but in the order, it was said that since that it can be refunded, the supposed and a GST expert was consulted. I do not know who was that. Who said that High Court has to say that GST has to be refunded.
Apparently, it was someone like me,
No, well,
the GST expert.
so
Knew as much of GST as me. Anyway,
anybody would know better.
That was refused on that ground.
That was refused.
High Court has to do what?
No, my lord.
High Court has to say that
Well,
it has to be refunded. And
That's his version. Let me hear his version first. Yes.
well, that is the
You are
order.
challenging that.
Lordship, kindly see page 136.
Let us see.
That is the impugned order.
Right.
Reference above your representation regarding refund of GST amount post honorable exit from the contract of Jan Ahar Howrah Old Complex along with Honorable High Court at Calcutta orders dated 5th April 2023 has been received. The matter has been examined and it is observed that the Honorable High Court with the order dated 5th April 2022 has stated the Group General Manager IRCTC Eastern Zone Kolkata shall consider the petitioner's representation.
You wanted a clarification basically from the High Court probably.
No, but I want the authorities to refund me the GST component. The GST component is returnable. That is an admitted fact that they have admitted. The quantum is admitted. Only thing is that they are not refunding it on one pretext or the other. Here the pretext is something very strange. The matter was discussed with GST consultant and GST consultant has opined that IRCTC has to wait till the licensee gets the order from court having specific mention for refund of GST amount. Number two, after getting order of the court, which have a specific mention for the refund of GST amount, IRCTC has to take an affidavit from licensee that they have not availed the input credit of GST, including a complete working supported by the documents in connection with not claiming the input. This was the, so whether the GST amount is to be refunded or not, that is not decided. Only thing is the High Court has to say that it has to be refunded.
Let your learned friend explain it to me, then we'll come back to it. Take your seat, Mr. Ali, I'll hear you. Yes.
My lord, that's why I wanted to start first because this order it's not satisfactory to me also. My lord.
Even then, just explain to me what is the.
My lord, what happens, my lord, what they are relying on a circular.
Take the microphone a bit closer.
What happens, my lord, they are relying on a circular which is at page 9 of this writ petition, stating that they are eligible to get a refund under GST. My lord, kindly see page number 9. I didn't get an instruction, my lord. I'm stating as by my knowledge, my lord. They have to file a form RFD01. Any person who is entitled to get a refund, they has to file an RFD01 under Rule 90 of GST rules, read with Section 54 of the GST Act. They ought to have filed that. But my lord, I didn't get any instruction. Number one. Number two, my lord, who ought to have released? Because first, initially, it was the contract is with your railways. Thereafter, it has been tripartite agreement, IRCTC, railway, and the petitioner. The GST has been paid to the railways at the initial point of time. Now, if at all they are liable to reimburse, who is going to reimburse? That is a matter of question.
But this is not a consideration as
This is not a consideration.
That is the difficulty. So I'll set it aside and directing them to consider it.
No, that will
But
be.
if you can, we can
I can-
iron out the creases
Yes,
then
that
they
we-
can
that's-
comply and it can be
Yes,
done,
Lord.
refunded to
May
them.
come on Monday and get a report.
A report may be.
Fair enough, fair enough. So it can be resolved once
Yes,
and for
ma'am.
all.
Yes, ma'am.
If it is payable, if you take a
Payable?
stand payable,
Yes.
they'll do whatever they have to do.
Yes,
It
Yes,
can be done.
Lord.
If you say it's not payable,
Then
just give one or
we
two
will-
lines of the reasons.
Yes.
I'll set this aside and direct you to give reasons.
Lordship, Lordship.
Very good. Learned counsel for the petitioner contends that after a previous round of litigation, relegating the matter to the respondent authorities, comma, to give reasons on the question of refund of GST amount to the petitioner, comma, which had previously obtained an honorable exit from a license to operate what was that, to operate
Refreshments
a food outlet, a refreshment outlet
in the Howrah station.
Jana.
Janahar.
in the Howrah station. Full stop. Next para. However, comma, by the impugned
That was it.
communication dated March 14, 2023, comma, the respondent authorities observed that the authorities had to wait till the licensee got an order from the court within double inverted, from court, double inverted, having specific mention for refund of GST amount. Full stop. That apart, comma, certain other hindrances were put up in the communication in the refund of GST. Full stop. Next para, it is argued that the said reasons sought to be furnished in the communication are dehors the law and defy logic. Defy, DEFY, logic. Full stop. Next para, learned counsel appearing for the respondent, comma, in his usual fairness, comma, submits that although a portion of the reasons given are not intelligible, comma, apparently something further was to be done on the part of the petitioners for the authorities to consider the question of refund. First, be that as it may, comma, since an amicable resolution of the issue may be on the anvil, as it appears from submission of counsel, comma, learned counsel for the respondents, comma, on his prayer, comma, is granted time till June 19, 2023, comma, when the matter shall next be listed under the same heading, comma, to take appropriate instructions from the respondent authorities. Full stop. On the next date, comma, learned counsel for the respondents shall inform the court as to what further formalities the petitioner has to undergo for the purpose of getting refund of GST, comma, if any. Full stop.
Great.
Great.
Yes.
There's only one thing, my lord, proportionate GST fee.
জিএসটি যেখানটা বলেছি প্রপোর্শনেট করে দিন, আমি দেখে নেবো যদি কোথাও কিছু। থ্যাংক ইউ।
Great.
Item number 7.
Well, item number 7, 8, 9, 10, Malor. Well, I am appearing for the National Jute Board, Malor. Well, we have instructions to appear in this matter. Well, if your lordship kindly adjourn it for 2 weeks, man, I'm praying for time. This is a hearing matter, man. This is a hearing matter.
So what? I'll hear it out today.
Some
Try to
difficulty,
intimidate me by saying it's a hearing. Most of the matters are hearing.
some difficulty, Malor. Otherwise, I would have not, Malor, prayed for.
Mr. You have to satisfy Mr. Banerjee of the difficulty.
No,
He's for the
he somehow prevailed over me, but 2 weeks is a little, not
2 weeks.
come next week, not
2 weeks, Malor. it
next
requires,
week
Malor.
anytime. He's prevailed over me for a week. Beyond that.
learned counsel for the respondent authorities seeks a fortnight's adjournment. Full stop. Learned counsel for the petitioner submits that in view of the urgency involved, comma, at the most 1 week may be granted. Full stop. Accordingly, the matter is adjourned till June 20, 2023. Full stop. The respondents shall come prepared for hearing on the said returnable date.
Yes.
Use this for getting your instructions.
7, 8, 9, 10 minutes.
7, 8, 9, 10. Shall I club these matters together?
Yes, yes, yes.
Lordship could.
Yes,
They could
yes.
be heard out.
তাহলে একটা কমন অর্ডার হবে, তাহলে প্লুরাল হয়ে যাবে, the matters. Thank you.
Great.
Choose. Thank you.
Item number 11.
Yes, Mr. Shah, what is the matter?
11 Lordship, I am for the respondent number 1 Central Bank. However, there are two matters clubbed together. The thing is, Lordship, I'm humbly submitting, I'm not appearing on behalf of my own client in the second matter. So I have only instructions in respect of the first matter.
Take instruction, come back.
I have already taken instruction. They have already appointed
someone else. You are appointed.
I am in item number 12, Lordship, for respondent number 3, Central Bank of India.
Lordship, my counterpart.
Opposition.
No, you are also appearing for the Central Bank of India.
Your Lordship, I appear for the
Please give me half a minute. Yes.
I appear for the petitioner in item number 11.
12.
Your Lordship, in 12, I am the respondent number 4. The matter is, Your Lordship, why this matter has been clubbed together. There are dispute related to 2 checks, Your Lordship. May I just make a clarify?
You are appearing for the? Who is appearing for the petitioner in 12? You are for the petitioner in 12.
On the last occasion, Mr. Pranav Sharma, accompanied with Mr. Rishabh Karnani, appeared in the matter for the petitioner, Your Lordship, in item number 12.
Why were these clubbed together?
Your Lordship, may I just clarify what is the position? The petitioner in item number 11, company maintained a current account with the central bank, Your Lordship. In course of his business, it issued 2 checks. They were post-dated checks. They were the undated checks in favor of the respondent, who is the petitioner in item number 12, Your Lordship. Now, those checks were presented on a particular day. My case is that it was presented prior to the proposed date, whatever may the case. But on the date of presentation, there was no sufficient fund in my account, for which both the checks were dishonored, and the charges for the dishonor were debited from my account that I can show. After passing of almost 2 months, Your Lordship, suddenly a message was forwarded to me on my registered mobile number that my current account has been marked as a lien. I was surprised because I haven't obtained any loan. Thereafter I started communication. The central bank is writing that yes, those checks were dishonored due to the fund insufficient. However, there was some system error for which subsequently it was honored in favor of the respondent, who is the petitioner of the item number 12. And now we have asked to ICICI Bank to mark hold on that amount, to refund those amount which was wrongly credited in their account. However, ICICI Bank could not do so. That's why to recover those amount, they marked lien on my current account, Your Lordship. So this is the case. Now, after filing of this case,
so then you will have to make a double payment, basically.
Yes, Your Lordship, because there was an understanding.
So according to you, if they committed a mistake, it is to be recovered from the person who was overpaid.
Yes, Your Lordship. Whether I am liable to pay to Mrs. Strack or not, that is a different aspect, Your Lordship. That has to be adjudicated. However, the fact which is apparent on the record is that Central Bank has committed an error. Now, to cover up their fault, their admitted default, they marked lien on my current account. In fact, closed the account without giving me any intimation, Your Lordship, and has also filed a suit against me, which I came to learn subsequently after receiving their affidavit in opposition.
Who are the pending counsel appearing for?
I am.
For the petitioner in the other petition.
Item number 12 is.
Who are they?
They are Mrs.
No, you take your breath first.
Yes.
I'm the
I don't want to take a risk.
Beneficiary of
You're
those
too
checks.
young for any risk.
Beneficiary of those checks. They are the beneficiaries of those checks, Your Lordship.
Oh, acha, either you have to pay or they have to pay now. Interesting. Very well. Yes.
In fact, Your Lordship, as far as
You are seeing the fun. You have committed the mistake and you are seeing the fun.
That I can serve from the document.
I can understand the feelings of my learned friend, but the problem
Our
remains,
feelings won't do.
Lordship, the problem remains the writ petition is not in subject to that point itself.
Yes.
The only prayer that she is making, my learned friend is making, my petitioner is
I'll
making,
come to 12. Don't worry. Yes.
petitioner is making in this writ petition is to remove the lien. Is to only to remove the lien. In my affidavit in opposition, I have already stated specifically that before filing of this writ petition, she has been the petitioner has been intimated that the account has been closed.
No,
That has been formally intimated by email in the registered email.
1 minute, Mr.
Lordship.
Shah. If an account has been closed by lien,
Lordship. No, it has not been closed by lien. It has been closed by under the notification of the RBI in respect of the negative balance.
That was not intimated to me. That's why
That
this
has
prayer
been
was
intimated. I have already submitted the
I will come-
relevant
I will come
documents.
to
So
that.
this
I will
DA
come to
news,
that.
There is no question of reviving of the account.
DA news say is not regarding Mr. Shah, that check bouncing.
No, no, no. I'm
It's
not
on a
saying
different
that.
footing.
I'm not saying that. I am saying there was a lien in the account. Subsequently, due to the negative balance, and as far as the notification of the honorable the RBI, the bank was supposed to close the account. The bank has done that, closed the account. I have stated that in my affidavit in opposition. Thereafter, I have intimated the petitioner that your account has been closed. Subsequent to that intimation, after a long period, they filed this writ application saying that lien should be removed. That is the whole point.
That lien was imposed prior to the closure of the account.
Prior to the closure of the account. However, subsequent this writ application has been filed long after, and there is no prayer whatsoever in respect of reviving of that account.
What would be
It's public money, Lordship.
No, public money, I understand. But Mr. Shah, what would be the effect of that lien
That
remaining
is
there?
already I have filed a suit against them. That is pending.
That lien was for what?
That
Because you're
lien
double
was-
charging.
Not double charging, Lordship. What happened, Lordship? There was the check was presented in their account.
Presented.
There was not undated. It was a dated check. It was a regular check, and that check was allowed. That check was accepted from the bank. There may be a technical mistake on behalf of the ICICI or on behalf of the central bank. I'm not going to comment on that. However, the fact remains is that check was cleared. The money was transferred to the beneficiary's account. Now, subsequently, when I see that, when the bank see that there is a technical glitch, it was intimated to them that this is a technical glitch. Your whatever check return amount is there, we can refund that, but this amount has been already disbursed. You have to pay that amount. And for that reason, since there is a technical glitch on part of the bank itself,
Why should they pay for your
I have
technical
already
glitch?
filed a suit.
Why should they pay for
That
your
is sub judice in the
Why should they pay for your technical
That
glitch?
is what I am saying. That it is a check issued by them.
Yes.
That matter is sub judice in the suit itself. I have already
You are
filed a
making
suit
it sub
claiming that-
judice, Mr. Shah does not improve the situation.
Lordship,
You have committed a mistake, you pay for that.
that
You pay the customer for that.
that is a technical issue by the ICICI Bank, not from
No.
our
That's between you and ICICI Bank too. You have released the amount. Why is it a technical glitch on the part of ICICI?
technical glitch only on the part of stating that the check has been returned, not on the other part.
No, Mr. Shah, under the NI Act, it was your liability
Lordship,
to be reasonably prudent. If you disburse the amount, it was your fault.
Lordship,
So you have to pay for that. The bank has to pay. Your bank has to pay for
that
that.
has to be paid. The only
Well,
prayer is to remove the lien, not to refund the money.
I have made that prayer in
If there-
But
if
it's
there-
a question of putting that lien at all in the first place.
Even if I remove the lien, Lordship, suppose agreeing to accept.
No, either you remove or I remove.
Yes, Lordship. The honorable court may. But
Mr.
I
Mr.
bow
Shah,
down.
why should it remain at all?
That is what I am saying, Lordship. I bow down to the court. Even if I
Well,
remove the lien, even
yes.
if I remove, there is no account present at it.
Even then,
may
it will be retrospectively removed then.
may I some
You, first matter is over. Second matter is
Your Lordship, I have to show some document. That's why since
Not
just
over.
a second, only one sentence. If I
Zoja,
just
I'll hear you. I'm just taking the contours of the challenges. Yes.
I am at a much better pedestal than my learned.
What is your challenge?
My challenge is I don't have an account.
Take the.
I don't have an account with the central bank. That is the account of my learned friend's client.
You have
Is
with
the-
ICICI.
My account is with ICICI.
But you are for central bank also. ICICI is a party in any of.
ICICI is a party.
You are for ICICI.
Yes. I lent an advance money. It's an intercorporate deposit to my learned friend, learned friend's client, which is respondent number 4. I receive part payments. For the balance amount, I receive the check. 2 checks, 15 lakhs, 40 lakhs. Both checks I deposit in my bank account with ICICI Bank. Both checks get honored. Now, after 1 month from the date of honoring of the check, my account has been marked lien and monies have been taken away from my account by Central Bank of India and ICICI Bank acting in unison. I do not know at whose instance, but both
Without any notice to you.
without any notice, and in as much as I don't have any banking relation with central bank, there cannot be any lien, either general or particular, so far as my account is concerned. I am only on this issue. Whether that money was duly credited to me, to my account or not, is not an issue. It was credited. That is their case. Now, I have utilized that money. Now, suddenly, from all payments which I receive, My account is, monies are being taken away from my account. Pending the adjudication of this writ petition as well, 30 lakhs have been taken out without any notice.
Total amount?
55 lakhs is what has been credited to my account. 15 taken away from the respondent number 4 account. That's what we have come to learn. I have nothing to say on that, but what the bank is doing is taking monies from both accounts, from the petitioner as well as the respondent number 4. But yeah, my submission is, I do not have a contract with the
Central Bank, yes, I can understand.
So
What-
Central Bank doesn't have any locus to mark any
What
lien.
about the ICICI? What's your argument on
But
that?
my account has been credited. It's after a month that they are taking away monies from my account. If I take their case to be the highest, that there was a technical glitch, then they should file a suit for recovery, and everything which they have taken out should be refunded,
Which they have probably.
which they have not. Not against me.
No, against them.
Against them, not against me.
Very
But I do not file a suit against my learned friend's client because I'm happy with the money. Now I am saddled with all these.
Hmm.
Because my dues have been paid off, so I did
You
not
have challenged that imposition of lien on your account.
on my account, and also taking away monies
Taking away
from
the amount also. What is your stand on this? CBI has any, not CBI.
in their
Central Bank,
affidavit. There's
Central Bank of India, yes, CBI.
CBI.
Do you have any? It's a magic name now.
Yes. Now it's
So yes, what is the stand of the CBI? You should be at the receiving end in many things.
Admitted.
What is the stand in this opposition? Tell me that.
technical error.
Whose technical error? What is the exact meaning of technical? Who committed the error? ICICI or Central Bank? And what is the error? Explain to me. This technical error is a very good umbrella for all of you.
Network failure.
Whose network?
Network failure.
Sue the Union of India for network failure? Or the operator, whoever was giving it to you?
This is another.
So why are you taking these poor people's, not poor people as such, poor in a different sense? I mean, yes. You suffer for that.
Lordship, the amount was credited. Lordship, the amount was credited. And after this thing, sometimes later, Central Bank of India informed the ICICI Bank that regarding the 2 checks. On that date, Lordship, 47 checks were honored by the technical error. But 45 checks were returned by ICICI Bank in respect of the same cause of action. And on that date, your Lordship, 83 lakhs, some thousands.
It was initiated by you, the central bank, because initially you say it ought to have been dishonored, but you honored those, and on your instruction, ICICI Bank paid. So up to that point, you were at fault. Nobody can doubt that. And if you were at fault, ICICI Bank acted bona fide, all the rest acted bona fide. But it's the Central Bank of India's problem then. Why should the others pay? This is public money. That's why the bank's officials should pay, who are responsible. You hold a departmental inquiry. Tell me who are the officials. I'll attach their amount, their salaries.
47 checks, 45 capital return.
Central Bank has to be accountable.
That is none of our concern.
Amount was credited to Central Bank.
First of all, why should the petitioners in 12 pay? Why should these people pay?
2 checks, your Lordship.
Why are they at fault? Tell me one reason why the petitioner in your writ petition is at fault. Tell me one reason. Give me one reason why they are at fault. What is it? Why should they pay a single paisa? Why? Yes, what is this? Give me one reason. One reason.
That's not me.
Not the amount is there, sufficient amount is there in that account.
See the poor face of Mr. Gupta. How innocent he is. What is his fault?
His account is insufficient. And due to technical failure, your Lordship, technical error, I have paid this.
I'll pass a technical order also then.
But 40 lakhs taken away from my account unilaterally, without any suit, without any.
I'll not leave the matter at that. I'll direct the central bank to file a report after a departmental inquiry as to who are responsible. There has to be an end to these games of yours. Please, no.
And it should take place, your Lordship.
Whatever. If it's a network failure, whoever is responsible for that should suffer. But there has to be a departmental inquiry as to why you. Network failure, give that report. I'll direct them to implement who is your service operator? The Union of India, the telecom authorities.
So for that,
Who provides the service of internet to you? You are a nationalized bank.
Yes.
So all of us know who provides. Let them be guilty. Let them be held responsible. Let them pay from the public money, and those officials will be responsible. Liability fixation has to be there. We cannot pass on the bucks like this. We have passed enough bucks after independence, no more.
What is your lordship? The account which has been insufficient balance, that person is not liable.
What is his fault? What is his fault? He has not got an extra payment. He owed that money. He got that. He has an account with you. He encashed a check. You paid that amount. What is his fault? The amount he owed the amount. They were entitled to the amount. They got their entitlement only. The bank is not doing a favor. They are keeping their accounts with the bank. You are encashing a check. So if they have no fault, you cannot charge them.
But your lordship, the account was insufficient.
It's not an overpayment. Suppose I have an account, interest accrues in my account, and you are to pay me, suppose 10 lakh rupees by way of interest. You are the bank. You, instead of paying 10%, 10 lakh, you pay me 20 lakh. That's a mistake. That's an overpayment. This is not an overpayment. This was a due payment. They encashed a check, and in that exact amount was paid to them. There is no overpayment. So it's not their fault. If it was your mistake, if they had something to do, otherwise it would be undue enrichment on their part. 10 lakh, 10 lakh has accrued to me, I get 20 lakh. That is overpayment, undue enrichment. Here there is no undue enrichment. No.
Why considering the due, lordship? Regarding, this is not the overpayment, your lordship. This is the payment which relates to that person.
Yes.
But the account was not set one. Account is so little. Someone.
What was your role? You encashed the check only.
And but
Why did you pay central bank at all?
Network failure and technically, lordship account was.
What happened due to the network failure exactly? What happened? System failed. So then what got stuck?
Amount was credited. And
System failed, and at the same time the account was being credited physically.
not only these two checks, your lordship, on that day, 47 checks.
If I may, lordship, in this
Give me a list, Mr. Shah. All those persons have to be compensated.
If I may, lordship, in this situation, what happens in a system failure? If there is
Yes, what exactly happens? I want to know that.
what happens in a system failure, lordship? What happens when a check comes? The copy is being sent to the other bank so that the matter it may be cleared or uncleared.
Right.
Now, in a system failure, when we are looking at the system that there is a sufficient balance or not in that particular position, the system is showing that the balance is there, and we clear the check. It is all automatic.
So what happened in this case?
Subsequently? This is what has happened in this case.
In this case,
due
Mr.
to
Shah,
natural calamity.
you instructed them to honor the check.
Yes, I did. No, I instructed them to honor the check only in respect, and thereafter when the check, when I found out that there was a system failure, I intimated that the check has been dishonored. Both.
So how did the system failure affect your intimation to them that please honor the check? How did the system failure affect that?
In the system failure itself, lordship, what happened was, it shows that there is a available balance of that amount. That is the system failure. It is an automatic process. It is not.
No, system failure is always an
automatic process.
Yes.
That is the whole.
Very well, Mr. Shah. I
And
get
as
that.
far as the first read is concerned, lien may be.
You are satisfied when you are satisfied and when you communicate to them that please honor the check.
Lordship.
At that point of time, there was no system failure. There was no system failure. How could you communicate interbank?
Lordship,
Because
they
the
have,
system-
the
same
ICICI
system.
bank has communicated with the central bank that the certain checks has been deposited and we have to.
Whether we should honor those.
Whether we should honor it or not.
Basically.
Now, as far as that point of time, the system failure was there, we saw that there is
System failure was not there at that time.
at that point of it was there. At that point of time, only on that point.
How did they communicate to you then?
That is what system failure does not
They
mean. that
communicated over the
system is
phone by
crashed.
letter.
No, system failure does not mean the system has crashed. It is showing error. The normal emails are coming.
What was the inquiry undertaken by you on this? If several persons were affected, system failure could be at your end.
But that,
So you could be at fault.
yes, as far as the other checks are concerned, in respect of that failure, they were all refunded by the.
You don't have a program analyst of sorts.
Yes, I do.
So they must be at fault then.
But that is due to
Could be your
natural
system
calamity.
failure.
That is why I filed a suit to recover that money
From whom?
from the
Why should they
petitioner for because it is their
System
check.
has failed, they will pay.
It is that is to be decided by the competent court.
Anyway,
I am
you have filed
admitting-
your affidavits, Mr. Shah. I'll
Not
close
sure.
our meeting.
I have already submitted that as far as their lien is concerned, since the account has been closed, your lordship, if the honorable court removes the lien from the
These are the replies to
retrospective
the.
effect, it will-
Three affidavits filed in item 12, one by the respondent number 2,
একটু আলাদা আলাদা করে
one
দিতে
by
হবে
the respondent
12
number 3, one by the respondent number 4.
12 আর 11 টা আলাদা আলাদা আগে 12 টা দিন আমার
My lord, in item 12 on behalf
please
of
give me
respondent-
half a minute. I'll take all of you. Let me sort out the papers between 11 and 12.
Just in such.
No, I'll hear you. Yes, let me sort out the papers first.
In item number 12, your lordship, may I file my
12.
wakalatnama and competency? No, it's not.
Wakalatnama, no, file it in the report.
Department is not accepting, since it was at that point of time notarized documents were being accepted, it was done notarized, your lordship. However, the department presently.
It will be accepted. It will be
Not
accepted.
accepted.
The department cannot accept, we cannot accept. Sorry. You cannot validate something which is beyond no.
Because that point of time, in January, it was notarized, your lordship, then not.
We'll lose it and say you have not filed it. So your appearance will also go. Waited to file in the department. If the department does not accept, nothing that the department does not accept will be accepted in court. I'm telling you.
So that the department makes.
Why should I give that leave if it is not technically correct?
Since it is notarized, at that point of time, then it was.
Do whatever has to be done and file it in department.
Since it is notarized document, that's why the document is, the department is not accepting. However, when it was notarized, your lordship, at that point of time, all notarized documents were being accepted. But
When it was notarized is not the relevant time. When you are filing is the relevant time. Now you are filing. What is the notarized documents are not taken now?
in January 23.
No, no. Whatever has to be done, do that and file the wakalat now. Can it be done during the course of the day? Mr. Gupta knows very well what has to be done. So his clerk will do it. Just pay him.
Who has signed the document is 80 years around old, your lordship person. Now it has.
There's a last thing to fall back upon.
No, your lordship, I have affirmed again to call him in.
ফরম্যাট নিশ্চয়ই কিছু গন্ডগোল আছে নোটারি না করতে হয় তো কি করতে হয় কি ম্যাজিস্ট্রেটের কাছে কাজ করবে নাকি send to the department. Whatever has to be done by the department. Department is supreme in accepting wakalatnamas.
On behalf of respondent number 2, this is the affidavit in opposition in item number 12.
আচ্ছা এগুলো sort out করো. Please file whatever you have to file. I'll take it on record and I'll come back in 10 minutes and decide the matter after a cup of coffee. Yes, Ms. Oja, please finish first. Mr. Gupta, take your seat. I'll hear one way. Please complete your arguments. I'll hear.
Yes, Your Lordship. The subject matter, which are the two checks, Your Lordship, those checks, my case is that on an understanding that those checks would be presented by the respondent, that is the petitioner in the item number 12 on a subsequent date. That was an understanding. I am not harping on that. However, those were presented prior to such date on 28 January 2019, Your Lordship. Sorry, 28 January 2020, Your Lordship. It was presented. On that particular day, there was no sufficient balance in my account, and that's why the checks, both the checks were dishonored, Your Lordship. Dishonored, the check dishonor charges were being deducted, which I can show from the account. Subsequently, after passing more than a month, in March 2020, I received a message from the Central Bank of India that my account has been marked as a lien, Your Lordship. Now, upon inquiry, then I immediately wrote a letter wherefrom they revealed, I'll show the document, Your Lordship, that due to system failure, the checks were honored and the amount were being transferred in favor of the beneficiary of the check, and accordingly you are liable to pay the amount. This is the defense of the Central Bank of India, Your Lordship. Your Lordship, kindly imagine a situation. What would have been if there is no sufficient balance? My checks were dishonored. At the best, I can be made liable by the beneficiary of the check under 138 or any other proceeding, which according to law, which they may choose. However, the bank cannot act as a recovery agent for the beneficiary.
So, yeah, admittedly, your account did not have that kind of money at that.
Yes, Your Lordship. There was no sufficient balance. That is admitted.
That be so, how can we avoid your liability?
Your
And
Lordship,
there may be fault on the part of the bank. Nobody doubts that. Because they shouldn't have, in the first place, they shouldn't have credited it.
Your Lordship,
Even then,
whether-
suppose a mistake has been committed.
Your Lordship, whether at all those checks, what is the, there is no adjudication of any amount by any court that I am liable to pay certain amount to Messrs. Tracker, Your
What
Lordship.
is the pending civil suit for?
That bank has filed against me for recovery
money.
of those amount. 15 lakh has already deducted, Your Lordship. Out of those checks were, one was of 15 lakh and another was of 40 lakhs. So subsequently, when the 15 lakh amount was came in my account, they automatically, without any intimation,
At the
deducted.
relevant point of time, when they when they honored the checks, basically,
Hmm.
at that point of time, if you did not have that money in your account,
Yes,
that can very well be proved whether you had that amount of money. If you did not have that amount of money, that money was never yours, but it was honored
Yes.
from public money, basically.
Yes, yes.
So if that be so, how do you avoid your liability to reimburse that amount? That amount was not yours. It was not there in your account at the relevant point of time at all.
Yes, Your Lordship. This I issued a check, Your Lordship. Now,
Issued a check.
yes,
But at the relevant point when it was dishonored or honored, whatever,
it
it
may
was
have.
not there in the account. The money was not there. You issued the check, but the money was not there to support it.
Checks were to be presented on a subsequent date. That is my case, Your Lordship.
Oh, it was
Not-
present on the same date.
No, these checks were issued on a particular date, that with an understanding that after certain months, those checks were being presented. However,
What was the date given on that check?
there was no date. It was filled up.
Dated.
Yes, undated check. It was filled up by the beneficiary and was presented on 28 January. Your
That
Lordship.
was your issue, actually.
Yes, Your Lordship. This is
Between
my-
yourselves, yes.
Yes, so that's why I am not harping
How
on
is the bank liable?
because when there was no sufficient balance, how could they honor the check?
Suppose
Because-
they committed
no,
a mistake.
No,
System error.
I was not liable to pay those amount, even if I am liable to pay any amount to Messrs. Traco. That is not on 28 January. That may be that I was liable to pay those amount in March 2020, Your Lordship, and that my liability could have arisen that I should have maintained the balance on that date. However, I was not liable to pay those amount in January. So there was no sufficient balance.
When
was
did
not
it
my
happen, you
fault.
said? What is the cause of action? What is the time of the cause of
28 January 2020, Your Lordship.
2020?
Yes, Your Lordship.
And they claimed they debited the amount from your account when?
I am even not aware because on 28 January the checks were dishonored, dishonored charges were being deducted, and in March 2020 I was informed that Your Lordship kindly consider the
Dishonor charges were deducted means there was a dishonor.
Yes,
But
that's an
the mistake
adjudication.
was on the bank's part for whatever reason.
Yes, Your
Let us,
Lordship.
for the time being, keep that aside. The bank by mistake had paid that amount.
Yes,
and honored your check, basically.
Yes, your
So
lordship.
your check was honored from money which was not yours.
Yes, your lordship.
So are you not liable to put back that amount in the bank?
Probably, your lordship, the bank were on that
It
particular
was
day.
an overpayment.
On that particular day, I was not liable to pay. That's why there was no sufficient balance. I may have been liable on a future date, but not on 28 January 2020. Your lordship.
Dishonor charge was deducted from your account.
Yes, your
You
lordship.
you never challenged that.
No, because I was aware that there is no sufficient balance. That's why the checks were being
It was
disbursed.
no sufficient money. Where did the money come from? Thin air. Had to come from public money. So you have to reimburse that. It was never your money at all.
No, but I am not liable to pay. I did not want those amounts to be paid on that particular day. That's why the
That's when
amount
you knew
was that day.
your intention is with you. I mean,
But
that kind of nobody else can be liable for that.
Your lordship, kindly understand the glitches or the error on the part of the bank. They deducted the dishonor charges, your lordship. Now, thereafter, certain money came in my account. The bank, without even any intimation that the checks were being wrongly credited or whatever was done, they deducted the amount of rupees 15 lakh, did not intimate me, and thereafter marked a lien for remaining 40 lakhs, your lordship. Now, there is the glitches or error or false or deliberate error on the part of the bank.
You
And
file a counterclaim in their suit for that amount of money.
that I will take steps in the suit. But however, your lordship, with the error which
This claim is related with their claim.
Your
Because they are claiming this money in lieu of their wrong payment.
my claim is first, your lordship. The bank cannot justify their error by filing a suit. If suppose, your lordship,
Counterclaim can be filed even then if your cause of action is
Then
first.
I
It has to be before that date of defense.
your lordship, kindly consider a situation that it is the case that I owe certain amount from it is their case. However, kindly consider a situation, your lordship, that I made a I gave a post-dated checks to a
You did not do that. That is a difficulty, ma'am. If you give a post-dated check, it was honored prior to that. It's a gross error. But it was undated. They put a date and encashed it.
checks, your lordship. Kindly consider a situation like I have given an undated check to a proposed.
You are not a naive rural person. You are a company.
Yes,
So even we, when we give post-dated check, we put the dates on the checks for whatever purpose. If you did not do that, the intention was very clear. You might have given it otherwise, made it out otherwise. That no, you can encash it whenever you like.
It may be otherwise that the
Maybe may not be.
it was
But for that, the bank cannot be liable. That is public money. They are right on that. How do you overcome that?
But your lordship, when there is apparently I cannot be, bank cannot act as the agent of the what would have been the situation, lordship? At the best, a proceeding under section 138.
What is your defense against that liability? That overpayment made, although your check was dishonored, that payment was made on your behalf to them, to Mr. Gupta's client.
That was not supposed to be made on that particular day.
That was not supposed to, but was made.
That was not. This was the error of the bank. That was not to be made on.
So you cannot take undue advantage of that error.
No, I am.
That money was never yours.
I am not taking your lordship. If there is any amount which the beneficiary claims that I owe, that has to be adjudicated, your lordship. But the bank cannot act as a court. Or
I am
a judge of
asking, what
agent,
is your
your lordship.
defense against that? Apart from their error regarding the liability, what is your defense? Your account was lying without that amount. They overpaid on your account, on your behalf. So what is your defense against that liability to reimburse the bank for their mistake undoubtedly?
Is that, your lordship, I have no liability.
Why?
Whatever, if there is any liability, that has to be adjudicated. So on very particular day, I was not supposed to make any payment to the beneficiary of the check. The check was supposed to
Anyway, the
be
method in which they
deposited.
did it was illegal.
Yes. Now I will show certain documents. One more point which has been taken, your lordship, that in spite of my knowledge that the account has been closed, I made prayer to remove the lien, your lordship. However, this is incorrect, your lordship, because had this lien not been imposed on my account, the account note has been gone to the negative balance, and question of this closure of my account also does not arise. Moreover, no information was given, your lordship. I will show the documents what they are claiming that information was given. There is no postal receipt at all that it has been ever been served. Moreover, during that period, lots of correspondence were being exchanged between the bank and the petitioner, your lordship, through their advocates even, your lordship. Those correspondence of the same day, not even ever a single sentence that your account has been closed. All along, they have stated that yes, there is an error on the part of the bank. However, you are liable to make payment. because there is error on my part, on part of the bank. Kindly,
When was the lien imposed?
that even I don't know, sometime in March, probably 13th March 2020, Your Lordship. Kindly, Your Lordship, kindly.
2020. Why did you prefer the challenge in 22?
Your Lordship, because during that period, due to Corona, several correspondences were being exchanged. Thereafter, Your Lordship, proceeding before banking ombudsman was also filed. However, the
Corona came as a savior to many people.
No, Your Lordship, in that very particular period, during from March, Your Lordship, this all entire thing started. And there are several correspondence that I can show, Your Lordship. Thereafter, we approached before the banking ombudsman. However, banking ombudsman dropped the proceeding on the ground that a civil suit is filed, Your
You
Lordship.
said lien could not be imposed like this.
Your Lordship, kindly, I'll just show 2 letters, Your Lordship, from
They pay for an attachment or anything of that sort from the court? No.
No.
How is that lien relevant even now after closure of your account?
That I was not even aware, Your Lordship. That's why in my
So
supplement.
now you are aware. Did you challenge that before any forum?
No, Your Lordship. I used a supplementary affidavit in this writ petition, Your Lordship, claiming to reimburse my 15 lakh, which has been wrongly deducted from my account, Your
15
Lordship.
lakh is one aspect of the matter. Regarding the lien, how is it relevant now? After closure of your account, the lien
Lordship,
does not operate at all.
Your Lordship, in the event, if due to their mistake, my account went to negative balance, which led to closure of the account, Your Lordship. So I cannot, had not this situation happened at that point of time, my account, there was no reason to close my account, Your Lordship.
Very well.
May I just show certain documents, Your Lordship? Kindly take up page number 13 of my writ petition, Your Lordship.
13, yes.
That is an extra P1, Your Lordship.
Right.
The third last, Your Lordship, there are 2 entries of 28 January.
Yes.
If I, from the bottom, it's first, second, third, fourth, and fifth.
The last 4, all the last 4.
Yes, Your Lordship, check dishonor charges
Mhm.
were being deducted on 28
Then 4.
January.
28th January, you are saying?
Yes, Your Lordship, there are 2 checks of 28 January.
Acha, check, yes.
Check
Check
dishonor
dishonor,
charges
check dishonor, right.
786, as well 2062 amount that has been deducted. Those particular checks were dishonored, Your Lordship. Thereafter, Your Lordship, I wrote a letter which is at page number 16. I'm not going, I just made inquiry. Which are the relevant portion, the relevant letters that I'm placing, Your Lordship. Kindly come to page number 16 and Excel P4, Your Lordship.
Mhm.
The letter issued by Central Bank of India. I'm just reading second paragraph, Your Lordship. On the date, that is 28 January 2020, of presentation of said checks, there were insufficient funds in your account for honoring the checks. Since there was no sufficient amount in your account to honor the checks, our bank uploaded the message of returning the checks in system portal, but due to system failure, the same was not delivered to the nodal agency for interbank settlement. Hence, could not be debited from the account of the beneficiary with the ICICI Bank. Thereafter, the said checks were returned to ICICI Bank over the counter on such and such date. Thereafter, I'm reading the next one paragraph, last paragraph, Your Lordship. Our bank lodged a claim with ICICI Bank for the said amount, but ICICI Bank has not yet returned the same till date. Since the checks were issued by you and the amount was credited by the system to the account of the beneficiary, the said amount is recoverable from your account. For this, you are liable to pay the said amounts to our bank. Therefore, you are requested to please make good of the said amount so debited from our account. However, if the said amount is remitted such and such. Now, Your Lordship, thereafter the amount was 15 lakh. When it came to my account, it was also deducted, Your Lordship. That they have not disclosed here. However, subsequently it has been disclosed, Your Lordship. Your Lordship, kindly consider a situation. If I issued any check to a vendor, that on supply of certain goods, the check were presented by. Had not this, if they fail to supply the goods, whether I am liable to pay. And on that account, can the bank take advantage that I have of their failure, that I have made a payment on your behalf, so you pay me those amount? I'm not yet liable to pay. The day has not yet arisen. The condition has yet not been fulfilled. So I'm not liable to pay as on date. So I have not kept the amount, sufficient amount on that particular
logic
day.
probably is not valid. The moment you hand over a check, you undertake the responsibility to pay the amount whenever presented as per the date. If you don't put a date on that, then it's the prerogative of the person who is receiving it to put a date. or anybody and everybody can put a
Yes,
date.
Your Lordship, that may be prerogative, but
So it will be deemed that you have put that date.
Your Lordship, but the bank cannot, bank has to act only whatever is appearing. If there is sufficient balance, they will honor, otherwise refuse, and the beneficiary
True.
is entitled to take whatever steps is entitled as per the law. But the bank cannot act as a recovery agent for the beneficiary or cannot justify their fault by taking all these pleas, Your Lordship. Now, Your Lordship, kindly come
So
to.
how should they recover the money according to you? If suppose they committed a mistake, the bank, central bank, they overpaid.
The bank is liable to pay. Bank is liable to refund because it is their mistake. It is not my mistake. If I am at all,
Although there was no money in your account at the relevant juncture,
not that much balance, 15 lakhs and 40 lakhs.
what should be midway between?
Your Lordship,
So the
there is-
entire amount was not there in your account, ma'am.
Your Lordship.
The bank paid that by mistake.
But
Although it was reflected in your statement of account that it was dishonored.
yes, Lordship.
There is no doubt on this.
Yes, Your
So on the relevant date, it was reflected.
Yes.
So check was dishonored. There is no doubt on that. Yet that amount was paid.
The bank will recover from them. If it is their mistake, they will recover from them. It is not my mistake.
Very well, very well,
Whenever I am liable to pay, I will pay.
very well.
Now, Your Lordship, there are several correspondences. I am not reading each and every one. I will just show one document where from it will be evident that they have deducted rupees 15 lakhs, Your Lordship. And also, they are in their affidavit in opposition, they have used a letter showing that we issued intimation regarding closure of the
15
account.
lakh was debited
Has already been debited.
before filing the suit.
Yes, before this filing of this.
Before filing the suit by them. By the
Yes,
bank.
Your Lordship. They have filed the suit probably for recovery of 40 lakhs.
Acha. So 15 lakh debited.
Has already been debited, Your Lordship.
So you have not challenged that before any forum.
No, because my writ petition was pending. I have yet not.
So 15 lakh was debited. You have not challenged that anywhere.
No, Your Lordship. The writ petition after deduction of this 15 lakhs, I have filed this writ petition
In the
itself.
writ petition, you have challenged that 15
Yes,
lakh
yes,
deduction.
yes, Your Lordship. That I have also mentioned that 15 lakh has been debited.
There is no such claim in the writ.
In my
To the fair part,
In my supplementary affidavit, Your Lordship, if I may.
subsequently of my submitting that the
My
account has been
supplement-
closed, they have filed a supplementary.
Yes, Your
affidavit.
Lordship, I will show that I had no knowledge of closure of the account, Your Lordship.
There is no claim at that point of time.
If I have no knowledge that my account has been
Start it.
closed, Your Lordship.
Please
how can-
continue. Please continue.
May I show the document which where they have relied upon giving intimation, allegedly giving intimation me regarding closure of the account. Kindly take up page 16 of their affidavit in opposition, Your Lordship.
Page.
Page 16 of their affidavit in opposition.
Yes.
This is the alleged letter by which they have given intimation, Your Lordship. That is date 9/12/2021, Your Lordship. However, they have not annexed any document to show that this letter was actually delivered, Your Lordship, to the petitioner. So I had no knowledge that my account has been closed. That's why the prayer for removal of lien was made. Subsequently, after filing of this affidavit in opposition, I came to learn about closure of my account and I used a supplementary affidavit, Your Lordship. However, Your Lordship would note the date 9/12/2021 is the date of the alleged intimation. On that very particular day, letters were also being issued by the bank through their advocate, Your Lordship, in correspondences. However, those letters not even make a single sentence averment that your account has been closed. I will place that letter, Your Lordship. Kindly take their affidavit in opposition itself, Your Lordship, at page number 96. I have also annexed these document in my petition, Your Lordship. Page number 96, Your Lordship, that is annexed. The date of the letter is same, Your Lordship, 9 December 2021.
Yes.
This is issued to the petitioner against a previous letter, Your Lordship. This letter, the entire letter, does not disclose, it does not mention a single statement that the account has been closed. I had no occasion to know, Your Lordship, what is the only concluding paragraph that you pay off the amount of rupees 55 lakhs together with interest. The entire letter does not disclose a single sentence that the loan account has been closed. When the correspondence are being made, they have annexed a letter which does not give any postal receipt or any document to show that it was actually delivered to me. Moreover, before deduction of rupees 15 lakhs, no intimation was ever given to me that 15 lakhs has been deducted, Your Lordship. That is why, Your Lordship, I have used a supplementary affidavit, Your Lordship, where in my supplementary affidavit, I have annexed my statement of account, which shows 15 lakhs has been deducted. Even it's an admitted position. There is no dispute regarding that, Your Lordship. And I have also prayed for refund of my amount in my supplementary affidavit because I had no knowledge, so I could not make those prayer in my writ petition, Your Lordship. And no intimation was given. And kindly consider a situation, Lordship, had this situation not happened, had not then they marked my account, wrongly deducted the
In your supplementary affidavit, you have stated something about 22,64,000. What is that? Page 4 of the
further deducted, Your Lordship.
right.
15 lakh and thereafter certain other amount.
764.
So 22 lakh altogether. Yes, 7,64,000. So 22 lakh altogether has been deducted, Your Lordship.
You have said nothing regarding how you came to know this 7,64,000 when it was deducted. Nothing.
Your Lordship, from my statement of account, I after receive of this opposition, I applied for a statement of account, Your Lordship, from the bank. Therefrom, I came to law.
Give me the page number.
Yes, Your Lordship. The statement of account starts from page number 7, Your Lordship, and this. There are so many entries.
Where do I find that the account was closed as per this statement?
That even that statement also does not say so. I could not find, at least. I was also looking for that where the account has been, it will be
According to them, when was the account closed?
That may I just indicate.
You just indicate that.
Opposition, yes.
In the statement of account.
Pardon?
In that page only, page 18. The
Page
last,
18.
Date.
Yes.
The third check withdrawal, that is the balance amount was transferred into a draft and kept with the bank so that they will take it back. And I have
not say
been given. I can show by the document.
That does not say that the account has been closed, Your Lordship.
Anyway, I get it.
I'll show. I'll satisfy the court.
Very good.
It does not reflect at all, Your Lordship. Had this, they are using a particular guideline of RBI that it has my account went to a negative balance. That's why it was closed, Your Lordship. However, Lordship, this.
So you are challenging the closure of the account. One. Second, all the deductions 15 and plus 764.
Yes, Your Lordship.
These two you are challenging.
Yes, Your Lordship.
What else? Nothing else can be challenged here because they have filed a suit for
Yes,
40.
Your Lordship. These two. Your Lordship, had this mistake not been committed by the bank, by honoring those checks and transfer marking lien to my account, the situation of going my account into a negative balance would not have arisen, and they would not have any reason to close my account, that too without giving me any intimation, a unilateral intimation that I am closing the account, and even that has not reached to me, Your Lordship. They are also using they have also stated in their opposition that they used a mail, Your Lordship. However, whether that particular mail was delivered or not, that also cannot be shown, Your Lordship. So no intimation, Your Lordship, was given to me prior to either deduction of the amount or closure of my current account, Your Lordship. So there is palpable fault on the part of the bank, which is evident. I have not placed the entire correspondence, but each and every correspondence used by the bank said that there was a system failure, and due to error on the part of the bank, those two checks were honored, though initially it was dishonored and there was no sufficient balance. That's all. This is my.
The lien is of 40 lakh.
Yes, Your Lordship. Initially it was 40 lakhs, Your Lordship.
Initially. If I may.
Initially means?
After deduction of 15 lakh, they marked the lien of 40 lakhs. Thereafter, the 7 lakhs was deducted subsequently.
In the writ petition, you are challenging that lien also.
Yes,
The closure as well.
Yes,
if the closure is reopened, if you win on the closure, then the lien reopens. That's why your challenge is valid.
Yes,
and rupees 15 lakh plus 764 that you have subsequently challenged.
Yes, Your Lordship. 764 was subsequently deducted.
Right,
Yes, Your
right.
Lordship.
Would your lordship permit me to make the submission because I have really minimum
No.
submission because the banks can thereafter reply
No.
taking into account both.
Whatever. I can hear out 11 first also.
That would be better.
I think that will be better. Otherwise, things will be confusing. Liabilities are different here.
That is right. Liabilities
So
are-
let us hear Mr. Shah on 11. Then I'll hear you and your learned friend for 12. Yes, Mr. Shah.
Lordship, as far as item number 11 is concerned, in this writ petition, there are threefold submission. First submission that they do not have any intimation as far as the closure of the account. Lordship would kindly come to page number 18 of my affidavit in opposition. They have shown a page number 16 that is a document dated 9th December 2021. However, I am not stating that the account was closed on that day. On that day, debit freezing was done. It is a systematic steps to closure of the account. The account was intimated on 19th February 2022, and that was given to their registered email ID. Kindly see page number 18.
It's a nationalized bank.
It's a nationalized bank.
Then orange. Yes.
I can reply to that, Lordship.
Yes. No, Mr. Shah, where is this proof of receipt of this or sending this? There is nothing on record.
This is an email sent that is already there to their,
Yes, this is the email.
to their registered email address. That is there. That is why I'm submitting that this has been sent. This has been received. Moreover, all the submissions relating to different aspects of not being informed, Lordship could kindly come to their document. On
Yes.
17/3/2020, the account was put on lien. In June 22, they come up before this honorable court.
Please give the dates again. Once.
Lordship, 17 March 2020. That
Yes.
is in their writ petition.
Date of closure.
Lordship, the date of lien.
Lien. I'm sorry.
Lien.
Yes.
That has been intimated to them. That is page number 16 of their writ petition. Annexure P4, which my learned friend has relied upon. Now, subsequently, several communication has been done. That is an admitted fact. On 19th February 2022, an email was sent to them intimating the closure of the account.
When did the closure take place? 18th of?
19th of February. That's from
The closure took place on that page 18.
Page 18.
What is the date? Just give me.
19th February 2022.
Oh, that was itself the date.
Yes, Lordship.
Very good. Yes. The same date you gave an email.
Yes, on same day. At even the date is stamped there, 1721.
So seen that, yes.
Thereafter, Lordship, in June, they come up before this honorable court praying for removal of lien on that account. Actually, what happened, Lordship, since we filed a suit before the learned, which is pending before the learned 7th bench city civil court, that is title suit number 2 of 21. That is also given in page number. I've stated that in page.
Have you got the filing date of the suit?
No, not filing date of the suit. I'm giving the number of the suit.
Have you got the filing date?
Lordship.
Well, number, give the number.
It's page number 9. It's money suit 2 of 2022. Since the money suit 2, it must be in the first month of 22. No, sorry, the date is there, Lordship. 23 March 2022. 23 March 2022. I beg your pardon, Lordship.
Which court?
City Civil Court, 7th bench.
Ready.
Now, Lordship, what has happened since they received summon of that suit?
This was a 40 lakh.
This was a 40 lakh.
Please continue. Yes.
Since they received summon of that suit, only to counteract on that portion, in June 2022, they come up before this court in this petition. And what are the prayers? Kindly come to the prayer of the writ petition itself. Kindly come to the prayer itself.
Yes.
A rule will be issued calling upon respondent to show such and such nature of mandamus, commanding respondent number 1 bank to remove the lien and or hold mark on the current account of such and such. They have been intimated 2 years ago that the lien is there. For 2 years, they have no issues. Account was closed. That was communicated. Even then, they had no issues. When we filed a suit for recovery of money, suddenly they woke up and come up before this honorable court praying for removing of lien, not even praying for refund of money, because refund of money as per their own submission, the 15 lakh was taken long ago. That was in their knowledge. They have not prayed for refund of money. Subsequently, when I'm coming up stating all the facts, they come up with a supplementary affidavit stating kindly refund the money.
Mr. Shah, a basic premise.
Lordship.
At the relevant juncture, when they presented the check, you had intimated for whatever reason,
Lordship.
not your fault.
I bow down to that.
Civil. Subsequently, that payment was made by you. A
Lordship.
green signal was given by you. Now, subsequently, could you unilaterally debit that amount from their account? I mean, satisfy me on that.
Lordship, as far
What is
as
your take on
as
that?
far as my understanding is concerned, subject to correction.
Just
Lordship,
because you're a bank.
that since I am a bank, since I am a nationalized bank, since it's a public money, I can always put that money on hold. It is their presumption. They have submitted a check.
Hold
whether
is
or not-
regarding 40 lakh.
Yes, yes.
What about the 15 lakh you deducted?
15 lakh is also part of that check amount. Whatever I am holding is holding.
So then what? Why
So
should
even
you
if
file a suit at all for that 40 lakh?
for the because that amount is not in the account. I have to recover that from the petitioner. There is no other option for me. I have done whatever the legal way is there. I am admitting my mistake, but admission of mistake doesn't make it liable for me to pay the public money to the individuals. They have issued a check. I am admitting
Yes.
since the only there's a system problem that the check was encashed. Now the beneficiary is before your honor, the pay is before your honor, both the bank is before your honor. Now conscious justice can be done by the court itself. That's all my submission.
Your Lordship, only one single sentence, I would say. Nothing.
Finished, Mr. Shah.
Lordship.
Take your
Only
seat.
one sentence, Your Lordship. This is that only as a counter blast after receiving of summons, this petition is filed. That is wholly incorrect, Your Lordship. I was proceeding before Banking Ombudsman. I have also annexed the documents at page number 67, Your Lordship, where in April 2022, Your Lordship, Banking Ombudsman rejected my complaint on the ground that there is a suit pending. Till that time, there was no service of summons subject to correction, Your Lordship. So after rejection of
Did you first approach the ombudsman?
Your Lordship,
That lien?
my complaint was filed. I'll just put a date, Your Lordship. Just sometime in. I'll give a date. Kindly give me a moment, Your Lordship.
You can give me the year at least.
Yes, Your Lordship, I'll give the date. In March 2022, Your Lordship. Approached the Banking Ombudsman, Your Lordship. And thereafter in
Lien
April,
took place in 17th of March 2020.
Your Lordship, till then, till before filing of this complaint before Banking Ombudsman, continuous correspondence were being exchanged, Your Lordship. Even till December 2021, Your Lordship, which I showed to Your Lordship, December 9, 2021, the correspondence was being
Correspondence
exchanged.
regarding what? This amount.
This amount, particular disclosure, imposition of lien, Your Lordship. And by that time, I was not aware about the closure of the account. So no statement regarding closure of the account was made. That's why thereafter I first, because I have to approach any complaint regarding bank, I have to approach the Banking Ombudsman. I approached, they rejected my complaint on the ground of
Throughout the
penalty.
relevant period, you say you are corresponding?
It's a matter
Yes,
of
Your Lordship.
limitation.
No.
Yes, Your Lordship.
Throughout the period, you were corresponding?
Yes, I was.
They had refused clearly. They had already done it.
Yes,
The impugned act.
yes, Your Lordship. Till December, the last
Very good. Get your
the last correspondence which was made by on my part, Your Lordship, was 3rd January 2022. Thereafter, I approached before the Banking Ombudsman.
Anything else, Mr. Ojha?
No, Your Lordship, that's all.
Fine. Take your seat. Petitioner in 12.
Yes.
Yes.
Lord, with the leave of this court, my Lord, Mr. Gupta is leading me. Lord, may I assist your Lordship? Lord, the factual matrix is similar, but the placement of the petitioner in item number 12 is a bit different, my Lord. And I shall satisfy your Lordship.
There are 4 operators here.
Yes, my Lord.
4 people may be liable, may not be liable.
Yes.
Them, you, and the 2 banks,
Yes.
basically. The 2 banks.
Yes, that's the factual.
Very well. So, according to you, what is
Lord,
this?
according to the petitioner in 12, my Lord, the petitioner in 12.
Let
got
us name
two
the
checks.
petition in 12 so that it
Lord,
will be
that's
easier.
Traco Enterprise.
Traco. So,
Lord,
you are
according
Traco.
to, yes, according to Traco, my Lord, Traco was provided with 2 checks by Etibar, which is the petitioner 11. My Lord, the 2 checks for 15 and 40 lakhs was admittedly, as per the submissions of Mrs. Ojha also, the checks were given in lieu of a debt. And that check, the petitioner upon obtaining the check, had the authority to deposit or present the check for payment of its dues, my lord. My lord, under the Negotiable Instruments Act, my lord, the check itself is a document, is a contract of transfer of money, my lord. My lord, the petitioner, upon receiving the checks, put the same to its bank for honoring or dishonoring. At that moment, my lord, the petitioner could not have known whether there was funds in the account of the drawer of the check, or whether the payment would have in fact been made to the petitioner, my lord. My lord, upon presentation on the very same day, the amounts are credited to the petitioner's account. My lord, once the amounts of both the checks are credited to the petitioner's account, unless the petitioner is intimated on the very same day or in the subsequent dates in 1, 2, 3, 4, 5 days, my lord, the petitioner has reasons to believe that that amount has been received by the petitioner and can be appropriated by the petitioner, my lord. Lord, this is the exact case what is before your lordship, lord. The petitioner upon receipt had no intimation from its bank or central bank.
What have we challenged, by the way, here?
My lord, here we have challenged the unlawful marking of the lien on the petitioner's account by ICICI Bank, which ICICI Bank on its reply letters have confirmed have been an act done by ICICI Bank on request letters given by Central Bank of India. But ICICI Bank on all its letters.
This imposition of lien is on the entire amount of 55.
Yes, my lord. Initially, it was on the entire amount of 55. Thereafter, my lord, something transpired. 55 lakhs was told that there should be a lien of 55 lakhs. 9 lakhs and odd was in my account as on the date of such letter which was issued in March 2020. My lord, the dates are relevant because, my lord, the check was presented and credited on 28th of January 2020. My lord, the first intimation, admittedly, that we received from our banker, which is ICICI Bank, asking for refund was on 2nd of March 2020. My lord, all this while, there was a stoic silence with regards to any errors, anything that had happened in the last 2 months. My lord. On 2nd of March, surprisingly, we receive a letter saying that CBI, Central Bank of India, has communicated to ICICI Bank that this was on a basis of an error and the amount should not have been credited to my account and as such has to be refunded. They found an amount of 9 lakhs and odd in my account and for reasons best known to them, marked a lien to the tune of 55 lakhs, asked me to deposit a further sum of 46 lakhs to refund the entire amount to Central Bank of India. As my account had only 9 lakhs, the account was barred from any further debits from my end, my lord. My lord, thereafter, what had transpired?
9 was frozen.
9 was frozen, effectively. And I was further demanded. We are challenging that demand notice also, my lord, because there is some consequential effect of that demand notice staying against me, my lord. Because that demand notice suggested, as on date, 46 lakhs I had to deposit in the bank account so that the same money should have been deposited. My lord, immediately thereafter...
Was the 46 lakh demand notice issued to you?
My lord, 2nd March 2020, the same letter. The same letter. There was... okay, my lord, 12th March 2020.
Yes, because...
12th March, I stand corrected. 12th March 2020.
The previous letter asked for 55.
No, the previous...
2nd March asked for 55.
2nd March was a mail, my lord, wherein they state that Central Bank of India, these funds need to be returned to Central Bank of India.
There the amount was mentioned 55.
No. Here the checks were annexed, the 2 checks on the basis of which I got the credit, which is 55 lakhs. The email had an attachment. My lord, that is at page 22, if your lordship wants.
So the refund refers to 55?
Yes, it was.
Both checks?
Both checks.
Very good.
My lord, thereafter, series of correspondences. Upon receiving such letter, we put our stand before the ICICI Bank that there was a due against which the payment was made and the check had been honored as far as we are concerned because the amount was reflected in our account. My lord, after the correspondences as the lien remained to be marked in a commercial account of a partnership firm, my lord, we had approached the Ombudsman of the Reserve Bank of India. My lord, that approach that we made was on 1st of July 2020 by our letter. Lord, ICICI Bank had to reply to the Reserve Bank of India Ombudsman. The proceedings began and the proceedings culminated into an order whereby the Reserve Bank of India said that as per the powers of the Ombudsman, this is one of the issues which the Reserve Bank of India cannot adjudicate upon. And as such, the complaint was closed. Lord, so there was no order on merit so far as the actions of the marking.
Was it closed?
Lord, it was closed.
Approximate?
In 2020 itself, my lord.
2025, yes. Let us carry on.
Yes, my lord, I shall give you the date. My lord, thereafter, we write through our advocate again intimating to ICICI Bank, stating that kindly take steps to remove the lien. My lord, it was closed on 16th October 2020. My lord, still the lien had been marked. No actions from the ICICI Bank, hence the writ petition, my lord. My lord, now in the writ petition, what we allege, my lord, one is the wrongful actions on the part of both the banks, because we have made both the banks a party, my lord, because we, as a private party depositing a check, could not have understood what has transpired between the two banks. My lord, as far as we are concerned, all our correspondences were linked to ICICI Bank, which is our
You are
bank.
caught
sir.
in the crossfire.
We have been caught in the crossfire, my lord. My lord, now in that situation, once the writ petition was filed, the same stand by ICICI Bank that on the letters based on Central Bank of India. My lord, now the question before your lordship is that one, when a person having a check presents the same, my lord, what is the domain that person is standing at, my lord? What is his responsibility? My lord, before a writ court, I have to suggest or show that the petitioner before your lordship had done due diligence of whatever the petitioner had to do, my lord. My lord, that is the first factor when I go and present the check. And the check gets credited. Now the question of demanding a refund of that amount from me on the basis of an error that had transpired either in Central Bank's part or ICICI Bank's part. My lord, later on, I shall endeavor to show to your lordship, my lord, that through the affidavits, it has actually transpired that Central Bank of India had the error at that account, at their end, my lord, which was told to ICICI Bank on the very same day. On the very same day, Central Bank of India has correspondences between the ICICI Bank, where Central Bank of India tells ICICI Bank to hold the funds in lieu of the errors. My lord, now for reasons best known to ICICI Bank, neither the funds are held on that day, the amount is transmitted to my account, transferred to my account, and only after 2 months am I being communicated that you have utilized the funds which should not have been utilized by you, as the same was credited when there was no balance in the account of the payer. My lord, such is the situation, my lord. Now what has transpired after that, my lord? As your lordship is already aware that 9 lakhs was marked and there was a lien to a subsidy.
Give me the date when the communication was made by CBI to ICICI.
My lord, that is in the CBI's affidavit, my lord.
There is a version of the CBI.
Yes, my lord.
They've annexed something to
Yes,
the
they have.
Same day means same day as what?
My lord, in paragraph 8, in their opposition, my lord, may I just read for your lordship's convenience? My lord, Central Bank of India states that the incidence of counter return of checks was communicated to ICICI Bank on 28 January 2020 by several mails from SSB Chennai at 2:43 p.m., 3:26 p.m., 3:55 p.m., 4:12 p.m.
This page 8 of their opposition.
Para 8 at page 4 of their opposition to our writ. The images of counter return checks were handed over to the representative of ICICI Bank in the evening session on the same day. The respondent number 3, Central Bank of India, specially requested to the officials of ICICI Bank to hold fund against the counter checks as per the prevailing interbank clearing practice, but the ICICI Bank, the respondent number 2, did not hold the center.
You cannot get the time when it was given to you.
No, my lord, that
probably the
is-
accounts won't reflect.
My lord, we have annexed the account. It's the first
Statement of account won't reflect that.
My lord, it's at page 21. My lord, that does not have the time.
Time probably is not reflected
That
in the
does not
statement
have
of
the
account.
time. Lord.
Very
That does not.
Very good.
My lord, now what transpires, the 9 lakhs remained marked. Thereafter, my lord, we were intimated by ICICI Bank that stating that CBI has taken recovery proceedings against the drawer of the check and has obtained a refund of 15 lakhs. So, my lord, subsequently, on the basis of so on the basis of that 15 lakhs, the lien mark was reduced. Lord, such is the situation that 2 proceedings have been initiated by 2 banks from 2 persons. And as per their convenience, the moment amount is refunded from one of them, the other person is told that this has been received by the bank. Lord, that 15 lakhs, the moment they receive, they happily reduce the marked amount of lien to 40 lakhs.
You couldn't have done it.
My lord, if at all, my lord, this could not be running hot and cold, that we are asking for recovery from both the parties who are involved in the transaction for an error committed on the part of the bank, my lord. And thereafter, subsequently, whoever pays me, I let the other person go.
So the whims are being reflected.
Yes, my lord, that is, my lord,
according to you.
it could have been one stand, my lord, if at all. If there is an error, there is an error. That is before your lordship. They have put it on affidavit. Now, my lord, that error cannot be linked to me as such, because I am the
Then
beneficiary.
every time there will be a flux there.
My
And
lord,
then it lose the suit again, it will go up.
that's exactly because we will have to wait till the time they can recover. If they can't recover, then our cause of action
Get the
will
logic.
begin. My lord,
I
that
get the
is-
logic. Yes,
My
yes.
lord, now coming to the second part, the moment 15 lakhs is refunded back from the Etibar to the bank, they reduce it to 40 lakhs. It stands at 40 lakhs. Now what has happened is money came into my account. A sum of rupees 3 crore and odd came into my account after filing of the writ petition. The writ petition was taken up for hearing
From a
on
different source.
from a different source because my account was working. The amount had been credited to my account. My lord, it is important to note that the writ petition had been filed by that time. The writ petition had came up for hearing before Justice Bhattacharya, my lord, Moshpi Bhattacharya. Affidavit directions had been passed. My lord, no interim order had been passed. Rightly so, my lord, because we had approached the court after 1.5 years, my lord. So there was no scope of passing any interim order in our favor, my lord. But thereafter, pending the writ, the moment the amount gets credited to my account, the tune of 40 lakhs is unilaterally taken out of my account. But so as such, as on date, if I may, I am nobody to advise Ms. Oja, but the point is that 40 lakhs has now been taken from my account. So 55 lakhs in toto has been received by the bankers, one way or the other. Because today I'm out of 40 lakhs. And 15 lakhs had been taken from their account. But that is the conduct. And as Milord, it had transpired only after filing of the writ petition. Milord, we have got this on record in our reply affidavits, which we have filed to the oppositions, Milord. Milord, those subsequent facts could not have been, of course, placed in the writ petition.
Subsequent means this 40 lakh.
This 40 lakhs. This taking out from my account. Only the lien was marked, no amount had been taken out from my account. And the moment they saw a figure of 40 lakhs available, that 40 lakhs has been taken out without notice. Milord, now, as on date, the petitioner in item 12 stands before your lordship with that 40 lakhs taken out from my account. The good part, on a lighter note, is that 15 lakhs is now with me, because that 15 lakhs now the bank is not wanting to take from me, because they have appropriated it from, I am assuming, the Etibar, and that
unless Etibar wins in the other one.
If they win, then again the 15 lakhs,
15 lakhs
comes back to me, Milord. So in this situation, Lord, there are two difficulties that the petitioner has, Lord. One, that for an error on the part of the bank, admittedly on affidavit, the petitioner is made to suffer and made to lie in a situation, a commercial account is kept in a situation that the petitioner does not know whether the amount is theirs or not theirs, Lord. And the second point being that the petitioner is entangled in a suit which is against a recovery suit, which the bank...
Your account is operating.
Lord, my account has always been operating with a marked lien, Lord. So now the amount has been taken off, so I can operate my account for the extra monies that my client might have in the account. But that is the situation. Milord, now the second burden that the petitioner would be faced, Milord, if at all it is understood to be a situation that it is a debt that the Etibar owed to Traco. Milord, in that situation, the only defense Traco could have had is to file a suit for recovery against Etibar. But that could only fructify the moment I understand that who is at fault. Milord, just because the bank suggests there is an error, Milord, possibly I don't have a cause of action to sue the person.
Then you will have to sue all. I mean,
Milord,
both
we
the
are
banks
stuck. And that your lordship is knows, Milord.
Or take away the entire amount which is lying over and above this. Park it in some other bank. It is a better option.
Milord, and there is one more subsequent event.
No, it's with ICICI, now park it with CBI. Yes, Central Bank. That will be a better option.
Milord, I'm just completing the other difficulty before my senior can take over, Milord. Milord, the second difficulty is that till the time the demand notice, which is our challenge in this writ petition issued by ICICI Bank, asking me to put that amount in, Milord, tomorrow, the interest on that demanded sum may also be attributable to me if that demand notice is not declared as void or recalled, Milord. Because that demand notice says 55 lakhs I have appropriated, which I should not have appropriated.
On the other hand, the lien amount you would be otherwise entitled to interest.
I could not. I could not
be entitled to interest on that, but
Milord,
you are not getting.
Milord, that is the Milord, may Mr. Gupta continue.
Only two things, Milord. One is, Milord, there is no contract with between the petitioner in item number 12 with the Central Bank of India.
Yes, yes.
They do not and cannot exercise any right of lien, either general or particular. That can only be in respect of the assets which I have or the accounts which I have. I do not have any account with them.
Central bank has not deducted,
No.
not created a
Central
debt.
bank has
Their
credited.
request.
They have requested.
That was a
Acting on their
stimulus for the
request.
ICICI to do it.
Yes, yes.
So
But it
central
is
bank has
actually-
not done
It is
anything.
actually the beneficiary of the lien is central bank.
Very well.
Through the ICICI bank is acting as an agent for the central bank for the lien, because as per the stand of the central bank, it's central bank's money. It's not ICICI bank's money.
Very well.
One other thing, my lord, initially, when 55 lakhs was credited to my account, my lord, 15, I had taken that money. 15 lakhs they have already recovered from the petitioner in item 11.
That Mr.
40 lakhs, yes.
40 will it?
Very
No, Mr. Kankani has said that
Yes.
15 was initially taken, then 40 was taken.
Not Mr. Karnani.
Yes, that's right. What did I say?
Kankani.
Oh, he's Mr. Kandani.
Yes.
Achha, it was recorded. I confused with Mr. Avinash Kankani.
Yes.
I'm sorry. Yes, very well.
But otherwise, there's no confusion.
No, this is utter confusion. Your entire matter. Apart
Yes.
from the matter, no confusion.
So, my lord,
Very well. These are your
yes,
points.
and where I stand is when the money was credited, after 1 month they take all these steps. I could have understood they immediately taking
He
action.
said 2. Mr. Kandani said 2 months. So decide among yourselves.
Yes. So, my lord, it's
1 month has elapsed in the meantime
1 month.
between your going out and coming. So it's 2 months.
2 months.
Very well.
And had they taken any corrective action instantly, then none of us would have been saddled with any liability.
Justice has been seen to be done for your client. Yes, take your seat. Yes, what is your reply? You are for CBI first, then I says the main culprit last. Yes. Regarding 12, do you have anything else to say? You are in 12, you reply on.
Thank you. I first submit before your lordship.
No, what is your stand? Tell me that. Your fault or ICICI's fault?
Traco has not
You are not a party.
discussed me. Traco's allegation against the ICICI Bank.
So you stand by that.
I'm respondent number 3, your lordship.
Very well. Yes, ICICI.
In item 12, my lord takes the petitioner at one hand and the respondent number 4 at the other hand.
4 is?
Etibar. So, my lord, Traco maintains an account with ICICI Bank. This Etibar maintains an account with Central Bank of India. Etibar gives a check to Traco. Traco submits that with ICICI Bank. Now, upon submission of that with ICICI Bank, ICICI seeks for approval of Central Bank of India that these are the list of checks which have been deposited with me, whether these are to be credited or not. Now, my lord, it is to be noted that this is not my account from which a debit has to be approved by me. I have to wait for an approval from Central Bank of India that the debit can be done. I, my lord, get the nod that yes, a debit can be proceeded with. Accordingly, Traco's account maintained with ICICI Bank gets credited. Traco subsequently remits that money. Now, my lord, subsequently what happened? I, my lord, receive intimation from Central Bank of India that there are a total of 47 checks which have been, as I say, mistakenly a nod has been given approval, and those are to be refunded. The total amount tantamount to somewhere around 87 or 88
Central
lakhs.
Bank says on the same date you are
On
intimate.
the same day, they say. On 28th of January, we receive an intimation that there are a total of 47 checks. Now, my lord, let me point out the 47 checks revolve around several customers,
Obviously.
several accounts.
Obviously, yes.
So the total amount tantamount to somewhere around 87 or 88 lakh. Now, my lord, we start the process of recovering those monies. In the meantime, we also seek from Central Bank of India that we go into deliberation with Central Bank of India. They give us a final nod to proceed with this.
So technically, do you say you are Mr. I'm sorry.
Bhattacharya, Saptashi Bhattacharya.
Mr. Bhattacharya, technically you are saying that the money which you disbursed was actually Central Bank of India's money.
It was credited by Central Bank of India.
Central Bank of India's money, notionally at least it was Central Bank's money. It was transferred to their account, Traco's account, held with you.
Held with me. I am at the Traco.
You
is
are
the
just
beneficiary.
disbursing it physically.
Traco is the beneficiary. I am the beneficiary's account holder.
Right.
Traco holds an account with me.
Right.
So I am not disbursing the money. I am not receiving the money.
Right. Very well. Very well. Let us proceed after where we
Now, my lord, these 87 lakhs takes some time to recover.
Hmm.
We, my lord, recovered around the amount of 45 checks. The only 2 checks remaining are the 2 checks in dispute today.
The rest, give it back to you.
The rest we have already handed back to CBI, Central Bank of India. Now, for these two checks, I have instruction that we have also approached the petitioner for a consent, that we have been intimated by Central Bank of India that the account holder who maintains an account with Central Bank of India did not maintain the sufficient balance as on that date. Though a nod has been given, but Central Bank of India has now burdened me with, or rather instructed me to reverse those amounts because those have not been correctly credited to you. Now I am under an obligation to instruct you to reverse that money back to me so that I can give it back to Central Bank of India. We did not receive that consent from the petitioner. Subsequently, we had to mark a lien over that account. Initially, a lien was marked over 55 lakhs. Being that amount.
What is your right to put a lien on that? What is your right? You are an intermediary in the
I'm an
process.
intermediary. I have been asked by Central Bank of India to reverse the credits of those accounts.
Do they have the right to ask you, and are you bound by their request to impose a lien on their account?
No,
And this is an independent account held with you. Who are you to put a lien? If there was a transaction with you, I could have understood. You are a mere intermediary. This is between central bank's money has been given wrongly to them. What Emitas or something? Etibar's money held with central bank was given to these people. Now, what is your right to impose a lien?
No, subject to correction, madam.
Yes.
This is.
I am taking a cue from your argument that you are only an intermediary sort of, trustee sort of.
Subject to correction, my lord, if I may place it this way. Today, Central Bank of India is a nationalized bank. Now, what are the reason given by them?
ICICI is not a nationalized
bank. No, I'm not on that. I'm not on that. Now, what are the reasons given by them while seeking the refund? The reason given by them is dishonor of checks. We have also, my lord, mail communications that I have sought for check memos from Central Bank of India. Central Bank of India produces me those check memos of those 47 checks. Today, the reason was funds insufficient, that they did not have the proper sufficient money maintained with them. I have wrongfully credited. Now, please return those back to me because those checks are not supposed to be credited. Those are supposed to be returned to me. So accordingly, this is not a case manner where they have somewhat challenged the merit of the transfer, or he is not entitled to, she is not liable to pay. Today, the reason was funds were insufficient. The checks have bounced. These are the memos. You are under obligation.
So, Bhattacharya, at the end of the day, what happens is when Tracos took the money from you physically, I mean, or whatever mode, online transfer, they were bona fide taking the money. Now, after the money is transferred to them or handed over to them, what is your right on that money?
No, my lord, if I may,
you are just another person. I mean, you are not even a creditor.
Absolutely. No, my lord, if I may, just for the sake of my lord pointed out that they were a bona fide customer at that point of time.
Yes.
No, if I say that the payee, if the payee did not have a sufficient amount at that point of time,
the payer actually
was the drawee a bona fide customer at that point of time?
Yes. Why not?
I am not challenging that he is not entitled to the money at all.
Payee and drawee are two independent entities. They have a transaction between themselves. They have certain liabilities to fulfill of each other. Now, whatever may be the dispute between them, from your end, they are an account holder with you. You have a liability responsibility to your account holder. Unilaterally, after disbursing an amount on whatever ground or count, after disbursing that amount, what is your right on that? I mean, it's his money.
Because I am saddled with instructions, or rather,
you are saddled by somebody else with instructions.
Central Bank of India. That
but you have once you have paid the money to them legitimately. At that point of time, it was legitimate. Don't forget that. Subsequently, it was sought to be rendered illegitimate by central bank's communication. But at that point of time, it was a legitimate transfer of money, handing over of money. The moment you hand over, it's their money. What is your right to put a lien on that or take back the money even? You can request them definitely. If they don't, then have you got a right under the law to take that back? And if you have, why didn't you file a civil suit against them, making them CBI a party?
My lord, I'm constrained to mark lien because I cannot take the money forcefully out of them. Rather, I requested them to, they did not.
You are doing it forcefully. What you could not do directly, you are doing indirectly. That is the difficulty. You could not directly take the amount from them. That's why you're doing it indirectly by freezing that amount of money in their account.
To the extent of 40 lakhs.
The moment you freeze that account, you put a lien, and you're the bank. You're not a third party. The bank with whom the money is putting a lien means you're withholding that amount. That means they cannot transact with that amount.
to that extent.
At the best, you could have, at best, actually what should have been done probably was Central Bank of India filing a suit against all concerned, making you a pro forma defendant there. I mean, I should not advise anybody, but that could be the only relief which comes to my mind. But unilaterally imposing a lien that amounts to attachment. You have not obtained an order of attachment from any court of law, not even filed a suit against anybody. And you attach the property of a person and a legitimate account holder in your account just because of some mistake of Central Bank of India or the system. System is very risky thing, like a brick brother sort of thing.
My lord, the creditor itself instructs me to reverse the amount. The one who has
Reverse, that reversal is very risky. Once you put that amount, you gift a property. Registry office is directed to reverse the transaction, the registration. Will you do it? Why should you? And how are you compelled even? Under the NI Act even? You are not compelled. So as far as your action goes, I don't find any justification.
That has been the situation.
Yes, it was between the petitioner in the other matter, Etihad, and this central bank. That I'll look into later. But as far as you are concerned in 12, I mean, you could not do this.
No, that has been
They
the
legitimately
situation.
got the amount. If there was a debit in their account, then they will.
And there has been another submission made that subsequently an amount of 40 lakhs was suddenly remitted in spite of the litigation.
Not
being
debited, probably frozen also.
in spite of the litigation being pending.
Yes,
My lord,
yes.
I might find from the affidavit of reply that the amount was 31 lakhs, but I may clarify it out, my lord, that an injunction order was refused initially. So, my lord, the lien was in subsistence from day one.
Injunction refused by whom?
By Justice Moshin Bhattacharya was the
No,
matter
because
was
in this writ court.
so
Acha.
in this writ petition, my lord, so the lien mark was in subsistence. So accordingly, when the account was credited, there was
No, if I
already
dispose of the writ petition, the entire thing will be taken care of.
Well, that's the difference. I'm just clarifying it out why the amount was remitted in spite of the litigation being pending.
At present, what is the amount which you are freezing? I mean,
We are not freezing. If the amount is the
Lien
lien that
on
has
what
been
amount?
marked, has been satisfied, the account remains operative.
no. Now at present, they can deal with the entire amount.
They can deal with whatever is remaining with them. My lien was to the extent of 40 lakhs only. That 40 lakhs being satisfied, they can operate with their account normally.
They have taken out 40 lakhs forcibly.
40
They
lakhs
have taken
satisfied
out
means you have
forcibly.
taken out the 40.
Yes.
Today,
You are satisfied, but I am not. You cannot take out 40 lakhs from somebody's account just
because
like
there was already a lien marked to the extent of 40 lakhs.
you're doing whatever you like. Today you are taking out 15 lakh. Oh, that money there in my other pocket. So I'm taking it out. You cannot do this. You're a bank.
There was already a lien in subsistence, man. That is why the amount was automatically remitted and it was
Lien created
accordingly
by
given,
you,
given to Central
generated
Bank
by
of-
you, initiated by you, originated by you.
Man, not the originator, my lord, was not me.
Lien was originated by
Lien was-
you on somebody's request. Some other bank, some other small brother probably. This is not done. Anyway, you have a better case than Miss Oja.
I received payments from other creditors and which money has been taken out. In that account, it went and gone up.
Very well. Any question of reply in your matter? No.
Your Lordship, I have to, my stand is same which I have taken in 11.
Has to remain the same.
Issue number 11, Your Lordship. Only I will just indicate the,
So now you have to decide basically between you and CBI.
yes, Your Lordship, the Central Bank of India is also acting in the same.
Unless I
manner.
change my mind in the meantime.
Whenever the amount came in my account, they deducted as per their will without giving any intimation. 15 lakh was deducted initially, Your Lordship, which is evident from the page.
So at present, a suit is pending at the behest of the Central Bank of India against you.
Yes, Your
They have claimed 40 there
Yes, Your Lordship.
because they have already taken out 15.
15 plus, Your Lordship, 7 lakhs.
7 lakh something, yes.
Which is evident from page number 18 of my supplementary affidavit.
Close arguments.
Yes, Your Lordship.
Heard learned counsel for the petitioners and the respondents in both the matters. First up, hearing is concluded. Judgment is reserved. এই দুটো বাবু আলাদা করে দিতে হবে। হ্যাঁ, thank you.
অর্ডার দিলে তখন দেখা যাবে। I understand what you're saying is correct. But আপনার assurance দিয়ে
দেখে দাও একটা দেখি 2 মিনিটের মধ্যে যদি শোনা যায় তাহলে।
Item number 13. World Corporation.
You are appearing?
Yes.
Can't be heard within 2 minutes. দেখে নাও। So I'll take up from this matter on the next service.
My lord, before your lordship rises, kindly pardon my impertinence, my lord. Item 15 is that insurance claim matter.
Yes.
Where my learned senior friend was arguing and it was, your lordship was
Yes,
considering
yes,
the
yes.
matter. My lord,
Precedence.
it's a bit late in the day, but we have found 4 documents with regard to salvage of the claims. Would your lordship kindly permit us to serve a supplementary affidavit in course of the day
I'll
and
not
keep it
permit
day
you.
after tomorrow?
I'll not permit you anything.
But-
Do whatever you have to do. You should be well advised. You do whatever you have to do, then I'll do whatever I have.
Because it's running in the list, that is why, my lord,
I'll not pass a formal order or give you a formal sanction on that. You do whatever you have to do. I'll consider.
after that.
My lord, only one indulgence, my lord. Since the matter is spot heard, can it be taken tomorrow?
I'm trying to hear out the matters previous to that.
My lord.
Not only to previous to your matters, whatever are the
My
matters.
lord.
So let us see. This will probably go up a bit. It is উপরে উঠবে
My lord, in
পাঠার মার্ক করিনি এটা না
ঠিক আছে সেটা অসুবিধা
নতুন ম্যাটার ছাড়া
The CM
pole transformer is going to be
No.
installed. And Malad, I saw them,
Not a single mode matter. Mr.
Malad, that is in the list. 56, Malad, any
No
time,
upgradation. No upgradation. Call on the list.
71, my lord.
No.
Otherwise, it will be an infraction.
Several of them of course, will become infractions.
Malad, Thursday, I mentioned, Malad, directed to on Friday.
Call on item number 1.
For judgment, item number 1.
Accordingly, WPA 10470 of 2023 is allowed on contest, thereby quashing the claim of the WBSEDCL for alleged outstanding dues of rupees 1686.2398 per se in respect of the deemed disconnected bulk service connection with a consumer ID number 941611900. The WBSEDCL is hereby directed to restore electricity connection of the petitioners in respect of consumer ID ending with 2012 as expeditiously as possible, preferably within a fortnight from date, without insisting upon further payment by the petitioners of the for the purpose of restoring such connection. Made clear that WBSEDCL shall henceforth not make any claim of such alleged outstanding dues in respect of consumer ID 941611900 against the petitioners in any manner whatsoever, nor as to cost urgent certified copies.
I'm grateful, Your Lordship.
I'll call the 2 p.m. matters first, then the top matter.
2 p.m. matter.
Yes. What is the
Item 84.
My lord, I beg to appear on behalf of the petitioner in this matter.
Yes.
My lord, so far the petitioner is concerned, my lord, they are engaged in running mobile medical units or mobile boat clinics at the remote part of Sundarban, where they provide the medical facilities with doctors, nurses, and other apparatus. Now, my lord, since 2013, he has been engaged by way of tender and with extension in providing the medical facilities. Now, my lord, what happened? In 2022, a notice inviting tender was issued. My lord, I participated in that tender. I became L2 with 352,000 and L3 was 373,000 and odd. Now, whoever the L1 is, he quoted absolutely low rate of rupees 126,000 and it was given to him. But he refused because he clearly stated that he cannot do this. With this price, he cannot do this. He only himself quoted that price. Normally, it was cancelled. It was given to us that you are the L2, so you will be conducting the whole process. It is for 3 years. Now, with a rider that you have to do it at the rate of L1, even though you have not quoted it. Now we said that this is not possible because you cannot impose rate of L1 upon us. The tender condition says the L2 in failure of L1 will be eligible for conducting the whole tender process, which is done. This is the norm. They said, no, you have to do it at the 126,000 at the half rate. We even offered that we can give some discount if possible at that time of 3 years. Now, what happened during pendency of the same? They call for a fresh tender. With the same issue, they have called a tender. Now, I draw your lordship's attention to page 144 for once. This is the notice inviting tender and the relevant clause which the authority has invoked at page 147, bottom 15. Contract period. The lordship has found contract period. Clause 15 at page 147. The rate shall be valid for 3 years from the date of commencement of work. The contract will be initially signed for 1 year from the date of signing of agreement. The contract will be renewed every year subject to satisfactory performance. Next, any failure to comply with SOP on bidder's half or serious fault deducted and reported time to time may invite non-renewal of agreement at the end of the assessment year. In such situation, the contract will be awarded to the next lowest bidder. So the authority itself invoked this clause and gave it to me. Now, my lord, I draw your lordship's kind attention to page 172 to give a glance of the rates which were quoted. Just one page. 172.
Yes. 172, right?
Yes, ma'am. My lord, kindly see the rates are quoted in boxes. 3,52,632 is 38 is my rate.
Then, my lord, this Digambar Angikar, that is 1,26,500. And the Sarvik Vivekananda is 3,73,000, which is given. And the left-hand side, lowest amount quoted by Digambar Angikar, Digambarpur Angikar. So absurdly low quote was quoted and it was given to him. Now, my lord, kindly take page 174, by which the L1, the alleged L1 was given the notice, the letter of award of contract, page 174. Now, my lord, kindly see, this is very important. Now, the L1 withdraws from the tender process, which is at page 179. This is very important, my lord, what they have stated in their submission itself. This is a typed copy. The previous copy is, my lord. My lord, I'll just draw your lordship's attention to the second paragraph itself.
Right.
Sir, we haven't our own boat. Hence, we had hired those from outside. But now the owners are starting to blackmail us and constantly increasing their initial agreement rate, which is gradually becoming a challenge for us to provide quality health services for the marginalized. With additional demand from the boat owners, it will be a huge monetary loss for us compared with the bidding rate, which might destroy essential health service community for the marginalized people at Sundarban. Hence, sir, we are not willing to start and continue to purpose emergency health service projects with all these uncertainties which are not in our control. So they themselves accept that compared with the bidding rate, they cannot do it because they have quoted abnormally low. So they cannot. Now, my lord, what happened after this? Kindly take page 180. We have been offered. That is of 10th of March 2023. My lord, kindly see confirmation on acceptance of award of contract for operation of mobile boat clinics.
Yes.
In terms of point 15, your lordship may be pleased to recall point 15 I placed before your lordship. Under section 2 of NIT, the AOC for operation of mobile boat clinics, MBC, in South 24 Parganas, Diamond Harbour Health District and Boshirat Health District, West Bengal is hereby being offered to your organization to run at the L1 rate offered for an amount of rupees 1,26,500. This is my humble submission. This is absurd. The rule says, clause 15 says L2 will be the next bidder if L1 fails. Nowhere in the terms of tender it is said that you have to take up the work at the rate quoted.
Why do they get 1,26,000?
It was the rate of L1, absolutely absurd rate, which they quoted and they have accepted.
So at page 172, you place those are the rates.
Yes, my lord. That is 1,26,500.
Oh, yes, right.
My lord, my
Very
humble
good.
submission in respect of page 180 is that the tender condition says in default of L1, L2 will take up the work with whatever quotation they have made. Now, it is beyond the scope of the tender document that you cannot impose the quotation quoted by L1 that you cannot compel me to conduct the process with their price. That is my humble submission. That is where they have gone wrong in my respectful submission, because there are two infirmities. Firstly, it is not there in the tender document.
Now, this clause 15 applies to failure to comply in the case of non-renewal of agreement.
It says or. It says or.
Achha.
Well, kindly see, it says or. And my lord, the authority itself has invoked clause 15. It is not we have invoked.
Yes, right.
They have invoked.
Right.
Now, my humble submission are two, that you cannot impose and it is not there in the tender condition. And my lord, it is an essential condition in my most humble.
You are challenging this as well as the fresh tender.
Yes, my lord, kindly take the next page.
Yes.
Page 181, that is our representation. I will not trouble your lordship much. We have even said that we are going to give you in the second bottom paragraph that we are going to give some discount also. Since it's a noble cause, we are going to give some discount if possible with us, but not at the 50% low rate, which they had absurdly quoted, my lord. Now, my lord, what happened? Surprisingly, even after their withdrawal, my lord, kindly see page 185. That is of 31st May of 2023. Despite the withdrawal of the L1, they keep the L1, that is Digambarpur Angikar, as L1. They withdrawn on 8th of February 2023. Despite all these things, despite they have offered after their withdrawal, the authority in their e-procurement portal keeps the Digambarpur Angikar as L1, which cannot be, because it was offered, they refused.
Page 185 is the subsequent tender.
No, it is the continuation of the second call. But they are showing as L1 as Digambarpur Angikar, which cannot be and accepted because they have already withdrawn. It has been given to us.
This is a continuation of the same tender process.
Yes,
the next stage.
Yes, next stage they have published it. Absolute infirmity in this. Now, my lord, kindly take page 1 186, 187. This is the fresh tender which they have floated.
Yes.
And my lord, kindly see the 13th of June 2023. That is today at 5
What
PM.
happened to this? Digamparpur was accepted.
It is wrong. They have already withdrawn. It has been given to us. Despite that, this error is there in their portal.
After giving it to you, this was done.
It has been done.
That
It was,
oh yeah, 23.
yes, my lord. Now, my lord, kindly see page 187.
Yes, yes.
13th of June 2023, because my lordship, I mentioned yesterday, it is my duty to satisfy lordship that why it was urgent. My lord, kindly see 13th of June, that is today, 2023, 5 PM, the fresh tender is being closed down for dropping of the tender.
Yes.
Now, my lord, my humble submission is on the point that, my lord, just very summarily, my lord, I will conclude. My lord, my humble submission is that the government authorities, while dealing with the state largesse, is bound by their own terms of tender and the norms. They cannot go beyond it. One, for which, my lord, there is 3 judges bench judgment of the Honorable Supreme Court, very celebrated judgment, my lord, 1979, 3 Supreme Court cases, 489, 3 judges bench, Ramana Dayaram Shetty. For satisfaction of your lordship, my lord, paragraph 12, I would like to place.
389. Yes. Paragraph 12.
1979, 3 Supreme Court cases, 489, paragraph 12.
Paragraph 12, yes.
Yes, my lord. May I just hand over, my lord?
Did you read it out first?
Yes, yes. This proposition would hold good in all cases of dealing by the government with the public, where the interest sought to be protected is a privilege. It must therefore be taken to be the law that where the government is dealing with the public, whether by way of giving jobs or entering into contracts or issuing quotas or licenses or granting other forms of largesse, the government cannot act arbitrarily at its sweet will and like a private individual, deal with any person it pleases. But its action must be in conformity with standard or norms, which is not arbitrary, irrational, or irrelevant. The power of discretion of the government in the matter of grant of largesse, including award of jobs, contracts, quotas, licenses, etc., must be confined and structured by rational, relevant, and non-discriminatory standard or norm. And if the government departs from such standard or norm in any particular case or cases, the action of the government would be liable to be struck down unless it can be shown by the government that the departure was not arbitrary, but was based on some valid principle, which in itself was not irrational, unreasonable, or discriminatory. I'm only on the point of conformity with the standards. That is the standard as per clause 15. Now, my lord, I would be next referring to 1991 3 Supreme Court cases 273, which is also a very celebrated judgment of Podda Steel Corporation. It is on the point of essential. Well, may I just hand over. Paragraph 6, it is on the issue of essential part and the non-essential part. In paragraph 6, my lord, placitum B onwards. Just after placitum A. As a matter of general proposition, it cannot be held that an authority inviting tender is bound to give effect to every term mentioned in the notice in meticulous detail and is not entitled to waive even a technical irregularity of little or so or no significance. The requirements in a tender notice can be classified into 2 categories: those which lay down the essential conditions of eligibility and the others which are merely ancillary or subsidiary with the main object to be achieved by the condition. In the first case, the authority issuing the tender may be required to enforce them rigidly. In the other cases, it must be open to the authority to deviate from and not to insist upon the strict literal compliance of the condition in appropriate cases.
So this is an essential requirement.
It has to be essential because it is determining the fate of the tenderer. Now, my lord, your lordship has been pleased to consider this judgment and passed very recently. Your lordship's judgment.
2 judgments of the Supreme Court are there.
Yes, and your lordship has followed.
This is well settled, this proposal.
Yes, your lordship has followed in this.
Yes, yes. Anything else, Mr.
This is my humble submission that it cannot be done.
Right. Yes, Mr. Shen. How do you distinguish my judgment? That is the most important. The others will follow.
Sorry.
Mr. Shen, what is this? I mean,
no, there is
how
a
do you-
Bengali expression. "E bole amaye dekh, o bole amaye dekh." Each party has, both the parties have made mistakes galore.
Parties here, I mean.
Parties here have
Not
made
the parties to the hearing.
Not the party.
No, Mr. Sen, yes, for
I
why
tell-
ये बोले हमें देखो.
I tell Lordship, Lord.
Please.
The tender at page 144 required certain basic eligibility criteria for bidders to participate. Once they have put in their bids are assessed, the L1 bidder is declared as the successful bidder. As in every tender, the notice inviting tender, which your Lordship will find at page 144, is nothing but an invitation to offer. The bids submitted are the proposals. The moment the bid is accepted by the government by declaring the bidder to be the successful bidder, a contract stands concluded. The moment the contract stands concluded, unless the tender documents say so specifically, L2 and L3 and all others go out of the picture. There is no automatic right conferred by the bid documents or by the law in general that if the successful bidder is unable to perform, the second bidder, L2 bidder, would get the contract. It's neither a proposition of general law, nor can it be applied unless the bid documents say so specifically. The bid documents must say that in the event L1's tender is cancelled for any reason, the L2 will get it at the L2's price. There is no such provision in the contract. The provision which was shown to your Lordship, paragraph 15, as your Lordship had remarked, my learned friend had tried to justify. I will not try to justify because it seems that it has been misapplied by the government.
By the government?
By the government. If your Lordship kindly comes to page 147 and please comes to paragraph 15 or clause 15 at the bottom of the page.
Yes.
The rate shall be valid for 3 years from the date of commencement of work. The contract will be initially signed for 1 year from the date of signing of agreement. The contract will be renewed every year subject to satisfactory performance. Lord, clause 15, the next part of clause 15 comes into operation after the contract is signed for 1 year. And it relates to performance of the contract as signed between the government and the successful bidder. Now, Lord, please see the next page, page 48. Any failure to comply with the standard operating procedure on bidder's half, the language itself, the English itself makes it clear how much of care and caution they took. Any failure to comply with the standard operating procedure on bidder's half or serious fault deducted and reported or deduced and reported
should be, yes,
time to time may invite non-renewal of agreement. So, this is the consequence which the bidder faces at the completion of the 1 year tenure. After he has performed 1 year. And we invite renewal of agreement at the end of the assessment year. So, in the event of non-performance, defaults, or any breach of the tender conditions or of the contract, his contract may not be renewed. Then what would happen is, for the 2 remaining years of the contract, in such situation, the contract will be awarded to the next lowest bidder. Not subject to being corrected by my learned friend, possibly this is the only situation in the tender documents under which the L2 gets a foot in the doorway, otherwise not. Here what happened, my lord, your lordships have been shown page 172, which is the bid sheet, the 3 bids by the 3 bidders. There's L1, L2 and L3. I'm not on the amount. There was an L1. Then a letter of award is issued at page 174 in favor of L1. Contract stands concluded by issuance of the letter of award. Once the contract stands concluded, L2 and L3 go out of the picture. If they have put in earnest money, they will get back their earnest money. If they have not, they do not enter into the picture unless the bid documents otherwise say so, and subject to being corrected, except for clause 15, there is no other provision. After the contract stands concluded between the parties on 15th of December, then Lord, on 8th of February 2023, which is 2 months after the contract tenure has started, there's a letter of at page 179 where the L1, Digomborpur, no, is it Digomborpur Ongikar?
Digomborpur Ongikar, yes.
He says, I am unable to continue. He gives reasons. He says that I had been able to bid the particular price on the basis that I would
Ports had and all this.
I would hire the ports.
Yes, yes.
Now I'm fine that I am being blackmailed. The prices are constantly increasing. I am unable to take care of the inflation in the market, essentially. He pleads the impossibility in terms of Section 56 of the Contract Act. He says, post-contract, impossibility of situation, I am unable to perform. So then, Lord, is the mistake that the government makes, which it ought not to make, which is at page 180. The government invokes paragraph 15 or point number 15 as is mentioned here and offers L2 the L1 price. There is no provision in the tender documents under which this could have been done. But having offered the L1 contract price, no equity is created in favor of the writ petitioner. Unless he had accepted this offer. But if he had accepted this offer, he would have fallen foul of the judgments which have been placed for your lordship's consideration. Because that would have been giving a largesse without an open, transparent, competitive bidding process. Both 79 and, my lord, the later judgment. Indian Airport Authority's judgment, my lord, was with regard to having those stalls in the airport, where the Supreme Court for the first time said, no, if it's state largesse, if it's natural resources, they have to be given in a manner which is transparent. But the later judgment of 1991, Podda Steel is really not relevant. Podda Steel says every contract has essential and non-essential conditions. Essential conditions can never be waived. Non-essential conditions can be waived or varied, but the variation must be made applicable to all bidders.
So you're not going into the essentiality of that.
Not at all.
That is not applicable in any manner.
Not at all. I'm saying the contract, as it were, came to an end the moment L1 bidder resigned from the contract. And the only avenue open to the government was to issue a fresh tender process, to have a fresh tender, which it has done, which your lordship will find at page 187.
Now, Mr. Shen.
Now, my lord,
I'm
sorry.
Please complete. It's on different.
But when we gave them the offer,
yes.
The letter at page 180 is an offer. This is an offer, really speaking.
So we cannot bind you on estoppel or offer acceptance. Definitely, there was no concluded contract.
Not
it was a fresh
to this
offer.
To this offer or to this proposal.
They did not agree.
This is a proposal deholds the tender. To this proposal, there could have been a binding contract had the acceptance been on unqualified and unconditional terms.
Right.
But the acceptance at page 181 is an acceptance, but it's not on unqualified and not on unqualified or absolute terms.
Yes.
Because he says, I am willing to work, not at this consideration, but I am willing to give you discounts. He doesn't say I am not.
That's a counter offer, sort
of. It's a counter offer. It's a counter offer.
Now, only one thing, Mr. Shen, this clause 15.
Yes.
Now, clause 15, if that gives the that mandates or imposes the liability on the employer to offer a contract at the end of one assessment year, after 1 year's tenure is over. I mean, what is the logic of that not being offered beforehand? Because here they did not start the work at all. I mean, although it's somewhat doubtful whether the court can go into that issue, but on an interpretation of this. I mean,
so far as the tender document is concerned, the tender document contemplates a manner in which the contract can come into being.
True.
With the parties satisfying the technical and financial.
Mr. Shen, it's on an interpretation of this contract. Please come to page 148 once, the first sentence.
Yes, Lord.
Any failure to comply with SOP on bidder's half or serious fault deduced and reported from time to time. This is not a serious fault deduced and reported.
No.
But why shouldn't it be any failure to comply with SOP on the bidder's half? I mean, the bidder was the L1 bidder, failed to comply with the standard operating procedure. I mean, why shouldn't it be awarded to the next lowest?
I tell you, Lordship, not the rational.
It can be done 1 year after. I mean, why not now?
I'll tell you, Lordship, the rationale is,
Hmm.
one is that we find
Hmm.
that you, contractor, you
Hmm.
are unable to perform your contractual obligations.
Hmm.
You are committing fundamental breach of contract.
Hmm.
That gives me a right under the general law to terminate.
Hmm.
Now, my lord, there may be reasons where there are operational issues which are in the standard operating procedure.
Hmm.
Those may not be fundamental to the contract, but they create difficulty in the management of the entire procedure which we have of mobile boat medical treatment.
Hmm. Hmm.
There, you have started a 3-year contract, but with a 1-year tenure at the outset.
Hmm.
We allow you that 1 year, but we will not renew. Now, Lord, even if in this case there had been a fundamental breach and we had terminated it at the very outset, that still would not have given the writ petitioner a chance to step in, because then we would have been compelled to issue a fresh tender.
No, but on failure of that, you have to offer it to the contract will
Lord,
be
that
awarded
is
to the next place.
that is only in the
If it
event,
remains valid till the next year,
Lord, that is only in the event of, as I said, failure to comply with standard operating procedures, which are operational issues, or serious fault deduced and reported from time to time, may invite non-renewal of the agreement. If there's a non-renewal of the agreement,
renewal comes in between this. Yes.
non-renewal for the second and the third years,
Hmm.
the contract will be awarded to the next lowest bidder and not necessarily at the price bid by the next lowest bidder. Because it's possible that L1, who bids at a price commensurate with the market, bids 100 rupees. Second lowest bidder bids 5 lakh rupees. The state cannot be compelled to make a loss because of what the other bidders have bid.
All right.
Now, Lord, one last submission that I would like to make is, if my learned friend were to be correct and I were to be wrong in my submissions, then my learned friend's client's response to the letter given by us saying that please work at the L1 state would have been, no, I'm not willing to work at all, save and except in terms of clause 15, give me the contract on my terms, and not say, I'm willing to work and I will give you a discount.
So that is a counter offer.
That's a counter offer. That militates against whatever arguments have been made. Now, one only confusion is this document at page 185. This is the only confusion which remains in the puzzle. The piece which doesn't fit in.
Yes.
This relates to the earlier tender. This is really nothing but the tender summary report. Every time that one opens the website and looks into the particular e-procurement portal of this particular department, we will get the list of the bidders. This does not say that on this date of 19th of March 2023, we are accepting him.
It's a status update.
It's a status update.
Yes.
Your Lordship will find the submitted date is 28th of March 2022.
Right. And that is the date of the status update.
Yes, Lord.
Good.
Now, Lord, we have done what we ought to have done all along. That is page 187. We have issued a new tender. My learned friend may participate. Page 187 is a new tender.
Good.
These are my respective submissions.
Yes.
Yes, my lord. At the very outset, my extreme learned senior friend had submitted, there is a mistake on the part of the government. None of the submissions afterwards.
Invoking clause 15.
Clause 15.
Yes.
None of the submission afterwards, in my respectful submission, stand after accepting the fault on the part of the government. One. Secondly, the government cannot reprobate and approbate at the same time, saying that yes, we have invoked it, but it is not correct. And giving me the tender that you proceed. Now, my lord, so far, page 148, kindly come to my lord, page 148, that clause 15. My lord, there are two elements. One is any failure to comply with SOP on bidders of, or, this is a disjunctive or serious fault deducted and reported time to time. We are not concerned with that because it's subsequent. This clause itself contemplates two conditions. One is post-agreement and one is pre-agreement. And in case of any failure, it will go to the next lowest bidder. Therefore, so far the first condition is concerned, I am covered under this first condition. And secondly, it says
No, it says SOP, not the contract. Not
standard of procedure.
standard
that
operating procedure.
operating
is not-
procedure
not
is the bidders at the stage of bidder. So it says otherwise the second
Very well.
clause, otherwise my lord, the
Very well,
second part would not have been applicable, would not have come even into this
All right.
clause.
All right.
Now, my lord, nowhere in the tender document it says that the L2 can be compelled to work at the price of L1, which is a major deviation from the essential.
Sir, one
contract.
other thing. How
Yes.
do you explain non-renewal? Because your right would be at the stage of non-renewal of the agreement after 1 year.
That I'm not
Here,
agree with
the
that.
agreement has not been
Exactly.
fructified at all.
That is my humble
So
submission.
then, whether you have this right or not.
That is my humble submission. We need not even go to that part because it has not reached to. That is quite premature.
So if that be so, then
Yes.
check clause 15 does not come in at
No,
all.
the first part comes in the effect. The first part.
Even the first part is qualified by the right is to invite non-renewal of agreement. So it's a question of non-renewal, whether it's the first part or the second part, whether it's a serious default later on or failure to comply with the SOP. The right which accrues in your favor is an invitation of non-renewal of agreement. I mean, their agreement
I
won't be
understand.
renewed and you will be called up.
Well, if you lordship
So what is the
kindly-
question of
Yes.
non-renewal if it does
Yes,
not
yes,
continue?
I'm coming to that, man. That is my humble submission. Clause 15 at the very beginning at page 147 says, contract period. The rate shall be valid for 3 years. So it contemplates a pre and post.
So then initially signed for 1 year, that is there. That is
No, it is for
qualified.
3 years. Every time
It
it
is
is
good. Let us continue with that.
Yes, yes. The rate shall be valid for 3 years from the date of commencement of the work. The contract will be initially signed for 1 year. From the date of signing of agreement, the contract will be renewed every year subject to the satisfactory performance. So that is my submission. There are 2 stages. One is first signing of the agreement, then renewal.
If
There-
the rate has to be fixed for 3 years, then it cannot be deviated from. So they agreed, the government agreed, the employer agreed at 1,26,000. Now that cannot be deviated for 3 years. And that's why they offered you, they gave you an offer at that same rate, because that has to be valid for
That
3 years
is,
also.
my lord, that is nowhere in the tender condition that I have to work in the same rate.
The rate shall be, if the rate is valid for 3 years,
The rate
if you
is-
read the clause, you have to
Yes.
read it as a whole.
Absolutely. The rate
Then
is valid for 3 years. The rate of
Rate is
who?
1,26,000.
The rate of the successful bidder. The successful bidder is L2, not
You are not the
L1.
successful bidder.
I am today after the
No, you are by default, you are coming in place of
Yes.
you are not the successful bidder.
initially. Now, after they issue the letter saying that I am a successful bidder now.
That does not make you a successful bidder. You are the
Subsequent-
runners up, still the runners up.
runners-up.
But you are called upon to take the award because you are because he has failed.
Yes, but it says that now you are the successful bidder. Now, after L1, my lord, this is a general principle of contract. After
What
L,
general principle?
my lord, the L1, if the L1 goes,
General principle of sports, you may say, not of
it
contract.
can be. Everything is sportsman.
No, not of-
All are running for their
not contract.
Like,
No, my lord,
like
just-
Ben Johnson and Carl Lewis.
Ben
Yeah,
Johnson
Ben
was the exact, because Mr. Shen, this probably relates to our generation or something like that. That Ben Johnson, that example precisely came to my mind.
Yes. My lord kindly appreciates there are, as I was submitting, there are 2 stages.
Yes,
Otherwise, the second stage with a disjunctive or would not have been there in the clause itself.
yes.
It says 2 conditions: any failure to comply with SOP on bidder's half, and then or serious fault deducted and reported time to time may invite non-renewal. One at the stage of non-renewal, as your lordship has rightly pointed out, subsequently for 2 years, and the first part is the beginning, at the beginning stage. Now it says, in such situation, the contract will be awarded to the next lowest bidder. It is the awarding of the contract, not the renewal. That is why I'm at the first stage. It is the awarding of contract. My lord kindly appreciates. The word used that in such situation, the contract will be awarded to the next lowest bidder, not renewed. So it comes in conformity with the first part, awarding of contract. Now, my lord, so far 174, my learned friend has submitted. It says that letter of award of contract to the Digambar has been given. So it is concluded I have no right. This submission, in my most respectful, humble way, disperse into oblivion for the fact on the very next occasion, it has been given to me. The moment you are closing L1 and giving the right to L2, the right accrues in my favor, at least to enter into the agreement. Page 179, my learned friend has referred, and 180 is the letter, my lord. Now, it is a confirmation. My lord, kindly see page 180. It says confirmation on acceptance of award of contract for operation of mobile boat clinics. It's a confirmation. Now, my lord, the respectful submission is that when it is said that it is concluded, therefore L2, L3 is outside the purview of the contract, perhaps it is not correct. With due respect to my learned senior friend, perhaps it is not correct, because the moment you're issuing page 180, you are playing within the periphery of the tender itself. You are invoking clause 15, first part read with the last part, awarding of contract, and you are awarding this confirmation on acceptance of award of contract. My lord, kindly see this award of contract read with clause 15, second part. It is just in conformity with clause 15, second part, that is awarding of contract to the L2. Exactly, it has happened. Now, my lord, the government itself is bound by its own terms and conditions.
That is it.
Now, my lord, the next submission which has been made is that offer and counter offer at page 181. My lord, this, in my most respectful submission, my lord, this is not a counter offer. This is because we are doing this in some sort of, for poor people at that area, it is needed. I have talked to my client, it is very much needed. My lord, it is since they want to, they're doing it from 2013. They have all the expertise, because this work cannot be done by any Tom, Dick and Harry. For that, they need to have a specific qualification, and the doctors from last 10 years, they're doing it for the poor people over there. So they have the expertise. So they said, very well, if you have done so, we are ready to give you some sort of discount. It is not any counter offer. I cannot bring government in a contract for a counter contract. It cannot be perceived. It is just, if your lordship can consider it as a goodwill gesture that we stated, yes, we are ready to do it in some way. It is not a counter offer. In the realm of contract act, there has to be a counter offer. I am in an unequal bargaining position with the government. I can only offer counter offer when I am at par with the government. It is not even allowed in tender. Tender comes, it's an offer acceptance. We have accepted, we have not denied. We said, very well, if you are saying we can do it we'll give some discount, but we have not deviated from our stand, because the tender document nowhere says that L2 is bound to quote the price of L1. Otherwise, the whole purpose of tender would be vitiated, my lord. Now, kindly appreciates one thing. Today, there are 5 tenderers. Someone comes with ₹5 and someone comes with 500 rupees. So it has to be done at the cost of 5, which is absurd. And the L1 itself has accepted that it is a non-competitive quote. They have accepted in their letter. I placed your lordship. That's why they lift their hand that we cannot do it at this rate. Merely because they have quoted an abnormal rate, which is to be the perfect rate, which is to be binding for others also. That may not be correct.
You participate in the new tender.
My lord, my right has accrued, my lord. I may not even come, because since my right has accrued and government is accepting the fact, it is maybe a fault on their part, but they have not deviated from the tender condition. I am bound by the tender condition.
They cannot deviate from the tender condition.
Tender condition, it is. My lord, if I participate, if I may respectfully submit, my lord, I may not come as the L1 or L2. So, my lord, my right has already accrued. Now, my lord, my learned friend has submitted page 187, 185 first. My learned friend says that it is of the previous tender, but it is of 31st of May 2023, much after issuance of the award of contract in my favor. And the same parties all are given. It cannot be. And my lord, kindly see page 186. At the top, the quotes are also same: 3,73,000, 3,52,000, 1,26,000. So it is not any of previous, it is of this tender. And this 187, my lord, it has been, my learned friend has submitted. My lord, so far the loss, proposition of loss to be sustained. My lord, in that case, none of the tenders will survive anymore. If the government thinks, no, it will sustain loss, then everybody will come with an abnormally low price and government will consider them for the contract. So then there would be no level playing field forever. And the work would be deteriorated for every time. We have the experience of 10 years we are working in this. My lord, that is my humble submission, that it cannot be imposed upon us that rate. Grateful, your lordship.
The present challenge has been thrown against a fresh tender issued by the respondent authorities, despite the petitioner allegedly having acquired a right in terms of the previous tender to get an assignment of the contract in question Full stop. Next para. A contract was floated by the respondent authorities for operation of mobile boat boat clinics in South 24 Parganas, Diamond Harbour Health District and Bosirhat Health District, West Bengal. Full stop. Next para. Learned counsel for the petitioner contends that in terms of clause 15 of the tender document, in the event of failure on the part of the L1 bidder to comply with the standard operating procedure within bracket SOP bracket close, the contract would have to be awarded to the next lowest bidder, that is the present petitioner. Full stop. In the present case, after the contract was awarded to the successful bidder, that is the L1 bidder, it was communicated on the part of the said L1 bidder that due to certain constraints, the said bidder could not honor the contract and as such, withdrew from the said contract. Full stop. Thereafter, in terms of clause 15 of the tender document, with a communication dated February 28, 2022, the respondent authorities invited the petitioner, who was the L2 bidder, to take up the assignment, however, at the rate offered by the L1 bidder. Full stop. It is submitted that the said rate of the L1 bidder was tremendously low and the same can be demonstrated even from the refusal of the L1 bidder to honor the contract on the ground of impending monetary loss if the same was implemented. Full stop. Next para. It is further argued, on the premise of certain cited judgments of the petitioner as reported at 1979 3 SCC 489 and 1991 3 SCC 273, that state largesse cannot be distributed by the government arbitrarily or in an irrational manner. Full stop. Next para. Unlike private employees, the standards or norms which have to be followed by the state have to be reasonable, non-arbitrary and demonstratively transparent. Full stop. Next para. Learned senior counsel appearing for the state contends that clause 15 ought to be interpreted in a different manner than that sought to be done by the petitioner. Full stop. It is argued that the said clause stipulates that the contract would be initially signed for 1 year from the date of signing of the agreement and would be renewed thereafter every year, subject to satisfactory performance, full stop. Next para. The second limb of the clause provides that any failure to comply with the SOP on the part of the bidder or serious fault deduced and reported time to time may invite italics the non-renewal of agreement at the end of the assessment year. Eta purota italics stop. Only in such situation, it is submitted, the contract would be awarded to the next lowest bidder. Full stop. In the present case, however, such occasion did not arise as the L1 bidder did not proceed with the awarded contract at all. Full stop. Next para. It is further argued by the state that the communication dated March 10, 2023 was erroneously done by the on the part of the respondent authorities and is not in terms of clause 15. Full stop. It is contended further that even if the said communication be deemed as an offer made by the state, the petitioner herein did not accept the said offer in an unbridled manner. Full stop. Rather, a counter offer was sought to be given by the petitioner insofar as the petitioner did not agree to take up the contract at the rate as offered by the respondent authorities. Full stop. Next para, insofar as the cited judgments are concerned, it is argued that there is no doubt that the state action is required to be transparent. Full stop. However, in view of the exact precise language of clause 15, it can only be interpreted in a single way, as per the arguments of the respondents. Full stop. Next para, upon a consideration of the materials annexed, it is seen that the state had given an offer, after the failure on the part of the L1 bidder to take up the contract, to the present petitioner, who was the L2 bidder. Full stop. The said offer dated February 28, 2022, however, quoted a particular amount which was equivalent to the rate offered originally by the L1 bidder. Full stop. In its reply thereto, dated March 15, 2023, also annexed to the writ petition, the present writ petitioner did not agree to such price. Full stop. As a counter offer, the petitioner stated that it was agreeable to give certain concessions to their original quoted price of rupees 3,52,638. But it would not be possible to take up the contract job at 50% discount. Full stop. Next para. Although the petitioner is justified in arguing that the rate at which the L1 bidder bid is not economically viable at the first blush, since the L1 bidder itself resiled from its original promise of taking up the contract, that ipso facto that does not justify that any right is created in favor of the petitioner as the L2 bidder by virtue of clause 15. Full stop. Next para. A careful perusal of the said clause clearly shows that the second limb thereof stipulates that even in case of failure by the L1 bidder to comply with the SOP, only at the juncture when the assessment year ends, a non-renewal of the agreement with the L1 bidder can be considered. Full stop. In such situation and in such situation alone, the contract could be awarded to the next lowest bidder. Full stop. The first limb of the said clause, on the other hand, clearly indicates that although the rate shall be valid for 3 years from the date of commencement of the work, the contract would initially be signed for 1 year from the date of signing of the agreement. Full stop. Thereafter, the contract would be renewed every year subject to satisfactory performance. Full stop. In the present case, there did not arise any scope of satisfactory performance, since there was no performance at all, as the contract with the L1 bidder did not reach fruition. Full stop. Even if a liberal view in favor of the petitioner was to be taken, the failure on the part of the L1 bidder to comply with the standard operating procedure could only attract a non-renewal of the agreement of the L1 bidder at the end of the assessment year. Full stop. Since the contract being awarded to the next lowest bidder arises only on such non-renewal, comma, in the present case, the said situation has not arisen at all, comma, which might have conferred a right on the L2 bidder to invoke the said clause. Full stop. In such scenario, comma, it could only be held that the offer given by the respondent authorities on February 28, 2022 was dehorse the tender and was an unilateral offer given by the respondent authorities beyond the scope of the tender, comma, which was in any event not accepted as it is by the present petitioner. Full stop. In view of the above facts, comma, the respondent authorities were justified in floating a fresh tender on May 22, 2023 for the same work. Full stop. Next para, in any event, comma, there is nothing to prevent the petitioner. There was nothing to prevent the petitioner from participating in the said contract. Full stop. Since the bid submission closing date is today itself, that is June 13, 2023, and the time for filing the last bid is up to 5 p.m. today, comma, the petitioner will be at liberty to participate by filing a bid in the fresh tender by 5 p.m. today. Full stop. Nothing in this order shall preclude the petitioner from participating in the said fresh tender process, and if so, comma, the respondent authorities shall consider such bid, comma, subject to the same being otherwise valid in terms of the tender, comma, in due process of law. Full stop. However, comma, there is no scope of interference in the present writ petition. Accordingly, WPA 13370 of 2023 is dismissed on contest. With the above observations, no orders to cost.
My lord, may I just pray for stay of this order and
at this juncture, comma, the learned counsel for the petitioner makes a prayer for stay of operation of the above order. Full stop. However, comma, keeping in view the extreme urgency involved, extreme urgency implicit in the very nature of the tender, comma, which would cater to the medical needs of people coming from unfortunate sections of the society, comma, such prayer for stay is refused.
My lord, your lordship has granted today up to 5 p.m. My lord, today by 5 p.m. today it is not possible because the updation of documents, there are several complications are there to upload, and so it's difficult. To buy today by 5 p.m. my lord, it is very difficult to.
Online, yes, possible.
No, the documents are lying with the office of the petitioner, and my lord.
Communicate. Your petitioner's man is here. Communicate to them.
It is
they have already heard
it. It is required to be done in. It is a time-taking, cumbersome process, my lord.
Well, won't stall the tender process.
No, the time for the petitioner, if your lordship is.
If it is extended for you, it has to be extended for all, Mr. Lai.
Yes, I understand, my lord.
I cannot be unjust to the others, other
participants.
Many people might have participated if
by now, yes.
Yes.
But there's a practical difficulty by now at this short.
If I extend it till tomorrow, many people who would be in a position otherwise to participate won't be participating because they won't be knowing about this.
Well, that is true, my lord.
That I don't believe in, Mr.
My lord,
Lahiri. Yeah.
I'm grateful to your lordship, my lord. I'm extremely grateful. I tried my luck.
You tried your very level best and it was a very good try.
I'm grateful to you. I'm extremely grateful. 85.
85 years. 85 person. Yes, you're met. You're for the state.
Kindly, my lord, day after tomorrow, my lord, senior standing council.
Please use the microphone.
My lord, senior standing council argue this matter. My lord, matter is, my lord, forge the, my lord, SC/ST certificate, my lord. My lord, the all pleadings are completed, my lord. Kindly fix the any, my lord, time as your lordship.
What is your urgency?
Sir, she is not able to take admission in college.
When does it close? Oh, it is already closed.
Already closed. Once it had reserved.
When does the
only.
session start? Have you got any
Session
idea?
has already started. Sir, admission is closed.
Both of you can't argue together. One of you.
Sir, I'm already delayed for 5 months, sir.
5 months?
Yeah.
What is the course?
Sir, for MD, AIPGP.
Refused. On the last occasion, you tried to mislead the court.
No,
That
no,
has
no,
been
my lord,
recorded
my
by
lord,
Justice
no, no,
Bhattacharya.
no, my lord, what has happened, my lord? No, mislead the code, my lord.
You have got
I'm not-
several opportunities, Mr. Adok. You were there all along.
Yes,
You were there all along. So you must be ready in the matter.
yes, yes, my lord, I am ready, my lord, because my lord, my senior is there, my lord, matter, my lord, senior standing.
No, if
counsel.
your senior can't be there, I'm sorry. No, you'll have to do the
My
matter.
lord,
Yes, move your
my
matter.
lord, my lord.
Yes. What is the challenge?
Sir, challenge is.
Mr. Adok, please take your seat. I'll call up.
Uh,
One of you will argue, the other will take your seat. Whichever one you choose among yourself.
Yes, sir. Thank you. Sir, my challenge is for cancellation of scheduled caste certificate,
Yes.
which was cancelled by respondent number 2 on 15 December 2022. Which was issued on 21.
Show me the certificate. Give me the show me the certificate and the cancellation.
Okay.
Page 58 is the cancelled certificate.
Yes. No. This is the copy of certificate.
Very well. Yes. What is the ground of cancellation? Let us see that. Page 59.
Sir, ground of cancellation.
Take your time. Come to page 59 once.
59. The order of cancellation. Sir, ground of cancellation is due to we have applied to the Diamond Havra jurisdiction default. But in order, they have said that we can apply again to the Kolkata jurisdiction.
Let us see that relevant portion of the order. Page 60.
Sir, you are referring, sir, the petition copy.
No, your writ petition copy. Yes.
Sir, just a second.
Why did your counsel retire from the matter, ma'am? You had abused them or something like.
Oh, nothing, sir.
Something must have happened on the last occasion. With this.
Sir, I read last. Therefore, the undersigned is satisfied that Mr. Sonia Kevad had applied from an address where she is not an ordinary resident by this misrepresented of fact, and as per her ordinary resident evident from EPIC ration card and Aadhaar detail, she would have made her application for issuance of scheduled caste certificate to the office of the District Welfare Officer, Kolkata. Hence, in pursuant of Rule 3 of the West Bengal Scheduled Caste and Scheduled Tribe Identification Rule 1995, read with clause 12 of the memorandum number dated 27 July 2050, the certificate number so and so dated 9 December 21 is hereby cancelled and revoked with immediate effect. However, Ms. Sonia Kevad may apply to appropriate authority as per her ordinary residence again for issuance of caste certificate. All the concerned party may take note of this order and do the needful.
All your documents show a different address.
No, sir. It's a single address in 13B Dr. G.S. Bose Road.
Show me your. Have you annexed the Xerox, the photocopies of your Aadhaar card? Let us see. What is the address given in your application for?
13B Dr. G.S. Bose Road. We have two residential address in Dr. G.S. Bose Road. One is 13B Dr. G.S. Bose Road, Kolkata 39.
Yes.
And another is 6 Dr. G.S. Bose Road, Kolkata 39. Both are fault with same jurisdiction, Kasba Thana.
Gotcha. Have you annexed a copy of your application for scheduled caste certificate? Have you got a copy of that? The original application for scheduled caste
No,
certificate?
sir, that was misplaced by her when he got her certificate.
Yes.
Do you have copy of Aadhaar card?
My lord, may I assist the code? My lord, Aadhaar card already annexed with my
I'll come
activity in
to you. I'll
opposition.
come to you, Mr. Definitely.
Let me check, sir.
Where did you apply in the first place? Originally, where did you apply?
Originally 2014.
Before whom? Before which authority?
District of Kolkata. When the
No, the authority says sub-divisional officer Diamond Harbour says should have made her application for issuance of scheduled caste certificate to the office of District Welfare Officer, Kolkata. But you initially applied before the SDO Diamond Harbour.
Why we have applied
Why?
in 2014 when we have first applied to the district Kolkata office when it is situated in AGC Board Road near PGX site. The case was deal in that year 2000. They have taken 2 years time, but after that they have rejected our application saying that if your fourth father, grandfather first become the resident of Diamond Harbour, which we have mentioned in our reply copy and petition as well, you have to apply first your application to the Diamond Harbour jurisdiction.
Where is that order?
Sir, they have not mentioned our this point in their order, but they have said as well.
You got a copy of that rejection order?
Yes.
The first one.
Yes.
By Kolkata, District Welfare Officer, Kolkata. Mr. Adu, give me the page number. Only page number, then take your seat.
Page number 40 of this writ petition.
Thank you.
So may I read?
Yes.
Pursue application and documents submitted by the application along with inquiry report, hearing report, local inquiry report, and recommendation of the backward class welfare officer is the recommending authority for rejecting the case with detailed report. They have submitted a few documents like copy of rent receipt dated 3 December 1940 in favor of Kodai Shah, the entail license for 1944-45 in favor of one Kodai Niaria, claiming those to be the in name of their grandfather. However, name of the tenant or trade license holder do not match with the name of the application grandfather is that Kodai Ram Kevat. As evidence, who submitted a copy of Mirzapur municipal tax received in their father name dated 11th October 1991 and copy of one land deed of 1963 registered at Mirzapur UB. Further, they submitted a copy of Kishan Bahin issued in favor of their father on 10th July 1997 from Uttar Pradesh, mentioning his residential address to be UP in UP. Date of birth of Sonia Kevat 24/7/1989 and date of birth of Sneha Kevat is 28 March 1989. Apart from multiple hearings since 24 June 2014, local inquiry was also conducted on 14 in November 2014. However, during local inquiry, also no proof of their family residence in the claim address since 1950 could be obtained. Thus, the application have failed to prove their family settlement in the West Bengal since 1950.
Your documents were disbelieved. It was said you did not reside here. So that's why on that premise it was rejected.
Sir, I mean,
reference to any other, no liberty given to you to approach before some other forum.
No, they have not mentioned whatever they have said verbally. They have not mentioned in their order. After that,
did you challenge this rejection anywhere?
Yes, my lord. Yes, my previous order copy ka High Court ka. We have challenged. Sir.
Where? Before which forum?
In the High Court. 2014 sir. Order copy.
Page number 38, my lord, page number 38. Kindly. After that, my lord, order was passed.
38. Yes, sir. So may I- The petitioner applies for caste certificate online on 25th February 2014. She is aggrieved because her application is yet to be considered and disposed of. Having heard learned advocate for the parties, I direct the Secretary Backward Class Welfare Department to ensure that the appropriate authority competent to grant caste certificate dispose of the application of the petitioner as early as possible, but preferably within 6 weeks from the date of receipt of a copy of this order. If the petitioner application is rejected, a reason order shall be passed. On the contrary, if the petitioner application is accepted, follow up the step in accordance with law shall be taken without any delay. The writ petition stand disposed of without cost. Urgent photocopy, certified copy of this order, if applied for, be given to the parties as expedient as possible. Sir, this is the as per the order of the Honorable High Court, Kolkata, the undersigned is forwarding here with a copy of order sheet stating the reason for rejection of your
But the
application.
present rejection is valid in law. I mean, why is it irregular?
Sir,
The subdivisional officer, Diamond Harbour, says you are residing in Kolkata. All your now the Aadhaar cards and whatever documents you now produce, you had not produced on the last occasion.
Sir, we have produced, sir. Sir,
Last occasion.
Sir, both occasions, sir. We have given our all original documentary proof in both occasions, in 2014 as well in Diamond Harbour.
In 2014, what was considered was your municipality tax receipt, rent receipt or something
Sir,
like
there is the point. They have mentioned the documents which are not valid for issuing the certificate. But whatever we have given them, there's one rent copy agreement, rent receipt, which prove that we are a resident of West Bengal. They have not mentioned in their order. Secondly, when we have applied Diamond Harbour after taking advice from one agent and from the department officer that your forefather, grandfather become first residential of Diamond Harbour, you should approach to Diamond Harbour for local inquiry. It can be issued.
Madam, they just clarify this to me.
Okay.
On 4th of December 2014, at page 40, 2014, your application was rejected for the first time by District Welfare Officer, Kolkata. That was in 2014. After that, this court, High Court, passes an order on December 1, 2015, on a subsequent date, after 1 year after that, saying that you have applied for a caste certificate online on 25th February 2014, which has already been rejected before this order was passed by the High Court.
So we have challenged the cancellation to the High Court.
But the High Court order does not reflect this. High Court order says, having heard both sides, I direct Secretary Backward to ensure that appropriate authority disposes of the application of the petitioner. It had already been disposed of at that point of time. So this was an erroneous order. You must not have pointed out. On December, I am referring to page 38 and page 40 together. Page 40 shows on 4th of December 2014, your application was rejected already.
Yes.
It stood rejected.
Yes.
So that application which you made online on 25th February 2014, that had already been rejected in December that year. After that, you moved this court, High Court, against that. But the High Court says, directs the authorities to dispose of that application only, which had already been rejected.
Sir, I'm not getting why dispose.
I'm also not getting.
Sir, that time she is handicapped. That time she is suffering from knee.
Actually, I'm suffering with the rheumatoid arthritis, which is incurable. It's a autoimmune disorder, sir. Right now, last 2021, I'm done. TKR done. Total knee replacement done. 2021, sir. Sir, these all incidents happened.
I fully empathize with you.
Yes,
I can sympathize also. But what happened in 2015 when this court passed the order directing the authority to decide the matter?
Yes, sir.
On the presumption that it was pending at that point of time.
Yes, sir.
But it was actually not pending. So there was no scope of any direction. His Lordship directed your application to be decided. And if rejected, reasoned order to be passed. Now it was rejected and a reasoned order was passed previous there too. So there is no question of further hearing.
Attachment दिखाओ 2014 का attachment दिया
So
हुआ है.
in law, you are not entitled even to prefer the second.
Sir, kindly please look the page number 40. So sign will be 14, 12, 14. Please.
2014.
14 years.
And reply, sir. Reply.
As in 2016.
16.
Which reply?
Sir, later dated 6 January 2016.
Which page?
Page 49.
Page
Now.
number 39.
39.
Yes, sir.
6 January 2016.
39 is on the communication of the order of this court. No, you don't get this. In 2014, your application is rejected. You challenge that before High Court. High Court says, having heard learned advocates, High Court directed the competent authority to decide your application. It was further observed by the High Court, if the petitioner's application, your application is rejected, a reasoned order shall be passed. On the contrary, if it is accepted, then follow-up steps. Now, your application was rejected. It went back to the authority. This order went back to the authority. After this, the authority replied to this by saying, as per order of the Honorable High Court, Kolkata, the undersigned is forwarding here with a copy of the order sheet, stating the reason for rejection. So, authority first rejects. You move this court. This court says, decide. And if it is rejected, give reasons. Then the authority says, I have got the order of the High Court. In compliance with that, I am communicating my previous order in which there was a rejection and reasons have been given. So this order does not help you. Your application has been rejected.
That time, sir, we are.
So difficulties unless you seek a recall of the High Court's order, that's a technicality. But as of today, your application stands rejected in the year 2014.
14.
High Court directed the asked reasons, asked them to give reasons. They have said that already reasons were given. So your rejection, after your rejection, how can a second application be maintainable at all?
Sir, when we have approached, sir, we are in search of the proper document. Again, we have applied. They have said us.
See, ma'am, I think the most prudent action for you is to comply with the order which you have challenged. Here, a liberty has been reopened for you to approach the District Welfare Officer, Kolkata. Avail of that opportunity, get it. Otherwise, you won't be getting future opportunities also.
But when
Under law, you don't have this right because your application was rejected once, not set aside by any court. Now you don't have a right to challenge for a second time. But this challenge was erroneously entertained by Diamond Harbour. Diamond Harbour said, no, you have to apply before the District Welfare Officer, Kolkata. But you don't have that right even to apply before the Diamond Harbour or District Welfare Officer, Kolkata. Your application already stands rejected. So, but since it has been opened for you, I can give you liberty to comply with this order by producing the further documents which now you have acquired. These documents you were not referred to in the previous rejection.
But sir, when the Diamond Harbour issued the certificate, they have
You go to the district
they
welfare
have
officer.
seen our all order copy. They have satisfied with local inquiry that we have belonged to the scheduled caste and now they are submitting that our document which they have issued on the basis of which inquiry they have issued our certificate. All documents are misplaced from their record. So, sir, only we are going to suffer. Then how can department had issued the certificate? If if our first application got rejected in 2004, we have shown them to all our previous application why we have come to Diamond Harbour. They have asked us question why you have come to Diamond Harbour. Then we have narrated our fact. After due satisfaction and due inquiry, they have verification of document. They have accepted our application and processed the application. And after 1 year, they have cancelled the certificate when I have applied to the District Welfare Officer, Kolkata.
No certificate was granted to you in the first place. What was rejected? What was cancelled?
Certificate 9 December, the certificate was issued on 9 December 2021 by Diamond Harbour. This certificate was cancelled by the issuing authority.
Where is that certificate?
Sir, I have given
That cancelled one. Now the one which you handed over, right?
Yes, sir.
Sure,
After all due process.
let me hear them. Please take your seat. Mr. Adab, you had issued a subsequent certificate. Good, bad, indifferent.
What is happened, my lord? I satisfied before your lordships. My lord, kindly, my lord, have a look. Government notification, my lord. I have page number 26 of my affidavit in opposition.
Please take your seat. Yes. I'll call upon you again if necessary. Page 26. Yes.
My lord. This is the government notification, my lord. Because, my lord.
Page 26.
affidavit in opposition, my lord. I have
Yes.
filed.
H.
My lord. As per my lord, government notification, my lord, Diamond Harbour, my lord, because my lord, his address shows it is a, my lord, under Kolkata Municipality Corporation and my lord, under jurisdiction of the Kolkata. My lord, here, my lord, kindly, it is, my lord, is it exercise power confirmed under section 5 of the West Bengal scheduled caste and scheduled tribes, so and so, so and so. Notification. Government is pleased to notify that caste certificate under section 3 or section 4 of the said act in respect of the Kolkata as identified in the clause 9 of section 2 of the Kolkata Municipality Corporation Act be issued by the District Welfare Officer, Kolkata. My lord, he has no jurisdiction because, my lord, his PAN card, Aadhaar card, and my lord, voter ID card, even also, my lord, all shows, my lord, address is Kolkata. My lord, his suppression of this fact, my lord, he, my lord,
Suppression. Diamond
no,
Harbour issued
no,
the caste certificate.
my lord,
They have
what
these
has happened,
documents.
my lord, what has happened, my lord, my lord, lot of pressure, my lord, after scrutinize, my lord, kindly have look the after scrutinize, my lord, I have annexed.
What is your business? I don't understand these things. Diamond Harbour issued erroneously. It did not have
Yes.
jurisdiction.
After, my lord,
Who is the person who re-agitated the issue, who made the complaint? Who is that person?
yes, my lord, page
What
number.
was the occasion? Because they could not satisfy your client. What was the occasion for this complaint? Your own mistake. Diamond Harbour issued, and now you are saying Diamond Harbour itself is saying, no, I was wrong in issuing. Now go to district. They cannot run from pillar to
my
post.
lord,
They have the documents. It was issued.
I have
Who
searched,
lost
my
the
lord.
complaint? Let us see who lost the complaint. Why the complaint was lodged?
My lord, kindly have a look that 22, my lord.
Page
My lord, we are-
59. Page 59, court sheet. Come to the order at page 59. A letter was received from somebody. DWO, District Welfare Officer,
Yes.
Kolkata.
Yes.
Yes. My lord, kindly have these, my lord, some documents, my lord, shows before your lordships. Why, my lord, I rejection, my lord, my lord, SDO, my lord, Diamond Harbour rejection this, my lord, AC certificate, my lord. Kindly have a look this, my lord, two documents, my lord. I have shows before your
One
lordship.
is Neha Khetawat, one is Sonia Khetawat.
Yes.
Now we are hearing Miss Sonia Khetawat's matter.
Yes.
So Sneha Khewat did not challenge.
My lord, what has happened, my
Who is
lord?
Sneha? You.
Yeah, I'm Sneha, she is Sonia.
So you did not challenge your cancellation.
Says, because certificate was cancelled her.
Your certificate was not
No,
cancelled.
no, I have, why this, her certificate was cancelled, I tell you, my lordship, I am explaining you, when her certificate was issued by Diamond Harbour after all due procedure compliance, that after that they have said, now you are the, this is the first certificate we got in our family. Okay. After that, they told, now you are, you can apply to the district officer Kolkata for only one certificate. আমি এক লাইনটা বাংলাতে বলছি, উনি বলেছিলেন কি,
আপনি বাংলাতে বললেও কোনো অসুবিধা নেই, আপনি
উনি
বাংলায় বলুন,
উনি
কোনো
উনি উনি বলেছিলেন কি আপনার শুধু একটা সার্টিফিকেট এখান থেকে প্রসেস হবে ডায়মন্ড হাবড়া থেকে, যা প্রসিজার ওদের ছিল লিগ্যাল
আপনি
ইনকোয়ারি।
কি হিন্দিতে বেশি কমফোর্টেবল? তাহলে হিন্দিতেও বলতে
हाँ
পারেন।
सर, हिंदी में भी।
যেটা আপনার সুবিধে সেই ভাষায় বলুন,
तो
কোনো অসুবিধা নেই।
सर उन्होंने फिर बताया कि आपका एक सर्टिफिकेट जस्ट बिकॉज ऑफ सी वो हैंडीकैप है, उसको बार बार कोलकाता ऑफिस, डायमंड हार्बर ऑफिस करना होगा। तो उन्होंने एक सर्टिफिकेट इशू किया और मुझे बोला कि आप कोलकाता ऑफिस में जाओ अप्लाई। तो उनके इंस्ट्रक्शन के अनुसार मैंने कोलकाता ऑफिस में, जब मैंने जून 22 को अप्लाई किया, उसके मैंने एक इंटरव्यू में अपीयर किया था। इंटरव्यू से मेरा एक लेटर गया था डिपार्टमेंट को कि इनका एप्लीकेशन जल्दी प्रोसेस कर दिया जाए, बिकॉज शी हैज वो इंटरव्यू में सिलेक्टेड हो गई हैं इसके लिए। तो उसके बाद डिपार्टमेंट में इंक्वायरी स्टार्ट किया कि ये डायमंड हावड़ा से क्यों इशू हुआ है। तो वो इंक्वायरी गया फिर डायमंड हावड़ा को, और उस इंक्वायरी लेटर के साथ सारे डॉक्यूमेंट्स।
आपका सर्टिफिकेट कोलकाता ऑफिस ने ही इशू किया?
नहीं, हमारा इशू नहीं किया, मेरा एप्लीकेशन उन्होंने रिजेक्ट कर दिया इनका कैंसिलेशन के बाद। इनका पहले कैंसिलेशन के मैंने अप्लाई किया इनके सर्टिफिकेट के बेसिस पे, क्योंकि मैं इनकी ब्लड रिलेशन में सिस्टर हूँ। तो इन्होंने इनके सर्टिफिकेट पे इंक्वायरी
आपका
बैठाई।
कैंसिल करने का वक्त ये बोला कि ये इनका भी सर्टिफिकेट कैंसिल होना चाहिए।
हाँ, हाँ, इनका कैंसिल क्यों होना चाहिए? तो सर अगर वो कैंसिल कर रहे हैं, इशूइंग अथॉरिटी को पता
आपका सर्टिफिकेट क्यों कैंसिल हुआ? आपका
सर
एप्लीकेशन
मेरा एप्लीकेशन रिजेक्ट हुआ, इनका सर्टिफिकेट कैंसिल हुआ है।
आपका एप्लीकेशन क्यों रिजेक्ट हुआ?
वो ग्राउंड दिया है क्योंकि इनका सर्टिफिकेट कैंसिल हुआ है। इनका सर्टिफिकेट कैंसिल हुआ इसलिए मेरा एप्लीकेशन उन्होंने रिजेक्ट किया है।
आप जब अप्लाई किया, वो
हाँ।
कोलकाता ऑफिस में अप्लाई किया, आप जब,
हाँ
तो तब पहले आपका वो एप्लीकेशन कैंसिल हुआ या
नहीं, पहले इनका
आपका जब पेंडिंग था, जब एप्लीकेशन पेंडिंग था, तभी ये कंप्लेंट गया है वहाँ?
हाँ,
अच्छा, तब फिर उनका कैंसिल हुआ,
फिर
तो
मेरा
उसके ऊपर आपका भी कैंसिल हो गया?
रिजेक्ट हो गया, एप्लीकेशन रिजेक्ट हो गया। सर मेरा क्वेश्चन ये है कि वो इशूइंग अथॉरिटी उनको पता है लॉ की, उनका जुरिडिक्शन कहाँ है, वो कोलकाता म्युनिसिपैलिटी में होना चाहिए, तो वो
हमने समझा, ठीक है, ठीक
सर्टिफिकेट
है।
इशू करके कैंसिल किया है।
तो आप डिस्ट्रिक्ट कोलकाता डिस्ट्रिक्ट वेलफेयर ऑफिस में क्यों नहीं जाते अब?
सर डिस्ट्रिक्ट कोर्ट नहीं गए क्योंकि इनका जब 1 फरवरी जिस दिन
तो लीव दिया गया है, यहाँ लीव तो दिया गया है ये ऑर्डर पे।
एक्चुअली हम अब तो देख रहे हैं लास्ट हियरिंग में एडवोकेट के साथ कुछ डिस्प्यूट होने के लिए उन्होंने जज के सामने जाके एनओसी दिया, हमें कुछ मालूम नहीं था, उसके बाद हम लोगों ने
ठीक है,
in
फिर
person-
आपका तो ये जो ऑर्डर चैलेंज किया आपने,
हाँ
इसमें तो आपका लिबर्टी दिया हुआ है कि सोनिया
सर
खटेवत
लिबर्टी दिया
केवल
हुआ है सर मैं बता रही हूँ आपको, वो लिबर्टी दिया हुआ है, पर अगर हम उस प्रोसेस में जाते तो इन्होंने इस साल फर्स्ट स्कोर किया है रैंक एमडी कोर्स में, जो WPGIC, वो रिजल्ट इनका लैप्स हो जाएगा सर जब तक ये प्रोसेस में हम जाएंगे। ये लास्ट 8 ईयर से सर एग्जाम के लिए प्रिपरेशन करी, 2014 में भी इनका रैंक आया था और इस ईयर भी रैंक आया है। अगर ये इस ईयर भी एडमिशन नहीं ले पाएंगे तो सर इनका करियर लॉस जाएगा। सर मिनिमम 2 इयर्स सर, एक एग्जाम के लिए मिनिमम 2 इयर्स ये प्रिपरेशन करती हैं।
इसके लिए लास्ट डेट, अगर आप ये ऑर्डर आपके फेवर में, आज ये ऑर्डर ये आपके फेवर में पास हो जाए, तो फिर आप कब तक वो एडमिशन ले सकती है?
सर वो मेरे लिए नेक्स्ट डे वो एडमिशन दे सकते हैं कॉलेज एज पर ऑर्डर।
लास्ट डेट कितना है, कौन है?
सर फैब मैच में
ये लिबर्टी आप कितने डेट तक पाओगे?
16/6 sir. 16/6.
16/6 ओ 16/6
The stay order validity up to 16/6 23 years sir.
Very well, बैठिए. Yes, what can be done? She has scored high marks due to your fault.
No, my lord, kindly have a look. This page number 17. My lord, kindly 2 minutes, my lord. My lord,
Satisfy me, Mr. Adok, on the grounds on which a scheduled caste certificate can be cancelled. Only satisfy.
yes, my lord.
Show me the
that's
law.
right. My lord, page number 17. Page number 17 in my opposition. My lord, affidavit in opposition, my lord. We sent a notice, the address of the Diamond Harbour.
No. Show me the grounds, the regulations or the law, whatever.
Yes, my lord, I can show, my lord. Before your lordships, my lord, I satisfied, my lord, 2 points. Also, my lord, factual facts, my lord.
No, what are the grounds on which their certificate can be cancelled?
Yes, my lord, this is not the jurisdiction, my lord, because, my lord, address shows, my lord, as per law, my lord, as per government
They
notice.
misrepresented the address at the time of filing of the application. Then I can understand it can be cancelled on that ground. What is their fault? They applied properly. They applied before Diamond Harbour for whatever reason. Diamond Harbour entertained, granted them caste certificate.
My lord, we verify these documents, my lord. This file is not, my lord, this is the, my lord, under the subdivision SDO office, because, my lord, everything is suppression. Because, my lord, we sent a notice, we sent a, my lord, local officers, but they are not residing that place, my lord. Everything shows, my lord, this is the jurisdiction of the Kolkata. When, my lord, we came the knowledge before your, before the SDO subdivisional officer, my lord, we, my lord, sent officers, BDO office, my lord, everything, my lord. This is the, my lord, municipality, local municipality. They shows they are not residing that place.
By memo number such and such dated 6th of September 2022. Do you have a copy of that memo? In pursuant to that, no, the caste certificate was initially given to her, issued to her.
Yes.
When was that given? Show me that.
My lord, caste certificate issued because
The one which is being cancelled, when was it issued to her?
9 December 2021.
Have you?
Nine,
There's a
that is the
date was
copy you have handed
mentioned,
over.
certificate.
Yes.
20.
This have you got another extra copy of this?
Yes, sir. We have,
Give it
sir.
to him, Mr. Adok.
no, my lord, 19, my lord, page number 19 in my opposition, my lord. I have, my lord.
You have
Yes,
page 19 of the opposition.
I have affidavit in opposition, my lord.
Cancel.
22 में cancel.
Pass हुआ है, ये मिला है हमको.
हम सही बताएं।
Right. Yes. Yes, Mr. Adok, why was that granted in the first place?
My lord,
It was granted already by Diamond Harbour. How could it be granted then?
my lord, actually, my lord, what has happened, my lord?
Only on the ground of lack of jurisdiction, it is now being cancelled.
My lord.
How can it be?
No, my lord, what has happened, my lord? This is the
No,
problem is the jurisdiction. First point is the jurisdiction, my lord. Second point is the suppression of the facts because, my lord, he got another.
Suppression of fact has not been quoted in the as a reason in this order, in the impugned order. Impugned order gives only one reason.
Yes. My lord, this
The
is
reason is
one,
that Diamond
one,
Harbour did not have
one reason is sufficient because, my lord, as per government, my lord, I shows before your
It's
lord.
your fault.
Page number 26, my lord.
Sir Adok, I'm repeatedly asking you,
Yes,
show me
yes,
from the
this
rules.
is my fault, my lord.
Not
Yes.
that. Show me from the rules. What are the grounds for cancellation of scheduled caste certificate?
Yes, my lord.
Show me that.
This is the, my lord.
Before
page-
going to something else, please show that first.
Yes, my lord. So, my page number 26 of my affidavit in opposition, my lord. This is the only grounds, my lord. My lord. My lord, this is the notification, my lord, dated, my lord.
Have you got a copy of this act, section 5?
Yes, my lord. I have.
Give me a copy of that. Give me section 5. As amended by 14th January 2013 modification, notification. Acha, Mr. Adok, how soon can, suppose if I direct the authorities to transfer the entire documents to Kolkata district office or to act on the annexures made here, then how soon can they decide it? No, they cannot do it within 16th in any event.
Within 16, my lord.
It can be reconsidered by the Kolkata office, but without that certificate being cancelled. She has to be permitted to participate in whatever. On the basis of the cancelled caste certificate, I'll set aside that cancellation, and the certificate will be operative till it is reheard by you. It will be in an irregular order, sort of, but so that she can participate in this academic year. Otherwise, she'll lose a year despite having come first somewhere.
Yes, my lord. This is the difficulty, my lord. Kindly, my lord, send to the, my lord. If, my lord, if send to all documents.
I'll direct the Kolkata office to reconsider her application and then.
According with law, my lord.
According to law, she'll produce all the documents again.
Yes, my lord.
But Diamond Harbour issued that certificate.
Lordship,
Cancel the certificate because, my lord, lack of jurisdiction, my lord. Lack of jurisdiction, my lord.
Yes, because that is my problem. Otherwise, on merits, Diamond Harbour held that they have a right to get that certificate.
so yes,
The entire thing will be revisited now.
My lord, section here, my lord, notification, my
So
lord.
I'll say this. I'll say that your certificate, caste certificate, is cancellation. I'll set aside for the time being, but there will be a fresh inquiry by the Diamond Harbour District Welfare Officer, Kolkata.
सर लॉर्डशिप आई वांट टू सबमिट 2-3 पॉइंट्स मैं और बताना चाहूंगी लॉर्डशिप उन्होंने अपने एफिडेविट इन ऑपोजिशन रिप्लाई में उन्होंने बताया है कि सारे डॉक्यूमेंट्स मिसप्लेस्ड है उनके रिकॉर्ड से आप एफिडेविट इन रिप्लाई में सर इन पेज
Affidavit in opposition में.
हाँ एफिडेविट इन ऑपोजिशन फाइल्ड बाय रेस्पोंडेंट नंबर 2 कि उन्होंने एक्सेप्ट किया है कि हमारा एप्लीकेशन उनके अंडर से प्रोसेस हुआ है बट हमारा सारा डॉक्यूमेंट अलोंग विद एप्लीकेशन अलोंग विद सपोर्टिंग डॉक्यूमेंट सब कुछ इनके रिकॉर्ड से मिसप्लेस है तो वो डॉक्यूमेंट क्या ट्रांसफर करेंगे कोलकाता ऑफिस को क्योंकि उन्होंने अपने सारे डॉक्यूमेंट्स ही मिसप्लेस है डॉक्यूमेंट और सर फिर अगर हम फिर से प्रोसेस करने जाएंगे सर ये तो फिर 1 साल 2 साल का टाइम लेंगे वो फिर हमारा करियर लोड हम फाइनेंशियल
आपके पास वो डॉक्यूमेंट्स है तो अभी आधार कार्ड वगैरह तो है तो
हमारा सब कुछ है डॉक्यूमेंट
आपका प्रोसेसिंग रिप्रोसेसिंग देखिए ये डायमंड हार्बर का जुरिस्डिक्शन नहीं था ये फैक्ट है क्योंकि आप लोग कोलकाता में रेसिडेंस है
सर
आपका आधार कार्ड से मालूम होता
सर वो एक्सेप्टेबल है
अगर वो एक्सेप्टेबल है तो फिर वो फ्रेश इंक्वायरी डिस्ट्रिक्ट ऑफिस कोलकाता डिस्ट्रिक्ट ऑफिस से तो होना चाहिए क्योंकि डिस्ट्रिक्ट ऑफिस कोलकाता डिस्ट्रिक्ट वेलफेयर ऑफिस ही आपको सर्टिफिकेट प्रदान कर सकते हैं सो वो तो नहीं हुआ अभी तक अगर नहीं हुआ तो कोलकाता ऑफिस को तो ये री इंक्वायरी करना ही है प्रॉब्लम ये है कि आपके इसके बीच में आपका ये ईयर चला जाएगा, नष्ट हो जाएगा, क्योंकि आपका ये सर्टिफिकेट नहीं होगा,
नहीं होगा
कैंसिलेशन हो गया। ये कैंसिलेशन में अभी सस्पेंशन में रख देता हूँ।
सर।
ये सपोज 6 महीने के लिए सस्पेंशन में रहेगा ये कैंसिलेशन, ये वैलिड रहेगा। मालूम है कि मतलब है कि ये वैलिड रहेगा 6 महीने तक। और 4 महीने के अंदर मैं उनको बोलूंगा कि कोलकाता डिस्ट्रिक्ट ऑफिस को बोलूंगा, आप लोग डॉक्यूमेंट्स फर्दर देंगे, 2 हफ्ते के अंदर आप दे सकते हैं,
सर
जमा दे
हमारे पास
सकते हैं।
जो
आप सुनिए, पहले दे सकते हैं डॉक्यूमेंट्स जो है,
हाँ 2 वीक के अंदर दे सकते हैं।
2 वीक के अंदर आप
हाँ।
डिस्ट्रिक्ट ऑफिस कोलकाता को दीजिएगा, वो फिर ये प्रोसेस जारी करेगा, वो फ्रेश सर्टिफिकेट इशू करेगा,
सर
अगर लॉ में आपका एंटाइटलमेंट हो तो।
सर वो सर सेटिस्फाई हूँ
सीनियर काउंसिल जो भी कहे यही है होगा।
सर, वो जो भी है, पर फॉल्ट तो उनका है सर कि उन्होंने इशू किया है। सर उनके फॉल्ट में जो उन्होंने इशू किया है सर, ये आपका ही जजमेंट है सिमिलर केस में सर कि ये कैंसिलेशन रॉन्ग है, क्योंकि इनके पास ऑथोरिटी ही नहीं है कैंसिलेशन करने का। ऑथोरिटी
कोई जजमेंट अप्लाई ये भी करेंगे, क्योंकि ये बोलेंगे कि ऑथोरिटी नहीं था इसलिए ही ये कैंसिलेशन हो जाएगा।
हाँ इसको
उस पे मत जाइए। Yes, Mr. Banerjee, how can you satisfy? I mean,
No,
one.
if your lordship, if I just can hear what your lordship view is,
I'm telling
your
you, I'm
lordship was very, very clear.
Definitely. Now, Mr. Banerjee, the difficulties initially their application was rejected by Diamond Harbour Authority.
By Calcutta.
By Calcutta Authority. Thereafter, another application was made before Diamond Harbour, but that was allowed and certificate was given to them. After giving the certificate, must have been satisfied. Diamond Harbour must have been satisfied with their document.
No. There is no record of Diamond Harbour, there's only the certificate is there. Then, if your lordship sees my affidavit, there is no record of issuance of the certificate. That is
You have lost from your.
This is manipulated. Somehow this record certificate has been drawn up. When this thing got caught, how? Because emboldened by this certificate, which your lordship is seeing in your lordship's hand, the sister applied for the scheduled caste certificate. Then when the scheduled sister applied in Calcutta, so then they said this one was issued by Diamond Harbour. So they referred it to Diamond Harbour for cross verification. When they check the file, there is no document available. There is this certificate alone. So that is why, because she would have got the certificate, nobody would have come to know also. Because there is no back record of anything. Now, Calcutta, when the sister applied, there's one expression in Bengali, when one gets very greedy, lobe pap.
No, sister applied in Kolkata.
Kolkata, because all their documents are in Kolkata. Diamond Harbour has no jurisdiction. There is no, I have in my affidavit, but not annexed all the documents.
But Diamond Harbour initially referred to certain documents when they produced those drain.
Nothing.
No, there was a previous rejection also.
No, Calcutta rejected.
Oh, Calcutta rejected.
Calcutta rejected. Their documents were all from Calcutta.
No, those documents were of Diamond Harbour probably.
No.
Oh, those rent receipts were also of Calcutta.
Everything is, your lordship sees all the documents necessary were of Calcutta. Diamond Harbour, there is no track. Now, Kolkata, they applied. In fact, there was an order to dispose of the application by this court. Ultimately, it was disposed of rejection. Thereafter, they quietly went to Diamond Harbour, got this great thing done. And if she would have been happy with that, she would have survived herself. Nobody would have known anything. But what happened is, using this, because as your lordship knows, they have to give reference of other people who are on the scheduled caste and these things, they have to give the other family member relation. So they try to use this certificate for the sister to get. So when the sister applied with this certificate, then they referred it to Diamond Harbour that you issued this certificate. Then they find Diamond Harbour does not find any record. In fact, there was a inconsistency of the jurisdiction also over there.
But it has been rejected, cancelled now only on the ground of jurisdiction.
Now what has happened is, when they went, now Diamond Harbour started conducting inquiry. So Diamond Harbour went to all these places where they have referred to as their house, their details. Now there they find there's no existence of this particular person. So when they found that there is no existence of this particular person, then they cancelled it after conducting an inquiry. This is the factual scene.
If Diamond Harbour did not have jurisdiction, then the order is right. I mean, they inquired whatever. I mean,
there is no track of this person. Because there is no back record. When I issue a certificate, there will be a master.
Mr. Banerjee, there is something else. Please come to page 60 of the writ petition.
Then can I argue tomorrow?
Just
I know the facts of the case.
no, see page 61 on the facts which you said.
60 of the writ petition.
60 of the writ petition. That is the ordering portion of this impugn order, cancellation order.
Yes.
Just see the last paragraph. Therefore, the undersigned is satisfied. Undersigned is Diamond Harbour. He or she was satisfied that Miss Sonia Khewat had applied from an address where she is not an ordinary resident by misrepresentation of fact, and as per her ordinary residence evident from EPIC, ration card, and other details, she should have made her application for issuance of such and such to the office of the. Therefore, this means indicates clearly that she has documents to show her residence in Kolkata.
Yes, she has residence in Kolkata. Kolkata refused it on different grounds that she does not come within the category which should be scheduled caste. This is not Kolkata. Not
that Kolkata rejection was on the ground that the documents produced by her, those were different documents, rent receipts and other things.
No. May I say, Kolkata jurisdiction is that is exactly what I had got ready many days ago. I'll tell you, she did not qualify in the caste.
Please come to page 41. You can get ready now also, Mr. Banerjee, because you're just brush up. Page 40. I'm only concerned about her academic year expiring on day after tomorrow. The day after that. So these are on a different ground. UP and all documents were provided by her, whose are not accepted. So on that ground, it was rejected by Kolkata.
Because today UP and all
were produced at that point of time.
Because she hails, today she says she belongs to a scheduled caste because she hails from this particular area which is of the scheduled caste area. This was because on the merit of the scheduled caste application, she resides in Kolkata. She gave the document, because if your lordship takes my affidavit, I have all the documents of hers which she has given, EPIC card, whatever.
All of Kolkata.
All of Kolkata.
She has annexed that in the writ petition also.
Yes. So all that is that so ordinarily she should have applied in Kolkata. So and she did. But they rejected her.
Rejected her on the ground, submitted a few documents like copies of rent receipts in favor of someone, trade license, claiming those to be her grandfather.
That is of UP.
Those were of UP.
Yes.
Mirzapur municipal. So grandfather's documents were produced at that point of time.
May I just take 1 minute?
That's why Kolkata refused.
1 minute. No. She said that she hailed from, say, let me take a factual. Let's for a moment, not from here. Let me say, I am a resident of London. Now, if
London is a good example for the state. Let us proceed on that premise, Mr.
Okay.
So there are certain features of London in Calcutta also.
Yes, absolutely. So today, if I say that I am a resident of London,
yes.
So today I should be able to produce a British passport. Should I produce possibly the tenancy documents of London City and things like that. Now today, and I applied over from Calcutta. Now I am a resident of Calcutta. There is no dispute. But the documents I furnished of London were not correct. So these are documents of
That's
UP
why it was rejected.
Yes.
Now she is producing documents of Kolkata, Aadhaar card, EPIC, etc., etc.
But she had, for coming under the purview of scheduled caste, because she comes from this particular caste, her grandfather stayed there. For that, because resident of Calcutta doesn't get a thing.
So she cannot lose it both ways. Mr. Banerjee, first Kolkata office says that local inquiry did not. Anyway, on merits, suppose district.
On merits, she can lose it. I'll tell you why she can lose it.
Yes.
Today, I say that, let me go back to this example, that I come from this place X in UP, and that my grandfather's name is this, my grandfather's address is, my grandfather's caste is
UP.
All that is in UP, and we belong to scheduled caste. Now, because scheduled caste, scheduled tribe comes only by birth. I cannot become somebody. So today I hail that my scheduled caste and everything, I track my family back that so and so these are my family members who are in UP, which is a scheduled caste. That is why I am claiming myself to be a scheduled caste. But today I am staying in Calcutta. These are my details. This is the details of my predecessors from where I'm claiming my right as a scheduled caste. So for that, so then the jurisdiction of Calcutta was, there's no dispute because she's a resident over there. But the dispute comes in the merit of the application. When they cross-check whether these were, she was at all a scheduled caste having a residence at this
Exactly, on merits it was dismissed by this.
Yes. So merits is
Kolkata.
dismissed.
Yes.
So that's why she loses on the merit part of it.
Hmm.
So on this now, then what happens? Once her application is dismissed on merit, not on the point that Kolkata did not have jurisdiction.
Yes.
Thereafter, she arranges for issuance of a certificate from Diamond Harbour. Now, this certificate was issued. Nobody knows anything. There's no record, nothing. So, but a certificate comes out in her name. Now, if she would have kept quiet, sat tight,
So
nobody.
that is proceeding on the presumption this is a fictitious document.
Which one?
It may also be the Diamond Harbour one.
There's no record of this time. It is. I see this.
Records.
Because I tell you, Lordship, where.
Was there a formal inquiry on this?
Yes, there's field inquiries on this. I've annexed with my affidavit. There was inquiry.
But the ground on which it rejected was Diamond Harbour rejected. It was referred to Diamond Harbour, saying that it was.
I'll just state it to me. Then what happens, Milord, is that she gets this particular document from Diamond Harbour. Now, would have not been any problem. She continued at a scheduled caste herself. Then she gets emboldened by this particular certificate of being a scheduled caste. She applies in Calcutta again. And this time, with reference is drawn, like her reference was drawn with maternal uncle or somebody in UP. Her reference is drawn to her sister, this lady, is drawn over here in Calcutta. Now, Calcutta sees her certificate, this perfectly good, everything's fine. But he says that I send it to Diamond Harbour for cross-verification. Now, when Diamond Harbour gets it for verification, they come to know that there is no track record. Then there is no file number, nothing. They're supposed to be here. Those details are not there. Then they carry out an investigation. There is no track, nothing. Ultimately, Diamond Harbour, having the issuing authority, has cancelled. This is the crux of this. Because that is why she lost both ways.
So now it has been given, liberty has been given to her to approach Kolkata.
So, yes. So now Diamond Harbour, so she's not a resident of Diamond Harbour. So she can't get a certificate from Diamond Harbour. But I would say this is very honorable of these officers that they are not vindictive. That if you want, you are a resident of Calcutta, go to Calcutta. If you want to apply, you apply, go. They don't have any vindictive say that you are a resident, all your documents are of Calcutta, go to Calcutta.
What happens if she goes to Calcutta now?
She'll have to try again. If her
will
fate will be sealed because she doesn't have on merit. She doesn't have. She's not entitled for it. Because it goes back because the last on merit it was the last time. So that is why she had gone, because they don't want this inquiry business to come out. If she's not entitled, she's not entitled.
Yes, what is your answer to this?
सर इनके अनुसार हमने ये जो बोलना चाहते हैं कि हमने किसी और वे से ये सर्टिफिकेट पाया है। सर अगर हमने किसी और वे से सर्टिफिकेट ये पाया है तो इन्होंने किसी और वे से इशू कैसे कर दिया? मींस अथॉरिटी जो है वो किसी और वे से
बोल रहे हैं कि इशू ही नहीं किया इन्होंने।
ये
इन्होंने इशू ही नहीं किया।
सर ऑनलाइन
फॉल्स सर्टिफिकेट है।
वो ऑनलाइन में सर अवेलेबल है।
मिस्टर बैनर्जी बोल रहे हैं
ऑनलाइन में अवेलेबल था बिफोर कैंसिलेशन, वो ऑनलाइन में भी अवेलेबल है। ऑनलाइन में अवेलेबिलिटी होने के बावजूद भी ये सर्टिफिकेट फॉल्स हो सकता है सर।
11 months 20 days the certificate is valid sir.
सर इन्होंने जब अप्लाई किया था एग्जामिनेशन के लिए तब भी वो वैलिड था। मींस उनके फॉल्ट की वजह से सफर हम करें, वो हमारा
There is a dispute as to whether this is valid or not. That dispute is there.
अगर ये वैलिड नहीं है लॉर्डशिप तो ये इशू इनके भी फॉल्ट है कहीं कि ये इशू कहाँ से हुआ?
तो आप इतने हेजिटेट क्यों कर रहे हैं कोलकाता ऑफिस में फिट जाने के लिए?
हम जाने के लिए
तो लिबर्टी दिया गया है।
लिबर्टी दिया जा रहा है सर। वेस्टेज ऑफ टाइम इन 2014 में भी ये जो ऑर्डर कॉपी में सबमिट हुआ है, हमने जो एविडेंस दिया, हमारा टाइम ये हुआ है सर इतना ज्यादा। हम तो जनरल कैटेगरी में सारे एजुकेशन
थोड़ा दिन के लिए मैं ये सस्पेंड कर सकता हूँ ये कैंसिलेशन। सपोज थोड़ा दिन के मैं सस्पेंड कर दूं, ये सस्पेंड करके मैं कोलकाता ऑफिस को बोलूंगा कि इंक्वायरी करे।
सर वो फाइन है सर, वो आप कर सकते
वो
हैं,
आपके लिए फाइन है।
वो आप कर सकते हैं। हाँ, अब वो उस हमारे लिए भी फाइन, हम सारे डॉक्यूमेंट्स जो है फिर से प्रोड्यूस कर देंगे।
हाँ।
पर मैं आपको ये एश्योर दे रही हूँ,
शेड्यूल कास्ट का क्या डॉक्यूमेंट है आपके पास?
रेफरेंस
आधार कार्ड शेड्यूल कास्ट का डॉक्यूमेंट नहीं है,
सर,
आधार कार्ड रेसिडेंस का डॉक्यूमेंट है।
आधार कार्ड, पैन कार्ड से हमारा रेसिडेंशियल,
हाँ हाँ, वो सब तो है आपके पास।
शेड्यूल कास्ट से बिलोंग करते हैं, केवट कम्युनिटी शेड्यूल कार्ड से बिलोंग करती है।
इसका क्या डॉक्यूमेंट्स है?
इसका एक ये सर्टिफिकेट है जो डिपार्टमेंट ने किसी को इशू किया है।
कौन डिपार्टमेंट? यूपी का?
नहीं, यूपी का नहीं, वेस्ट बंगाल का।
अच्छा,
बैकवर्ड क्लास वेलफेयर डिपार्टमेंट की केवट,
अदर डॉक्यूमेंट्स आपके पास है?
केवट शेड्यूल कास्ट से बिलोंग करती है सर, और ये केवट कम्युनिटी यहाँ पे लिस्ट में है सर। मेमोरेंडम सर, हाँ, वेस्ट बंगाल मेमोरेंडम, कॉन्स्टिट्यूशन ऑफ इंडिया के पेज नंबर 162 32 पॉइंट्स।
Mr. Banerjee, let them participate in this whatever course she's trying to. Within which,
Department.
so that liberty has been given. I'll not interfere here. Apart from, yes, I'll interfere in the sense that merely on the ground of jurisdiction, she cannot lose her opportunity. Subject to the outcome. Subject to the outcome of the inquiry by the district welfare officer, Kolkata. Whatever happens.
Say this, Lord.
Yes.
Today, a certificate.
Just got certain documents, Mr. Banerjee.
What is the documents?
The documents, several documents are there.
Lord, your Lordship will adjudicate today whether she scheduled caste, scheduled tribe.
Can I?
On the basis of these documents.
I cannot.
I do not know. So that is why I'm saying, Lord,
I cannot. Therefore, your district officer will.
May I say this, Lord, one thing? Today, Calcutta rejected it.
Hmm.
It was open for them to go up on appeal.
They did not.
They did not. Lord, what I don't understand, Lord.
But they're not shying away from the inquiry by the fresh inquiry by the district welfare officer of Kolkata.
Absolutely. Lord. I'm not also shying away from this entire thing.
Let
But
it happen.
your Lord should not stay this. Which they have.
You won't be able to participate in this academic year.
Because then, Lord, that if she can't.
No.
Lord, that she can't. In any case, she's jumping high on over the entire general category of students. Lord, you will not give Lord, somebody who's not deserving of that protection to ride over the general students. Lord, your Lord should kindly not go into that issue. Lord, I have very strong views on that. There are many a brilliant boy who does not get a chance. Many a boy who commits suicide because of this reason, who is in the general category. And somebody not entitled to. If that person will not get a preference, Lord, then let it not happen. Lord, they could have come much earlier. But today, Lord, today this would mean, if your Lordship gives this period, Lord, you are depriving of many people from the general category. And this is not. And it is proved subsequently. Lord, what happens then? Things can't be
Can I say, sir, something, sir?
Yes.
Sir, I'm still fighting for this course around 8 years. सर हर साल मुझे एक जनरल टेस्ट में भी रैंक आता है सर। I'm not सर के अनुसार कि मैं मतलब काबिल नहीं हूँ, ये हो नहीं सकता है सर, क्योंकि सर ऑल इंडिया और अमंग 33,000 my rank is 517 और as per all India SC rank 23 and as per SC ranking state rank 1. Okay, but if I am go through the general rank, then I have to go for the Telangana. So why I am going to Telangana at this age? Or even everybody knows that I'm a physical handicap. I'm totally dependent on medication, sir. I'm a rheumatoid arthritis with advanced level of osteoarthritis. Both me are deformed and all the joints are affected. I'm totally dependent on my family when I'm sick. During this course, and I'm for 6 months bedridden. During the patient, each year I'm getting affected with this disease.
Well, I'll pass my orders tomorrow morning. The first thing in the morning, 10:30.
I'm totally dependent on biologists, sir.
Pass my order. I'll think it over. Yes, Mr. Banerjee.
Sir, I'm so generally 517. I'm not a qualified woman.
Let me go through the documents. If anything can be done, will be done. But otherwise, no. Let us see. I'll pass my order. I'm still undecided. Not because
सिर्फ तेलंगाना नहीं जाना पड़े इसलिए सर मैं लड़ रही हूँ।
sentiments are definitely there, but we also have to go by law. So I'll have to consider the documents which have been produced by.
The department is not denying that we are not belong to the scheduled caste in their rejection order as well as their reply.
The second application was not maintainable.
Well,
because
fraud
district
vitiates
welfare-
everything.
No, district welfare officer Kolkata initially rejected on merits. A second application on that same with the same pair is not maintainable in law. But you have been given that opportunity.
Sir, as per, we have
That is the difficulty against you. This could not be reopened. You did not challenge. आप challenge नहीं prefer किए वो पहले order के against.
Sir, क्योंकि sir मैं आपको बता
Anyway,
रही हूँ
I'll pass my orders to
all-
correct order.
Lord, would your lordship Lord, allow me to give your lordship the cases on fraud? Because fraud.
Your allegation is fraud. Fraud has not been pleaded in particulars.
Fraud vitiates everything.
Where are the particulars of pleading?
It's not the.
In an opposition,
No, I am. Your lordship.
I go by order 604.
Very well.
Heard learned counsel for the parties. The matters be listed tomorrow at 10:30 for, sorry, not 10:30, 2 p.m. Tomorrow at 2 p.m. Tomorrow at 2 p.m. for passing orders. Mr. Banerjee, I'll think it over and then do something.
As you lordship.
Even if I don't interfere, then even then they have a right to go before the district welfare.
Whatever it is, I am not.
Petition in person.
I have
Sonia ki
too many years to bother about what ultimate.
Sir,
result.
simply requested
Please
to you,
go
sir,
ahead.
if I am fraud, if I am doing, given wrong documents, sir, why I am standing here, sir? Simply look out my condition.
Good.
I'm fighting for this for 8 years. Give you, sir, my physical disability certificate also give you, sir.
Ma'am, I'll definitely consider that. But law has to prevail whichever way. Thank you. Call on the next one.
Thank you, my lord.
Yes, call on the next one.
Item 2, top item.
Yes.
And for the Milord, respondent number 6 to 8, Milord, on the last occasion, Milord, your lordship
Yes,
called
yes.
for a report from the registrar as to whether the title documents were essential. Milord, till now, Milord, no copy has been filed to that effect by the learned counsel for the state, Milord. I don't know whether, but in the meantime, Milord,
That this is the deliberate absence of the
Milord,
state authority.
Milord, a development has cropped up, Milord. I was not equipped, Milord, on the last occasion, Milord. The order is appealable. It is the maintainability of the writ petition can be challenged. If your lordship kindly have a look at section 7 of the.
Give me half a minute, Mr. Bandavad.
Lordship inquired about, Milord, the alternative remedy, Milord, but I was not equipped on that day. I've gone into that aspect.
No, this is regarding the requirement to have a no objection certificate. So for that, the state was to give a report.
Yes, but,
Otherwise,
I
your
find
lordship
that
has
the
decided that
state-
case.
State is not present here or not the.
What is your maintenance? You did not take the maintenance report at the first, at the inception.
Milord, I was
Can you
not-
take that later on?
Yes, Milord, point of law, Milord. Pure-
What is the point of law? Let
Pure
us-
and simple question of law, Milord.
Alternative remedy,
Section 7.
not absolute bar.
No, Milord, absolute, Milord, no.
Absolute bar, alternative remedy.
This
In
case,
226.
In this case,
This is an
Milord,
entirely new proposition.
no allegation of violation of natural justice. has
Acha,
been
very well. Which
actually-
section? Which section?
Milord, Section 7 of the Societies Registration Act,
Yes.
read with Rule 11 of the Societies Registration Rules, Milord.
Right.
Both the pages have been flapped by.
Yes, yes, you have.
Milord, kindly come to Section 7.
Hmm.
1. The registrar, upon being satisfied that the memorandum and the regulations accompanied it comply with the requirements of this act and the rules, and upon payment of the fees department subsequent to, shall certify under his hand and seal that the society is registered under this act. 2 says, Milord, there shall be paid to the registrar fees such and such. And 3 says, Milord, most pertinent part, an appeal shall lie to the state government against an order of the registrar refusing to certify the registration of an association as a society under this act, and the decision on such appeal shall be final. Milord, on the analogy, Milord, on the basis of principle laid down there, Milord, I can very well, Milord, very respectfully.
Appeal is a creature of statute. How can it be on a principle? This is if the registration of the society is refused.
On the.
He is an individual not asking for registration of a society.
No, he is seeking for cancellation. And registrar has refused to cancel the registration. Now that can be appealed against, Milord. And my lord, rule, kindly see the rule. My lord. Rule 11. How memorandum of appeal shall be filed in duplicate.
No, no, rule is different. Rule is just memorandum what
Procedural part.
procedural part we are not interested. But Mr. Bandyopadhyay, satisfy me on rule section 7 being applicable to this case.
He is Mr. Totto.
I'm sorry, Mr. Vans. Yes, satisfy me on this.
My lord, analogy, kindly see, my lord, the analogy, my lord, if
How can there be appeal on analogy?
my lord, the principle, if registrar can refuse to certify.
Appeal has to be a specific provision. There has to be a specific provision for appeal. Appeal has been provided where against an order of the registrar refusing to certify registration of an association as a society under this act.
My lord, in the same breath, my
There
lord,
is no refusal here. They have been registered. Now he's saying that that should be cancelled.
Yes, they can cancel
That
it.
was invalid.
Registrar has refused to cancel the society. Now, my lord, that can be appealed against by the petitioner.
Let us revert to the original grounds. I mean, let us see the challenge.
But Mr.
Lord,
Mahato has
another-
come for the state.
My lord, another state.
Yes, Mr. Mahato, you have to file some report today.
My lord, I have to submit, my lord.
My lord,
Then submit.
another
You have to submit a report, then submit.
another judgment, my lord, which
No, my
says,
lord,
my lord,
I will
within
submit the
section-
report, my lord, my lord.
kindly see, section 21, registered being a quasi judicial authority cannot invoke the section.
There is no appeal provided against refusal to cancel a registration.
Lordship kindly sees this judgment, reported judgment 2012.
For what purpose? For on what proposition?
My lord, this section 21, my lord, cannot be invoked by the registrar. Being a quasi judicial authority, it cannot be invoked. Whatever he has to, the petitioner has to do, he has to do in course of a suit, my lord, civil suit or proceeding. That is the tenor of this judgment. It is.
Yes, what about the report, Mr. Mahato?
My
Paragraph
lord, I have
23, if
not
your
got the
lordship
report till now, my lord. My lord, I need, my lord.
Tomorrow file it then.
My
I've given you sufficient time already.
On 6th, your lordship heard.
6 June, I have given you time.
And
Why is the state so reluctant, Mr. Mahato? 6 June, I have granted you time. Today, I've given you 1 week, in fact.
Your lordship initially granted 2 days time, but on their
Yes.
request.
No,
it was
Mr. Mahato,
extended.
it cannot go on like this.
Another 2 days, my lord. On Friday, my lord, I will submit the report.
Friday will not be there.
I will be.
My lord, paragraph 23, my lord,
Let us
My
wait
lord,
for
actually, my lord,
Friday.
on the
The
basis
junior-
of
The state was to file a report by the previous direction of this court. Full stop. However, learned counsel appealing for the state seeks a further adjournment for filing such report. Full stop. As a last chance to the state to file the report, the matter is adjourned till June 16, 2023. Full stop. It is, however, made clear that in the event the state does not file the report on the next returnable date, costs might be imposed against the state on such score. Full stop. Learned counsel for the respondent numbers 6 to 8 submits that the writ petition is not maintainable in view of availability of alternative remedy of an appeal under section 7 of the West Bengal Societies Registration Act 1961, coupled with rule 11 of the West Bengal Societies Registration Rules 1963. Full stop. Next para, learned counsel also places reliance on the judgment of Brij Mohan Gupta versus the Registrar of Societies
2012
rendered by a learned single judge of the Delhi High Court, reported at 2012 SCC Online Delhi 2535 on such score. Full stop. Next para. However, in view of the adjournment sought by the state, the matter shall be listed for being taken up report in question. Please consider these judgments and come back also.
Maybe on at the top, my lord.
This was today at the top. তাহলে ওটা করে দিন on June 16, 2023 at 2 p.m.
ঠিক আছে।
Thank you. I'll decide on this, Mr. Dotto, also on the next day. Very well. পরের দিন যখন শুনবো একসঙ্গে পরের ম্যাটারটা।
Item 3.
On item number 3, I beg to appear on behalf of CSC.
What is the matter?
No, there was a direction passed by your lordship directing the petitioner to file a supplementary affidavit in respect to prove their possession of the property manor.
Have you
No,
filed that?
Respondent number 3, I am.
Oh,
Petitioner number 1, from the day 1 is doing the same thing. Your lordship kindly appreciate. I kindly peruse your lordship's order dated 1st of May 2023. They are referred to certain documents, but subsequent to the same in your lordship's order, my lord has prima facie found that the said documents did not find any proof that the petitioner is in settled occupation of the property and
I'll dismiss it for default. I'll dismiss it for default. I cannot dismiss on merits in their absence. On May 8, 2023, the matter was adjourned on the prayer of the petitioner. First up, it is seen that with a order dated May 1, 2023, it was observed, inter alia,
the second page, one a middle portion. One.
that prima facie the court did not find any proof that the petitioner is in settled occupation of the property concerned. Full stop. Upon such observation being made, learned counsel for the petitioner has sought liberty to file a supplementary affidavit annexing further documents to indicate prima facie that the petitioner is in occupation of the property in question. Full stop. Next para. Even from the previous records, it is seen that the petitioner has consistently been absent when the matter was called on for hearing. Full stop. In view of such repeated defaults on the part of the petitioner, WPA 973 of 2023 is dismissed for default without any orders to cost. Full stop. Interim order, if any, stands vacated.
Grateful.
Thank you.
Grateful, Your
Got it.
Item 4 and 5.
In this matter, last occasion and probably on Thursday,
Yes.
my learned friend handed over a copy of the reply sent against the representation made by the petitioner and others. Lord, I have, subject to your lordship's kind approval, I have found a supplementary affidavit controverting the allegations made in therein in furtherance of the writ petition that there is a discrimination even after filing the
This is virtually rejoined to the reply.
No, not rejoined to the reply. I'm writ petitioner. They have just handed over a copy of the reply, reply to the representation, which was not supplied to us earlier. Now we have we have found the supplementary bit annexing that reply supplied by them in the course of before your lordship. And I have also annexed one document showing that the contents made in the reply are wrong.
You have given a copy to them?
No, just now I'm just giving. Today, yesterday.
Take it, I'll permit them and come back with whatever is your response to this. I'll go on playing like this till eternity.
Kindly give me the
On the prayer of the petitioner, liberty is granted to the petitioners to file a supplementary affidavit, which, filed today, be kept on record. Full stop. A copy thereof be handed over to the learned advocate for the respondent authorities. Full stop. The respondent, since a copy has only been handed over here and now, the matter is urgent till day after tomorrow or when? The matter is urgent till June 15, 2023, when it will be listed under the same heading.
Well, just not on 15th, either 14th or 16th. Any subject.
17th very difficult. I'll keep it on 16th. 16th. Come back on 16th. Tell 15th na kore 16th.
Item 6.
Yes.
Item 6.
The affidavit that was
I've used
affirmed
one.
is in connection with item number 5.
Yes, yes, one affidavit I've just. Because they have not done it. In Pratibha Das,
দুটো একসঙ্গেই নাম্বার appear করছে কি?
yes, 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 same contention,
No,
same.
there,
I'm giving a copy, you're standing.
You are not in that.
no, there are two different matters. One is
Same
item
matter,
number 4
same-
and item number 5.
জানেন, আমাকে
You are not appearing in 5.
No,
But
I am
the
appearing
corrected
in
matter,
item
same
number 4.
matter, same stand will be there.
Please hand over your copy to him.
He has already
I've
given.
given, 2 copies I've given.
I have received the supplementary. As a matter of fact,
Aran,
the representation which was considered and disposed of by oil company.
Are you ready on the supplementary affidavit?
I have to go through the same thing.
So the order remains. Come back on 16th. দেখেছো তো? Yes, who is appearing in the next matter? Mr. Chatterjee, you are appearing?
Yes,
Yes.
there are two matters, my lord. One is appearing in the list, the other one is not appearing in the list, my lord. That is
Not
more-
appearing in the list.
No, my lord, that's more important actually. This is with respect to, my lord, declaring me as a willful defaulter. Without hearing me, they have acknowledged that they have not heard me, my lord. But they dropped the earlier proceeding, they again started a new proceeding, did the same thing, and again, my lord, declared me a willful defaulter by one line order. The second matter is challenging, my lord, that subsequent order.
So
That
this has
means-
become infructuous basically.
Not infructuous, my lord, because this will be a part of a continuation.
The
my lord.
number it will appear on the list.
Lord, it's very urgent.
Whenever the file comes, the
But
file is in
if
the
it can be,
department.
my lord, tomorrow itself, my lord, I'll
Tomorrow
be-
very difficult, Mr. Chatterjee.
then
The file may not come within this time.
নম্বর ফাইলটা কোথায় এখানে থাকার কথা ফাইল করেছিস কোথায় WPA
That's a new motion
yes
for
new
this
motion.
court.
Yes, my lord.
When was it filed?
This was on June 23. Lord, it's 6288/2023.
Cannot be for this court.
No, my lord, it was filed before justice.
Sarfin is there. You can rest assured that it was not for this court when he says it's for this.
No, my lord, it was filed in March, looks like, my God. I have served with a copy on March.
I understand.
First, locate Mr. Arifin whether it is in the list, combined list or somewhere else.
No, it's not there, my lord, it's not there.
So give the number, it will appear whenever it comes, whenever the file
But
comes.
there's huh?
Maybe next Monday or Monday after that.
Tally fixes it, otherwise it'll be very
No,
difficult.
too many
Before
fixations.
Publication, willful defaulter, I'll be nowhere.
They were waiting for from March, month,
I
from the
was
month
not
of
waiting
March.
anywhere. I can assure my learned friend, I was not waiting.
On
The
15th
business of the court
March,
did not allow. the
When
matter to
counsel
be
for
taken
the petitioner submits that a connected writ petition is required to be heard along with the present, full stop. The learned advocate in record for the petitioner is requested to hand over the number of the same.
That's 6288/2023. And we've handed over the slip as well.
Full stop. Upon such number being handed over, comma, the same is directed to be listed along with the present writ petition as soon as the file of the said matter comes to this court. File টা এসে গেলে দিয়ে দিও, কাল এলে কাল দিও, পরশু দিও।
Very.
Whenever it comes, Mr. Chatterjee.
আবার টপ কিনবো জজ সাহেবের মাথার উপরে।
Top Justice Mitra.
কি
Great. Is this play acting or you are seriously annoyed with him?
Well, I'm
It is
never
play
annoyed.
acting, 100%. Next
I'm
matter.
never annoyed.
Then it's play acting, obviously. Yes. Dako, Pert.
Item 7.
Yes, what is the matter?
Lordship, may I please your lordship?
Please.
Lordship, on last Tuesday, that is 6th of June 2023, your lordship has been pleased to take up the matter. But the affidavit service with regard to service upon the private respondent was not complete. Lordship, I have served again.
Good service now?
Yes, yes.
Very good. Yes, what is the matter? You had given a copy of the supplementary affidavit to the state.
Yes, yes.
Very good.
On the last occasion.
Right. What is the matter?
Lordship, section 14, petitioner is agreed because of pendency of section 14 application for more than.
Oh, you're the bank.
Yes, yes. Lordship, I would beseech your lordship to kindly straightaway come to page number 28.
You are Mr. Rai.
Lordship.
Mr. Rai, have you ever anywhere in your writ petition or supplementary affidavit that nothing, no stay order or something is
Yes,
operating?
yes, that has been,
That is done in the.
that is the supplementary affidavit filed on the last occasion.
Just show me the relevant paragraph.
Yes, yes.
Yes, yes. Paragraph 7
Yes.
of that affidavit. Very well.
Yes, yes.
Yes, let us see page 28 of your.
Lordship, kindly come to page number 28 of the main writ petition of your Lordship's brief.
Yes.
Kindly come to left-hand side at the top. It was received by the office of the district magistrate on 4th of March 2022.
You want an early disposal of that?
No, no, I want because the district magistrate is supposed to dispose of my application within a period of 30 days. At the most, it can be extended for another 30 days, but for such extension, reasons are required to be.
Here, how many days have elapsed?
Lordship, they were supposed to dispose it of by May 2022. We are
60 days have elapsed.
More than a year. Because 60 days has elapsed.
That is what I'm saying.
60 days
you want an adjudication. You want a direction.
Disposal of the section 14 application within a specific time frame.
Despite service, none appears for the respondents. The further affidavit of service filed today in court be kept on record. The grievance of the petitioner bank is that the district magistrate concerned, despite the statutory period having elapsed long back and in view of about a year having passed since the application under section 14 of the SARFAESI Act was filed by the bank, the same has been kept pending by the district magistrate. Next para. In view of the nature of the prayer made, no further service of notice on the respondents is deemed necessary. Further from the annexures to the supplementary affidavit filed by the petitioner bank, it is seen that the bank has already affirmed an affidavit indicating that there is no stay order subsisting against the bank in the proceedings pending before the Debts Recovery Tribunal number Roman 3 at Kolkata. In such view of the matter, WPA 1732 of 2023 is disposed of by directing.
Respondent number 2, Lordship.
Thank you. The respondent number 2, that is the district magistrate, North 24 Parganas, to dispose of the proceeding pending under section 14 of the SARFAESI Act 2002 at the behest of the petitioner bank before the said respondent against the private respondent as expeditiously as possible, positively within 4 weeks from the date of communication of this order to the district magistrate. All concerned shall act on the server copy of this order without insisting upon prior production of a certified copy for the purpose of compliance.
I'm grateful, Lordship.
Item 8.
Lordship, I have for the petition.
But I objected for the respondent number 2 and 3.
Right.
Milord, I am appearing on the behalf of the state. Milord, actually, what is happening, this matter, state respondents not serve, and I actually not received the information regarding the written instruction. And that's why I pray 2 days time.
I'll give them 2 days. Because state is necessary. State, what role has the state?
They are the answering respondent to whom they.
This is the Right to Information Act.
Yes.
Second round litigation.
That's why I
A
actually.
prayer is made for on behalf of the state to obtain appropriate instructions to enable the state to duly contest the matter. Accordingly, such prayer is granted and the matter is adjourned till June 15, 2023, when it will be listed under the same heading.
Affidavit service be kept.
Affidavit of service filed today be kept on record. Please come back. You are for 2 and 3 means those authorities.
I'm the second appellate authority, Lordship. Grateful, Lordship.
Item 9.
But I appear for WBCDCL. This is a matter relating to shifting of pole. Second inspection was ordered. That has been complied with. Notice has been served. Copy has been given.
The petitioner remains repeatedly unrepresented. Full stop. Even today, when the matter is called, comma, none appears for the petitioner, although the WBSCDCL is represented through counsel. Full stop. Hence, WPA 3135 of 2023 is dismissed for default without any orders to cost. Interim order, if any, stands vacated.
Grateful, Lordship.
Item 10.
Item number 10, I appear on behalf of
I appear for the
WPA.
petitioner, my lord. I'm led by Mr. Malay Ghosh, my lord, but I'm ready if Lordship so desires, I can start.
Yes.
My lord, the petitioner is a steel re-rolling mill. The grievance is against the policy of the WBSCDCL of charging or rather undercharging within the DVC control area. But my learned friend is saying this won't get over in 15 minutes, but I've in your
Let's come back to order. He's right because several motions are pending.
Mr. Kaur is leading me in this, but this will take time.
Come back next month after next.
Lordship, kindly, my lord, this has been pending for some time.
And fix a time.
Due to paucity of time, at order recorded, due to paucity of time, the matter cannot be concluded today. Accordingly, let the matter stand over till tomorrow. Come back tomorrow, let us see.
Kind enough to fix a time for this.
No, definitely not. If I fix a time, it will be 4:15 on any date, and I'll continue hearing this 4:15 every day. See the expression of Mr. Chakraborty behind you, that is sufficient. He's trying to intimidate me from the morning, but I'll not accede to his prayer. He doesn't know that.
That's what you were telling me. That's what you were telling me when I was having a talk
He's
with
literally running from pillar to pillar. Yes, next matter.
Grateful.
11.
I am agreeable at 4:30, but I do not have any problem.
11. 11. You are for the petitioner?
No, my lord, I am appearing for the state respondents.
State.
But I appear on behalf of the WBSCDCL. There is one mistake on my part. There was a direction passed by your lordship to file a report. When a report is there, this is a scanned copy. May I submit? When the only thing, my lord, I could not circulate because
Submit a proper report, Mr. Mukherjee, not this. This will be a part of the court's record.
then, my lord, will your lordship be kind enough to take it off? Give me 2 days time because it is in Ganganagar.
I'll take it up next week. An adjournment is sought by the state, by the WBSCDCL, I'm sorry, to file a report, file the report. In any event, none appears for the petitioner at the time of call. Let the matter stand adjourned till June 19th.
I'm grateful, man. Well, I am for the petitioner, my lord.
Item 12.
As per your lordship,
You're for the
Respondent number 9.
This is my evidence.
I know who you are appearing for. Yes. What is the matter?
Matter is for my lord. Petitioner want to electric connection for his residence, my lord.
Private respondent
yes,
opposing?
Yes, my lord.
You agree to that? Why are you opposing?
There is a service and there is a padlock. But it is necessary to.
Well, what happened, my lord? The residence of the private respondent and the residence of the petitioner are adjacent to each other. Now, my lord, a meter room was shown at the time of inspection to the CSC Limited. The meter room belongs to the private respondent in the residence of the private respondent. Now, my lord, the private respondent has no objection if the meter is given to the petitioner from the service line directly, but not through the meter room of the private respondent.
My instruction is it is in the common space.
No.
But it is in the common space.
They are having
and that
their
is a
own
meter and they are putting the padlock.
No.
Padlock is necessary to be broken and their meter can be installed.
The civil suit is pending.
No civil suit is pending, my lord. If your lordship kindly comes to, my lord, there is a finding of the CSC which has been annexed in the petition. The CSC is saying that there is a meter room, therefore there is no separate meter is not required.
Yes.
There is a meter. That is a fact, my lord. That meter belongs to me. But that meter is in the meter room in my premises. And this petitioner...
Your premises are numbered separately?
Yes. And he is...
Where is that finding? Which page?
My lord, kindly comes to page...
page 26.
Now, my lord, he is having a right of way. He is
going to his premises from that right of way, from that path. No matter if the meter is taken from the service line.
No,
through
they
that-
say it's the same premises.
Yes. No. But that is the premises number is also different. Because they have constructed a house.
Structurally, it may be the same.
But there is a common service. From that common service, the meter can be, this is a loop
Cannot
meter,
object.
your lordship. My loop meter can be installed. My learned friend cannot object.
It will be a loop meter. What is the difficulty?
But if
You know what a loop meter is?
it is if it is
Should
in-
know. Why not? You're doing an electricity matter. It's a
But
different question that the court also doesn't know exactly what a loop meter is. But since the CSC submits it's a loop meter, it has to be a loop meter.
My instruction is that it is within my premises. Normally, if it is within my
No,
premises,
loop meter is something else. I mean, your meter room, you won't be hampered. Your position won't be hampered.
No, not
Explain to him what is a loop meter.
I will explain to him also.
No, outside, inside court.
এক্সিস্টিং সার্ভিস বোর্ড আছে যেখানে অনেকগুলো মিটার থাকে ওনার মিটারটা ওইখানে ইনস্টল করে দেওয়া হবে।
my instruction is that they are having their own meter board, meter room inside their premises.
Obviously, they don't.
No, my lord, they have not obtained the meter as yet, my lord, because they are having the meter room. They are having the meter room, but they don't have the meter.
But this is the second round of litigation. Now I have to open my mouth. It's the second round of litigation. In the first round of litigation, there was a specific direction by this Honorable High Court for making inspections. And on the basis of that inspection, we found that there is an existing service board or where we can install the loop meter. That order was challenged by my learned friend before the appellate court. Thereafter, the appeal stand dismissed. So the order remains still there that there is an existing service from where we can install the loop meter.
But the only thing
So
is
my
that-
learned friend cannot come in the way, stand in the way now and can say that it is my premises, so loop meter cannot be
My
installed.
management has said everything. The only thing which they have not done at the time of inspection is that whether the who is the consumer in respect of that meter. That they have not done because they are because the petitioner is
They'll not give it from, you will give it from their meter.
No,
From
from
the
the
meter room.
existing service.
my lord, which is inside my premises.
Learned counsel for the petitioner contends that due to resistance by the private respondent, the CSC Limited is not being able to give a new electricity connection to the petitioner. First up, learned counsel for the CSC Limited submits that there is an existing service connection which is situated in a common position between the houses of the petitioner and the private respondent, comma, from which the private respondent is already enjoying a connection. First up, after a previous round of litigation, comma, it was ascertained that the meter, only a loop meter can be given to the present petitioner from the said existing service connection. First up, next para, learned counsel for the private respondent opposes the contention of the CSC Limited and submits as that, comma, as per his instruction, comma, the meter room is situated within the premises of the petitioner, of the private respondent, and, comma, as such, comma, if a connection is given to the petitioner from the said room, comma, the such connection shall hamper the possession of the petitioner.
The privacy of the petitioner.
Hamper the possession as well as privacy of the petitioner. Full stop, next para. Upon considering the submission of parties, comma, it is clear that there is an existing service connection from which a loop meter can be given to the petitioner as per the licensee itself.
My order is page 27, previous order.
Full stop, next para. That apart, comma, from a previous order dated March 3, 2021, passed in WPA 1769 of 2021, it is seen that a coordinate bench of this court had observed that the
Last paragraph.
who was the respondent number 4 there?
They were the respondent, they are the private respondent.
Kindly see the second paragraph and the third paragraph.
That the respondent number 4 therein, that is the private respondent herein, comma, to provide a separate electric meter at the existing service at the subject premises. First up, next para, that apart, comma, since the CSC is of the opinion that a loop meter can be installed only from such existing service connection, comma, the right of the petitioner under section 43 of the Electricity Act 2003 to get such an independent connection in his name cannot be prevented by the private respondent. Accordingly, WPA 10531 of 2023 is allowed, thereby directing the CSC Limited to give a loop metered connection to the petitioner from the existing service position as expeditiously as possible, positively within a fortnight from date. First up, if any obstruction is offered by the private respondent and or his men and agents, the CSC Limited will be at liberty to approach respondent number 8, the officer in charge of the Mahestala police station for adequate police assistance. First up, if so approached, respondent number 8 shall act on a server copy and give server copy of this order and give such assistance to the CSC Limited at the cost of the petitioner. First up, if any padlock or other hindrance is put up to resist the CSC personnel, the police personnel will be at liberty to break open such padlock for the limited purpose of enabling CSC Limited personnel to have access to the existing meter board position.
Ma'am, one thing, Lordship, subject to compliance of all other formalities. Said Lordship.
Yes,
ma'am. Within.
Direction WPA such and such is disposed of by directing CSC Limited to give electricity connection to the petitioner, loop metered connection to the petitioner from the existing meter board position, subject to compliance of all formalities by the petition.
Deeply obliged, Lordship.
Grateful.
Next one.
Grateful, my lord.
Please, thank you.
Item 13.
One time for the petitioner, my lord. This is my affidavit of service, my lord. Earlier it was not a delivered, but now delivered, my lord. For a petitioner, one
Wants what?
One for electric connection for his domestic purpose, my lord. Resistance by the private respondent.
Private
my lord.
respondent has been served properly.
Yes, my lord, delivered, my lord.
Despite yes. No inspection.
We are getting objections from there. Your Lordship, it's a new service. It's relating to Mouse Committee, Lordship.
Heard learned counsel for the parties. Despite service, none appears for the private respondent. Affidavit of service filed today be kept on record. The gamut of the issue is that the petitioner has applied for a new service connection, but due to obstruction, the CSC personnel cannot get access to the
We are to lay down the cable, Lordship. It's relating to service. New service, Lordship.
The CSC Limited could not cannot get access to the locale for the purpose of laying cables to give new service connection to the petitioner. Puts up next para. In view of the petitioner having a right to get an electricity connection in the petitioner's name, subject to compliance of formalities, such right cannot be prevented by obstruction from third persons. Accordingly, WPA 11286 of 2023 is allowed, thereby directing the CSC Limited to lay the required cables and give the new connection to the petitioner as expeditiously as possible, positively within 4 weeks from the date of compliance of all formalities by the petitioner, and or from this date, whichever is later, subject to such compliance of formalities by the petitioner. First up, it is made clear that if any obstruction is raised by private respondents and or their men and agents, in doing so, the CSC personnel will be at liberty to approach the respondent number 8, that is the officer in charge of the Bajbaj police station, who will give adequate police assistance on being so approached at the cost of the petitioner by acting upon a server copy of this order. First up, this much, not rest to cost.
Grateful, my lord. Grateful.
Deeply obliged.
Next one.
Lord.
Item 14.
14, my lord.
Very well. Yes. Whatever you are submitting something. 14 who is appearing?
No, Mr. Devjit Mukherjee is appearing for the CAC.
I'll take it up tomorrow. Yes. Why mention?
One matter was left day before yesterday. I mentioned previously.
Left without address.
Lordship.
Matter was left without address.
Left without no.
Matter was passed over.
Not passed over. One matter is left just 16 item Lordships taken out.
Left to be taken.
And I mentioned previously matter but the matter is খুব urgent, my lord. That's why.
What is the item number?
34, my lord. The tender matter, my lord. I mentioned previously.
What can I do? Sir, the difficulties, there are several other matters. I've been refusing consistently. All upgradations, all.
No, go down. One matter is left only. 17, 16 matters.
I'll introduce something here in my court. Each of the parties will be given 5 minutes each for the motion matters.
My lord.
You will have to complete within that. Whatever is completed, even if I don't understand, I'll pass out.
My lord.
But otherwise, I cannot take up so many matters.
My lord.
Only you and Mr. Chakraborty are agreeing.
34 item number, my lord.
34, no upgradation. My lord,
Not today, my lord. If tomorrow at any time, my lord.
My lord,
My lord, lordship,
I've been consistently refusing. At the end of the day, I cannot make a deviation. Others will suffer. In the morning, some people mention.
only one matter. That's
Mr.
why, my
Hadi.
lord.
Yes, my lord, due to very urgency, my lord, I'm mentioning item number 50, my lord, due to Bakrid, my lord, this is Zoha, my lord. This matter is to be.
Pick up serially whatever happens.
My lord, 20th June to 30th. Thereafter, my lord, I could not. I could not get any permission from the defense. We got permission from Calcutta, my lord. So for that reason, my lord.
Your volume won't make a difference, Mr. Hadi. Yes. Any new prayer?
Tomorrow is the only day, my lord. 15, my lord, possibly is not sitting, my lord, is possibly having the division bench. My lord, 15 the last date for disconnection. Tomorrow I am only having that. Only thing, my lord, may I pray, my lord, only, my lord, kindly. Now, this item was appearing as 34 on Friday. But what is happening? The returnable.
You have been hearing to the mentionings just before you.
My lord, I'm not saying anything.
Persons more senior to you have mentioned in the morning. Even senior persons have mentioned.
Was there? I was also. My lord, I'm not saying anything. What I was only.
Cannot. I won't make
not
it.
asking for anything.
It's my limitation, Mr. Chakraborty. I cannot take up more than these matters. But the difficulty is if I can't take up.
Kindly, my lord, I'm not asking for. I was only requesting, my lord, if the new motions which has not been touched, first time appearing, if it given some precedent, what is.
I don't know which have not been touched or not. Now it's out of control.
Returnable.
Because I have inherited so many matters from the.
Returnable motions are getting precedent. That is the difficult. It's going down, my lord. 34 item on Friday has now.
New filings are going down.
Yes, my lord.
That's why, my lord, my item was 17. 16 matter lordships taken.
আচ্ছা ঠিক আছে I'm just speaking right now before you. অরিত্র কি ব্যাপার? নতুন মাসে তো সবসময় আমার ঘরে উপরে আসে।
Only that much, my lord.
Would have been
This was beyond my knowledge. Thank you for pointing.
My item was
So new matters, my standing instruction is new matters have to come first.
That is what I have.
That was what was happening in the electricity determination also.
Electricity matters, my lord. That was.
Yes.
My lord, I should have told my lord yesterday only. Then, my lord, possibly my matter would have been heard.
So new matters have to come first.
That is what I also know, my lord. That is why it's going down.
কাল থেকে যেন এক্সেপশন না হয়।
I'm grateful.
Grateful.